Yeah. Yeah, when you get a chance, can you add the events?
Yes. Thinks that's going to be a better setup for everyone. I'm not sure. Is it connected? Does it looks like it has a power cable, but does it have that blue cable? When Sergeant Brown was here, he kind of just like, I'm gonna unplug everything. Because it should have a blue Ethernet cable. We're gonna have to give you the IT stipend.
Sure, you can let them know.
All right, let me try now. Let's see. Yeah, it's connecting now. All right, Ms. Rivers, are you ready to go on the record? Let's do that. We are on the record in State versus Parks and Phillips. It is Monday, September 23rd. We have our prosecutors here. Good morning, prosecutors.
Good morning, Your Honor.
We got Mr. Phillips and his lawyer, Mr. Parks and his lawyer. Good morning, everyone.
Good morning.
How are we doing with jurors?
If
If they're not all here, that's all I need to know. So we can, they know the light trick. Okay. I would like to talk about redactions to Mr. Parks's interview because we're going to get into that this morning, I suspect, with Thorp's testimony. And then we need to talk about Mr. Jarvis and what he can testify to. And then if we have enough time, we can talk about this video recording of Ms. Blakeney. Let's start with the interview. I got a helpful, we all did, email from Mr. Abate. It looks like there were 6 additional redactions that Mr. Manettis requested, 4 of which the state made, 2 of which the state isn't making. And Mr. Abate provided a little context to what was requested and where it really was and what was really said. Mr. Monetis, tell me if you're satisfied with what the state did, or if we need to discuss the two for which the state is saying nothing needs to be redacted.
Yes, thank you, Judge. I do want to discuss those two and ask that they still be redacted.
Let's start with the one that is at the 17-minute mark, where the police ask Mr. Parks, how did you leave the neighborhood? And Mr. Parks said it was a red Mustang, doesn't know whose car it was. Tell me how that is in any way inconsistent with Bruton.
Well, Judge, because it just adds credibility to the video, whether or not that's Mr. Phillips on video.
So tell me how that language in any way, adding credibility to the video is not a violation of Bruton. If Mr. Park said, that's when G and Woe and I got in the Mustang and drove away, that's a Bruton issue. But saying that we left in a car and the jurors have seen repeatedly 3 people getting into a car, there's nothing wrong with that, I don't think. But I need you to articulate more than, hey, it adds credibility to the video. How does it directly implicate your client as being a participant in the crime?
Well, Judge, because our reasoning for allowing the use of the pronoun we is that there's 3 individuals and that it could refer to we, me, and G. But when you say we got in the car and you see 3 people get in the car, then logically we cannot refer to just me and G. That we must refer to all 3 of them.
Well, it refers to 3 people, and the jury has now seen unequivocally 3 people getting into the car. Whether the guy in all white is your client or not is a question for the jury to work through. But there is independent evidence that the we is a threesome. But stepping back from that, I don't hear in listening to it, I don't see in reading it a reference to we that says we the 3. You're coupling what the jury now knows, independent of Mr. Parks' statement, with what's in his statement. And his statement is I'm gonna call it a neutral we. It's not we, the 3 of us, or Woe and G and I, we the 3. It's just we got in the car and left.
Yes, Judge. It's just that, as the court said, they have that video, and so I'm just arguing that it's a logical inference. And according to Bruton, that logical inference would not be made if it weren't for that statement by Parks.
Okay. How about the other one at 28:28, where I don't quite know what Dems means, but whatever Detective Thorp is saying, it sounds like Mr. Parks says, first of all, I didn't say that. It was G who said put on masks, and Parks said, hey, I'm just covering my face.
Yes, Judge. That goes again to the pronoun aspect where it says them. I don't know what that autocorrect is and add the dems, but it's essentially, to summarize it, Detective Thorpe says something like, you even had the audacity, or you even had the something, I remember. But I don't think that's relevant for this argument. To tell the rest of them cover your face. And so in that case, I don't think that them can be neutral, because if there's 3 people and you say rest of them, the them must be the other 2 people, or otherwise you would have said him. So them is plural. It has to logically include 2 other people, not just 1.
Got it. Okay. Well, again, the jurors have seen extensive video footage of there being 2 other people besides Mr. Parks. So, and in this particular space, Mr. Parks says, I didn't even say that. You're saying something that G said. So I hear your concerns on both. I'm overruling your objections. And I believe the video of Mr. Parks's interview is now good to go. Did you have any other concerns, Mr. Greiner, about it?
No, Your Honor. I would just also point out, court's already made its ruling. I would also point out that it's not good English, but sometimes people use the word them to refer to just one person.
Could be.
They, that kind of thing.
Certainly, and in this day and age, they can refer to a single person as we work through gender identity. So it's murky, but more material to Mr. Menendez's concern. There is this independent evidence showing 3 people. So we're not dealing only with Mr. Parks saying things that could, not necessarily would be, but could be construed as there being more than 2. It could be 7 people, but the jury has this non-brutal, properly admitted evidence that shows 3 people. So I think that takes the potential brutal sting out of all of this. In fact, there may be some things you redacted that you could unredact. I don't want you to do that, but the jury can count. And so I think we're in an okay space, and I'm okay with the now being played.
Thank you, Your Honor.
All right. Mr. Rowe, I never skip you, but none of this implicates Mr. Parks other than the larger issue of it coming in, but it's coming in. Any concerns about the video? Okay. Let's pivot to Mr. Jarvis.
One more thing, just to perfect the record, we're not waiving our original motion to sever based on the entirety of the video. We just went along with redactions because that's of course we understand that. So we still would preserve our original motion to sever because of the redactions being insufficient in general.
Noted. All right, let's turn to Mr. Jarvis. Please summarize for me, Mr. Greiner, what Mr. Jarvis is going to testify to. I read Mr. Menendez's email from last night and the emails he repeatedly sent to Mr. Abate. I am concerned that Mr. Menendez never got to see the physical evidence despite having a right to and having asked a bunch of times and filed a motion which didn't get him access either. But a lot of this depends on what Mr. Jarvis is going to testify to. I need you to help me with that. And let me be clear, he's going to testify to lots of things, his qualifications, what he does for a living, et cetera. But as to the shell casings, Mr. Menendez has raised a concern that based on what he was given access to, which was not everything far enough in advance, he didn't have the granularity of this shell casing was found here. And maybe Mr. Jarvis is in a position to say, if we look at I can't remember if there's been an overall, there's a map with evidence markers, states 127. These shell casings over here contained a mix of 3 different guns. These shell casings in the other location contained a mix of 2 different guns. It seems like that extra step is something Mr. Menendez wasn't able to understand, not because he doesn't understand things well, but because he didn't have access to either that last bit of information from Jarvis, whether we call it notes or report, doesn't matter. It's disclosable. But more importantly, it sounds like access to the physical evidence so that Mr. Menendez could see, oh, what Jarvis calls 7Q is number 14 on the map with evidence markers that crime scene technician Parker put together. So I said a lot. I'm trying to distill this still in my head. At one level, Jarvis, I believe, can testify, and that's to say, I analyzed all the shell casings, and at least 3 guns were used to fire the bullets that were there. I don't think the late disclosure of evidence and the non-disclosure until trial time of the physical evidence is affected. That affects what was in Jarvis's original report. But if you were trying to take it to the next level, where Mr. Jarvis is saying, I can tell you in this cluster of shell casings, it was the Beretta and the Taurus. It sounds like that is a natural and otherwise admissible byproduct of the secondary notes that weren't disclosed and looking at the envelopes to see what matches with what. Things that Mr. Menendez wasn't given an opportunity to do until now, which seems late. Now as in the last couple of days, which seems late if it really does force him to pivot from merely present to self-defense. So I said a lot. If you've got questions about that, I'm happy to clarify. But really, it strikes me as a non-issue if Mr. Jarvis is simply going to say, I looked at the shell casings and there were at least 3 guns that fired. Not 1, not 2, but 3 guns.
Yes, Your Honor. I'll try to answer all that as best I can.
Okay, sorry.
And we may need Mr. Abate to come and clarify a couple of things concerning communication between my colleagues and the state. First of all, it's my understanding that at the time of the immunity hearing, whatever date that was, that the box of physical evidence was brought here to the courtroom for previous counsel to have the opportunity to view at that time. Okay. I understand, I believe that Mr. Monetis became involved in the case sometime after that period.
Correct.
So part of the evidence in the case, which was disclosed, is, Judge, if I could just provide a little bit of background, then I'll
Sure.
circle around here to direct questions. Part of the evidence, which I anticipate we'll put up today, involves a crime scene sketch.
Okay.
So
That's through Thorp.
this is through a different detective,
Okay.
Detective Fall.
Okay.
And so this supports all the photographs and the testimony that we've seen before concerning locations of shell casings. So we do have that additional information putting location and shell casings.
And that crime scene sketch is something that the defense has had for plenty of time. It's not a new thing.
Correct. It's not a
Okay.
new thing. It's my understanding this was produced way back at the beginning.
Okay.
It was actually part of, I don't know, more than 100 pages that was produced way back at the very outset. So I think what my colleague is most concerned with is that Mr. Jarvis's report, which was produced a year ago or more. The report, it talks about 3 different collections of cartridge casings.
Mhm.
There is a collection of 12, there is a collection of 16, and there's a collection of 3 for a total of 31. So, and then Mr. Jarvis goes on to do all of his work and conclude that the 12 cartridge casings that are in one pile all match one gun. The 16 cartridge casings in the second pile, now he does have one small error in this one paragraph, but he's talking about the 16 cartridge casings. Those match a second gun. And then the 3 cartridge casings match a third gun. So 3 individual guns. They're all 3 consistent with being fired by a Glock or Smith & Wesson pistols. And there are some metal jacketed bullets that are fired by Glock pistols. Can't tell which gun that would have matched to, but 3 different guns on the scene firing those 3 different quantities.
All right. So that's an expert opinion that has been out there for every lawyer who's been involved with Mr. Phillips's case to know for months and months.
Correct. The date of the report was July 26, 2023. So when I took over the case, I spoke with Mr. Jarvis on the phone. I asked him for everything because my initial reaction was, how do we have 12 casings being collected that all just happen to be fired from the same gun, 16 that just happen to be fired from the same gun, and 3 that just happen to be fired from the same gun? Because I know that they weren't collected that way. And he says, no, he put those in the piles. And so he got this massive evidence and he put them he looked at them and he said, this looks like this goes here, that goes there, that goes over there. And so then he went about doing his work. And he explained to me that, there are these evidence markers. There are notes concerning evidence markers. And so he tried to keep all that straight too. I said, okay, can you send me everything that you have? And so he sent me a worksheet. And I think this is what my colleague is concerned about, is because on this worksheet, Mr. Jarvis, if I can read his handwriting correctly, it seems that he put in pile 1A, which is one gun, he puts the evidence markers that link up to that one gun. Same thing with gun B, same thing with gun C. And then there's an unspent cartridge and it's there in its own category and he's got all these notes. typically, Your Honor, notes are not, necessarily discoverable. But as soon as I got all this, and there are photographs too, he takes photographs of the head stamp on the cartridge and all these different things, immediately sent it to my colleagues on the defense team. And so that's where we are. And I believe that Mr. Jarvis would be able to testify about his categorization of these different piles and how they, his notes about these things. But this is a worksheet. These are his, I think he calls them bench notes that he did. And, this is in his own handwriting. It goes on for several pages. I wouldn't be able to understand all this necessarily on my own, but that's, I think, what my colleague is most concerned about. So it does provide clarity to the case. And as soon as I received it, I turned it over.
So if Mr. Menendez had access to the physical evidence, I appreciate Mr. Francis did, different lawyer. And when Mr. Menendez joined the case, he said, I'd like to look at it. He's entitled to do that. If he had been able to look at the individual envelopes in which the shell casings are held, would he have been able to see, what Jarvis calls 1A is evidence marker 6?
No.
The only way to do that is through the notes?
Well, it was helpful.
What I call the bench notes.
Yes, Your Honor.
What you call the bench notes.
Yes, Your Honor. It was helpful to me. I don't know. I've looked at the envelopes. We could look at one now, but to me, I had my own questions, and that's why I went straight to the source.
Sure. Do you intend to have Mr. Jarvis look at some crime scene diagram, whether it's Parker's or Falls, to say everything that is red is a shell casing from gun 1, and everything that is blue is a shell casing from gun 2, where he's getting specific and linking an evidence marker with a shell casing from a different gun? Or is it going to be a much more generic level, which is, hey, I grouped these in my report in this certain way because I figured out there's 16 shell casings that match. They all came from the same gun. And there, whatever the number was, 12 that came from another one and 3 from a third gun, which everyone can translate. Someone shot 16 times and someone shot 12 times. And this is the key part in my mind with the concerns Mr. Menendez had. Those shell casings from those different guns were scattered all over the place, as opposed to there was a pile of just 16 found in one place and a pile of 12 found in another place.
I do not plan on having Mr. Jarvis look at a map and point to different locations where evidence was collected. I don't think he's qualified to do that. He's done his role in the lab. He's opened up an envelope. He's made a note about this. It says evidence marker number 1, or it'd be like 3.
Yep.
Evidence marker number 3, and I'm going to put this in pile 1A. Based on what I have looked at, 40 years of experience, and this looks like it's going to go in pile 1A.
Right.
Evidence marker number 5, I'm going to also put in pile 1A because it looks like it's, but I think that's really what we're talking about with his testimony. He's not going to look, and I don't intend on having him look at photographs and say, oh, that went there. This in 1B, that was over here in that location. I don't think he's qualified to do that.
So to distill his testimony, it will be there were 3 guns fired at that scene.
There will be 3 guns fired at that scene. Gun 1 fired what was marked on the envelope as evidence marker 2, evidence marker 7, evidence marker 8, evidence marker 23, evidence marker 25, 26, 27, 28, 29, evidence marker 31, 32,
you don't
33.
need to read them, but so he will be letting the jury know that gun one, its universe of 16 or however many it was, were the following evidence markers.
Correct.
How was Mr. Menendez supposed to know that gun one's shell casings corresponded to that set of evidence markers?
Your Honor, I say this respectfully. The telephone is like a two-way street. And on the front of the official report by Mr. Jarvis, he's got his phone number, his website address, and there is nothing that I know of that would have prevented either of my defense colleagues from calling Mr. Jarvis the way that I called Mr. Jarvis. Every time I call Mr. Jarvis, he answers the phone. It's not like you have to go through a complicated network and you don't get in touch with the guy. So my initial belief is that they could have done the exact same thing that I did. It's my understanding that the physical evidence is available down at the Atlanta Police Department for them to go view on their own. They don't need me or somebody from the district attorney's office to do that. But
so let me make sure I understand that. I don't remember when Mr. Menendez got in the case, but let's say it was a month and a half ago. A month and a half ago, all the shell casings were at APD and not in the DA's office?
correct. We the general office policy, and as far as I can tell, since I've been working here, is that we don't go and grab the physical evidence until we got a jury seated or we're absolutely going to go to trial. And I don't know, I think that when I got in the case, I think I did get the evidence pulled a couple of days ahead of time, ahead of when we began jury selection, but it wasn't weeks and weeks. I haven't even been involved with this case for too terribly long. And so I'm the one who asked my investigator to go get the physical evidence. It has not been downstairs in our office for very long at all.
Okay. Are you aware of anyone from the DA's office letting Mr. Menendez know that if he wanted to inspect the physical evidence, he should go to Atlanta Police rather than the very natural, struck me as the right channel, approach of reaching out to the colleague, your term, reach out to your colleague on the other side and say, I'd like to see the evidence. And it might have, I don't know, but it might have been okay if Mr. Abate or you or anyone from the DA's office had said, I can't get it for you. I don't have it yet, but it's with the Atlanta Police Department. Let me know if they give you any trouble, but you should be able to go down there and they'll let you look at it. I don't know that they would let him look at it. I've never heard of a DA telling a defense attorney, go to the police to look at the evidence. I'm not saying it doesn't happen. That's is news to me. And I've been doing this for a little while. But you're not aware of anyone who told Mr. Menendez, we don't have it, DA's office, go to the Atlanta Police. And I'm sure Detective Thorp will come in from the cold and get it out for you.
Your Honor, I personally did not have that conversation with Mr. Menendez or Mr. Rowe. I don't want to try to speak with somebody else. I do think that Mr. Abate might be the best one to answer the question on his behalf. I do know that Mr. Menendez did, and this is a little unrelated, but it's kind of related. I do know that a lot of the communications went back and forth between Mr. Menendez and other people in the office, even after I'd filed a motion. And so I've had very little contact with my colleagues on the defense team here up until really the day we started trial. Mr. Menendez did have a question about opening an interview or something or celebrate phone records or something. And I did respond to that email and giving him step-by-step instructions on how to open up that piece of evidence. And I believe, I could be wrong, but I believe that I may have put something I usually do. I'd have to look at it. I may have put something along the lines of, please contact me should you have any additional issues or questions. At some point it was becoming obvious that I'm going to be lead counsel. So I'm not trying to pass the buck on anyone.
Okay.
I just don't have the answer specifically for the court right now.
All right. Thank you.
Yes, Your Honor.
Mr. Menendez.
Yes, Judge, I think the court articulated a lot of what I'm about to say pretty well. I'm not gonna spend too much time on it. But I'll just go through some of the things the state said. So as far as it being obvious that he was the lead counsel, I didn't know that until the Friday before trial when I tried to have a conversation with Mr. Abate.
You were reaching out to the attorney of record for the state and we got that covered. I mean, he's not here. They don't have someone else here to say, oh, I told them who to call at Atlanta Police Evidence. So you don't need to cover that.
Okay, thank you, Judge. And then as far as getting the evidence from myself, I think the court correctly stated that as a bit putting way too much of a discovery burden on the defense. I have gone there before when it was already arranged by the state and there was still a miscommunication and the detectives are saying, who is this young guy just at our station asking to look at evidence in a case, and it was this whole thing. So I think the court's intuition about that, is correct. And that is something they could have told me or could have said, yeah, here. What I was wanting is to avoid that. Time's precious. I wanted to go there and have them expecting me or have their investigator get it. I've had 2 trials with the same state this year. That's exactly what happened. I sent similar emails. They said our investigator is going to go get it for you and meet us in Miss Willis's office in this conference room. We're going to bring it to you, cut it open, you look at it, photograph it, do whatever you want.
That's how it ought to work.
Yes, Judge. So that didn't happen in this case. As far as the telephone being a two-way street, again, that puts a lot of a burden on me. I mean, I filed for discovery and it just wasn't handed over. It's not Mr. Griner's fault. It doesn't matter whose fault it is, but under the case law, specifically, Alexander v. State, which I cited in my motion to exclude 203 Georgia Act 375, it talks about just because any individual ADA doesn't know about something, still was their duty, and it is considered to be in possession of the state when it's in possession of their crime lab. This is the crime lab they used. That's also cited in Baker v. State.
Okay, I'm good on that part too. Let's get to the impact of the late disclosure and non-disclosure.
Oh yeah, the impact, Your Honor, is huge. And what I am asking is for that exact thing, that they are not allowed to point out which group is which evidence marker, because that's going to have an impact that I'm going to describe. So on September 5th, when they announced ready for trial, the ballistics report to my defense was irrelevant because I was saying that Mr. Phillips did not shoot in the driveway. Then on September 9th, this video comes out where you see Mr. Phillips shooting at the car at the court scene. Still don't think ballistics are relevant because who's to say that those shell casings from the car have any connection to the shell casings in the driveway? That connection didn't get made until September 16th, 2 days before trial. And Your Honor, I would say just because you call something notes or call something a worksheet doesn't make it a worksheet.
Did you ever reach out to Mr. Jarvis?
At some point, yes. And he called me back and then I called him back and he didn't answer. And I don't know exactly when that was, Your Honor. But I would say that's similar in the vein to, oh, you could have gone and got it from the police.
It's different. You could have spoken with Mr. Jarvis to see, what are you justifying? Tell me about the work you did. It would have uncovered perhaps that you didn't have everything from his file. But it sounds like you did try to reach him, but just didn't close that loop.
Right, Judge. And I don't think that absolves the state of the discovery obligations under the case law that I cited. And so now, September 16th, it's my duty as an advocate for Mr. Phillips to cast doubt on the work of Mr. Jarvis, or to argue that, okay, yeah, I did fire in the driveway, but I was scared because we were getting shot at, as the court's heard. And on September 16th, I just don't have time to do either of those. And the very next day before trial, I motioned to exclude them. On that day, we could have perhaps continued the case for me to hire a ballistics expert or to explore prior difficulties and self-defense and who are these attackers and on and on and on. And we didn't address that. And so at this point, that's what I'm asking, is the state be only allowed to argue what was disclosed under their obligation and the progeny of the case law, which is that, yeah, there were 3 guns. I understand that. And that, yes, there were certain groups of casings. And there were he does say how many are in each group. He says a group of 16, a group of 12, a group of 3. Okay, there was a group of 16, 12, and 3 shell casings, in my opinion, fired from the same gun, found on the scene. And I think that should be the extent to what that expert is allowed to share, because if he looks at the crime scene sketch and says this group of 16 was this one and this one and this one, that creates the connection of shell casings in the driveway to shell casings at the car where you see Mr. Phillips fire a shot, which is what that worksheet showed with several legal conclusions. And they're not just notes that support legal conclusions in the report, they have novel legal conclusions.
Give me an example of a legal conclusion.
Investigative conclusion, I'm sorry.
Okay.
An investigative expert opinion conclusion that creates an obvious inference that would have changed my defense substantially, almost entirely. And it also included conclusions that this group of shell casings had this brand of bullet fired out of them, and that some were this brand, others were this brand. So same argument, Your Honor. So those are the two things that are investigative expert conclusions in what's labeled a worksheet, but I'll stand on it. I don't want to split hairs and get into semantics and philosophy and linguistics.
I'm not focused on what it's labeled, but had you received that, you would have been able to see that Mr. Jarvis engaged in another level of analysis. Now, it is frankly grade school analysis. It is matching up, okay, the thing that this first shell casing that I looked at, that I put into pile 1A, it had on the envelope evidence marker 6 on it. That is nothing expert about that. My kids could do that, but you didn't have, I've been calling it the secret decoder ring. I mean, it sounds like you never received that. The thing that would let you know from where on the crime scene map did the 16 come, and from where did the 12 come, and where did the 3 come, whatever the numbers are, that was something that you would have learned had you received his notes / other reports, had his final report included that, and it didn't. So I'm not sure that you had noticed he was going to testify to that. And then no one's been able to answer this yet, but maybe on the envelopes that have each shell casing, it says 1A on a Jarvis sticker, and it says 13 on an APD sticker. And that would be a way to draw the connection as well. But you've made a clear record that you weren't provided access to that physical evidence until trial time.
Yes, Ron, I can proffer that the court's exactly right about that, because included in that September 16th late disclosure were actual photographs of the back and the front of all the envelopes, including photographs of the mark that he's claiming to pair, labeled with which evidence marker this cartridge is from. So again, I like to exclude all those photos of the envelopes that show the marker locations, and the cartridges that are labeled as the cartridge locations, those photographs and those investigative conclusions.
So how do you get around this? Mr. Jarvis says, here are all the shell casings fired by gun 1, the 16 shell casings. Why wouldn't an Atlanta police officer, let's say crime scene technician Parker, be able to say, oh, that's what I labeled number 4. That's what I labeled number 6. So she's not an expert. There's no notice the state needs to provide. How would that be? I want us to cover it now, because if I'm a creative prosecutor and I'm told, you know what, you stubbed your toe on the Jarvis stuff, late disclosed, didn't make physical evidence available, and it's not okay to say the defense attorney should go knock on the door at APD. We all know what would happen there. So Jarvis cannot say, here are the evidence placard numbers that correspond to these 12 shell casings. I may well make that ruling. Stymied, the state then says, all right, well, we can still, what Jay Jarvis can do is say, here are the 12 that I put in one group. And he just doesn't say anything about evidence placards. Why couldn't Parker come in and say, oh, well, that's number 16, that's number 2?
Well, because had that been That's absent from all the investigative reports of the police. So
What's absent?
which marker corresponds to which of Jarvis's groups?
Well, that's not in a report, but Jarvis, surely you assumed that Jarvis would be able to testify, these are the 16. Not here's where they were found or anything like that, but these are the 16 that I put in group 1A. You've been on notice for months that he's going to say 16 shell casings fall into group 1A. And that's all he does, limited to that. And he goes away. And then the state recalls a witness to say, all right, tell me what evidence markers correspond to these.
Well, Judge, I would be able to do that, and I have.
I'm not saying you, why can't the state do that? How is that inconsistent with the discovery faux pas that may have occurred in this case?
Well, Your Honor, because the only way for me to be put on notice of that is had I been provided a chance to review the physical evidence. So I made my defense based on what is the universe of information that the state provided with me.
Was this the first trial you were involved with when you learned that crime scene technicians assign unique numbers to shell casings as they're collected?
Of course not, Judge. And there's actually photographs in the provided discovery that show the actual evidence marker. You can zoom in on the photograph and see, oh, this one by the basketball hoop.
Right. So you knew that was going to be in this case, that every shell casing would have a unique APD evidence marker.
I did.
Okay.
What I didn't know is which markers are in which of Jarvis's groups.
Right.
And so if we're not going to allow Jarvis to testify to that, I think it would be an unfair way to backdoor that in by then creating the obvious inference by combining the police officer testimony with his, and now you get to say what it is that we don't want Jarvis to say. So just because it's not Jarvis saying it, it's still putting something in front of the jury that because of this, stubbing of the toe, I don't think they should be allowed to know that.
Okay, let me think about it. Mr. Rowe, anything you want to add on this front?
No, Judge.
All right. How are we doing? All our jurors are here. So we don't have closure on the Jarvis situation yet. I'm going to think about it more. We do have closure on Mr. Parks's statement to the police. So I think we're ready to go. We can talk about immunity testimony today as well. And I'm also prepared to talk about the Blakeney recording, but those aren't going to hit our radar right away, I think.
Yeah, just one more thing on the Blakeney recording. If we can just hold out on that, I did reach Ms. Blakeney in Carolina.
Okay.
She acknowledged she received my subpoena, so she indicated she would be here tomorrow at 9 a.m.
Problem solved.
Unless she doesn't show up, but I believe she'll be.
Okay. Well, we'll see what happens there. Mr. Griner, anything else before we bring the jurors in?
Let me make sure that Detective Thorp is here. He did indicate to me earlier that he might be slightly late, but I think he's here. Let me just verify.
Why don't we have your investigator do that while you're standing right here? Who do you call if he's not available?
I think he's going to be here.
Okay.
I don't have an easy answer until I know he's out here.
Okay.
There. I'm told that Mr. Jarvis is here.
Yeah, that's not helpful. I mean, I'm glad he's here, but he's not ready.
Your Honor, I had talking about the testimony at the immunity hearing. I had printed off a copy of the transcript and I had made some markings, suggested redactions, and I had turned them over to my colleague, Mr. Menettis. And I don't know where that is now, or if they have visited those issues, he and Mr. Rowe, if they have talked through it, and if they are ready for that part of it. But that's another thing that maybe if we had a few minutes, we could maybe shore up any difficulties.
All right, let's find out from your investigator first. Is Detective Thorp here?
So he's trying to find a parking downstairs, Your Honor.
Who else is outside?
Mr. Jarvis.
That's it? No medical examiner? No Detective Fall?
I guess, Your Honor.
Okay. Mr. Menettis, have you reviewed the proposed redactions to your client's immunity hearing testimony?
For the most part, Judge, yeah, and I have what the state referred to here in front of me, but I didn't ever give it to Mr. Rowe.
Okay, well, if you've gone through it, then if you get it to Mr. Rowe, that's something it sounds like we'll need to deal with today if the state's going to do that. We still need to finish our argument about that. It seems like we've got a few more minutes. Why don't we talk about the immunity testimony, not the redactions, but its admissibility writ large. I haven't heard from the state yet. They haven't been given a chance as to why the state thinks Mr. Phillips's immunity hearing testimony is admissible.
So, Your Honor, I see that document. You have that, not the transcript. Can I just see that for a second? Thank you. Your Honor, back on July 25th, 2023, there was an immunity motion held in this case, and at that time, defendant Phillips, Mario Phillips, did testify. Your Honor, the defendant was subjected to direct examination by his attorney and cross-examination by the defense attorney. Both sides had the opportunity and similar motive to develop testimony or his testimony by direct, cross, or redirect examination. Admissions by the defendant in this case, whether direct, adoptive, implied, or by conduct, they're admissible under OCGA 244401, 244402, and also 24801D2, which provide the testimony given as a witness at another hearing, the same or different proceeding, or even in a deposition taken in compliance with law, in the course of the same or another proceeding, if the party against whom the testimony is now offered, or in a civil proceeding, a predecessor in interest has an opportunity and direct similar motive to develop the testimony by direct, cross, or redirect examination. And also OCGA 248804B3 states that the following shall not be excluded by the hearsay rule if the declarant is unavailable as a witness. Number 3, a statement against interest. The statement against interest is a statement under A, which a reasonable person in the declarant's position would have made only if the person believed it to be true, because when made it was so contrary to the declarant's proprietary or pecuniary interest, or had so great a tendency to invalidate a claim by the declarant against another, or to expose the declarant to civil or criminal liability. And under B, supported by corroborating circumstances that clearly indicate the trustworthiness of the statement if it's offered in a criminal case as a statement that tends to expose the declarant to criminal liability. Your Honor, under these two statutory sections, the defendant did take the stand. He was subject to cross-examination by the state. There was a similar motive that the testimony was being produced at that time. He also did make statements against his own interest. He, if I'm not mistaken, my colleagues had the transcript for a while, but I know at a minimum he admitted to being present at the scene and also firing his weapon at the scene. And
so all those things are true, and none of those things are the reasons why Mr. Menettis has opposed this. He hasn't said it's hearsay or it's not a statement against interest. He identified the tension between rights, that a defendant ought not to be forced in order to pursue one right, the right to vindicate his right to self-defense, in other words, pursue immunity, to have to decide, well, do I testify in my immunity hearing knowing that that could be used against me at my trial? And he said it puts his client, any defendant, in an unfair dilemma. And what you said doesn't address that. I agree with everything you said, but I could still agree with everything you said and then agree with Mr. Menettis and exclude it, because his argument is that it is protected testimony. It could be used to impeach Mr. Phillips if he takes the stand and testifies. So he exercises his Fifth Amendment right in the direction of, I will testify. Certainly he can't hide behind some protection if he said something different at the immunity hearing. But this is a different scenario. You want to use it not knowing whether Mr. Phillips is going to testify. So I'm curious if you or a colleague has assessed that tension between the right to pursue an immunity motion and the right to not have that used against yourself in your subsequent trial if the immunity motion doesn't go well. And the classic case is this U.S. Supreme Court case, Simmons, in which a defendant took the stand in a suppression hearing because he had to establish standing. And then he didn't do well with the suppression hearing, went to trial, and the state or the government, I can't remember if it was a federal prosecution, they used his suppression hearing testimony to prove that that was his house where the drugs were found, because he said as much in the suppression hearing. And a majority of the U.S. Supreme Court said you can't force a defendant to waive his Fourth Amendment right to protect his Fifth Amendment right. Simmons has been a little sloppily applied after that. Simmons talks about constitutional rights, and specifically it was Fourth versus Fifth. You can't vindicate your Fourth Amendment right if the only way to establish standing is to testify, but that could be used against you at trial. It's not clear to me that we're dealing with the same scenario here. I'm not aware of a constitutional right to be found immune from prosecution. And Mr. Menettis gets creative with this right of self-defense, but I don't believe there is an enumerated right to self-defense. So I don't think it's an exact comparable to say he had to testify at his immunity hearing. I've presided over a bunch of immunity hearings where the defendant doesn't testify, probably because he doesn't want his testimony used against him in the future. But there's some scenarios where if it's just two people and there's a dead guy and a survivor, the only way to establish what was going on at the immunity hearing is for the defendant to testify. That's not this case. We saw there lots of witnesses, but for whatever reason, Mr. Phillips testified in his immunity hearing. I'm curious if you did any analysis of what Georgia law says about that tension between pursuing an immunity hearing in an effort to have the case thrown out and your right to remain silent at trial.
Judge, I don't have a case in my back pocket on that, but as the court has correctly pointed out, there were a number of witnesses here to this scene. There were a number of individuals that the defense could have called upon. They chose to have the defendant testify. And when the defendant testifies, you know, it can be very, very powerful evidence in a case where the defendant specifically states his version of events, and that can be very powerful testimony before a judge or a jury. But I think that that comes with it risks, and it's exactly this: is that if a defendant testifies, he is like any other witness, and that testimony, if it's subject to cross-examination, it may later be used in a matter that's against him. And so that's really where we are here. And the court is correct. There are, you know, maybe most immunity hearings do not involve defendant testimony for this specific reason. And so I don't have a case in my back pocket on this, but I think it just really speaks to, you know, it speaks to the issue, the risks and rewards, potential rewards of testifying as a defendant at an immunity hearing.
Mr. Menettis, your thoughts?
Yes, Your Honor. My intuition about this scenario, because I really researched this and I could not find any time that a higher court in Georgia or the 11th Circuit has addressed this, But as Your Honor knows, those courts only review things if there's been a decision about them, and then there's a non-acquittal, and then the defendant appeals. So I think what makes this unique is not the fact that it's statutory and not constitutional. I do argue that it is still constitutional based on what I cited in the motion. I think what brings us here is because most of the time, if a defendant does testify at an immunity hearing, he's going to testify at the trial. There's not really a scenario that I've ever been involved in my career where that wouldn't happen or that hasn't happened. The reason this unique scenario came about, and I can proffer, and I didn't want to put it in my motion, and I have subpoenaed Mr. Francis to come here tomorrow in case I need to use him as a witness. But what my investigation produced is that Mr. Francis, at the time of the immunity hearing, had not prepared any other defense and not investigated any witnesses.
So I need to know why you think it shouldn't come in, and not so much Mr. Francis, your perspective on Mr. Francis's performance.
Right, and that's why I addressed the state's argument about, other people could have testified.
Okay.
That's not true in this case.
All right, but that's clearly not going to be determinative. I think when an appellate court rules on that, they won't say, because that's impossible to prove that no one else could have testified. So tell me why you think that the testimony should not come in consistent with Georgia opinions.
Just, Your Honor, because of the Georgia Constitution and the immunity statute. Yes, it's a statute, but it's not like a statute that governs, a stop sign or something with a rational basis. It's a statute that wasn't just made up by the Georgia legislature. They didn't say, oh, we think people should have a right to defend themselves.
They did make it up. There are states that don't have it. There are stand your ground statutes, non-stand your ground. So why does one statute, is it because it's printed in a different kind of ink that it gets more deference than the statute that says a stop sign needs to be read? I don't know that the legislature would like to hear that some are more important than others.
Not more important, Your Honor, but more based in the Georgia Constitution. And what my intuition is that I didn't get a chance to go this deep, but that the legislative intent is to put parameters on our right to defend ourselves from the Georgia Constitution. And the Georgia Constitution, when addressing the right to defend yourselves, explicitly mentions that. It says that just like in the United States Constitution, under the Georgia Constitution, people in Georgia have a right to use force to defend themselves. They have to establish the standing first. The judge can decide not guilty or innocence, but whether it can go forward. And the next sentence that I cited in my motion is, but the Georgia legislature shall have something like, I don't have it in front of me, Judge, something like it's in the authority section, something along the lines of what the Georgia legislature shall have the right to put limitations or parameters or guidelines upon the use of this fundamental constitutional right to defend yourself from the Georgia Constitution, which is what I argue to the court is being done by the immunity statute, which makes it unique in that, to me, it is a constitutional right. It's a statute talking about a constitutional right like the Constitution tells it to do, not like running the stop sign statute, which of course, again, poor choice of word is not more important, but just more constitutional, which puts it under what the court properly articulated, that it creates this constitutional tension. And if all you would have to do is put in Second Amendment for Fifth, Eighth, other amendments when it comes to establishing this. And so I think if all we're going to do is say that, well, it's a statute and it's not out of the Constitution, I don't think that gives it enough nuance, because the Constitution itself directs the legislature essentially to enact a statute like this. So it is unique in the sense of its basis in constitutional law.
Okay, so we're clear. The Georgia Constitution says nowhere that there is a right to self-defense. The Georgia Constitution, mimicking the Bill of Rights, says that there is a right of the people to keep and bear arms that shall not be infringed. And from that, you leapfrog to immunity. Of course, immunity doesn't say anything about guns. It says using force. It could be a baseball bat. It could be a bow and arrow. But here's my ruling on this. First, there is Georgia case law, Cowards versus the state, 266 Georgia 191, in which our Supreme Court said that bail testimony can be used at trial because, one, you don't have to testify at your bail hearing. You can. It may make that hearing more effective. But if you stray into the area of guilt, innocence, and not so much, I'm not a risk of flight, that could be used against you. We've got plenty of cases that talk about a defendant waiving privilege against self-incrimination to the extent of his testimony. There are a series of Georgia cases that allow defendant's testimony from a previous trial that ends in a hung jury to be used against him in the new trial, even if he doesn't testify, pitting fifth versus fifth. So I don't find that it is excludable. I find that it may be used. The Georgia cases where a defendant's testimony from a previous trial was used against him in his subsequent trial when he chose not to testify, demonstrating that his testimony wasn't necessary to make his defense because he didn't testify in the second trial. The way those played out is that the state had to wait first to see if the defendant was going to testify. And if he didn't, then the state was allowed to reopen evidence and get in the testimony from the prior trial. And that's how we're going to do it here. I don't know if Mr. Phillips is going to testify. If he doesn't, then the state can get the immunity hearing testimony in after the defense rests. If Mr. Phillips does testify, then there's a different conduit of getting in that, because one, the state will be able to cross-examine him. And if he says something materially inconsistent with his immunity hearing testimony, he can be impeached with it. Mr. Rowe, again, not intentionally excluding you, really not your debate. Anything you want to add?
No, Judge.
Okay. Mr. Greiner, any questions about that?
Just so I'm clear, I want to make sure I heard all that right. We're going to wait. State's going to rest without reading all that into the record.
Correct.
And then we'll see what the defense decides to do and then play off of that.
Correct.
Okay.
If Mr. Phillips testifies, this is appreciate why the motion was filed. It was a prophylactic motion, should have been filed given Mr. Menendez's concerns. But if Mr. Phillips chooses to testify, then those concerns evaporate. Not was Mr. Francis deficient in his performance at the immunity hearing, et cetera. That all can be raised at a later date if there's a conviction of Mr. Phillips in this case. But the concerns about rights bumping into each other are made moot should Mr. Phillips choose to testify. If he doesn't, whether Mr. Phillips puts up any evidence or not, I'll allow you to reopen. It'd be natural rebuttal if he puts up evidence, you can rebut, but there's not a slick move that Mr. Menendez could play of saying, well, we're putting up no evidence, and so the state is foreclosed then from reopening. I'll simply allow you to reopen evidence because I'm not going to have Mr. Phillips tell us right now whether he wants to testify, although we're going to have to talk about that soon. Okay?
Okay. May I then get back my copy?
Well, once Mr. Menendez needs to finish going over it. I don't think he had finished that.
No, Judge, and I thought that was my copy to keep, but I can certainly take a photograph of the information that's relevant and look at my own transcript and look at the lines.
Okay.
I do want to address just a couple more things. Of course, I respect.
Stop for 1 second. Has Thorp made it here yet?
He's here.
Okay. All right. Yes, briefly.
Very, very briefly. So I do want to say that I don't mind divulging some attorney-client communications, but it's our position right now that, but for the court's ruling, Mr. Phillips would have chosen not to testify for sure, and we're going to proceed now with the rest of the trial to see how it goes. Secondly, I did want to, of course, maintain my objection that I understand what the court ruled. I just want to perfect the record that under the discovery statute and the 5th, 6th, and 14th Amendments, I don't think that it's an appropriate burden for the attorney to go through and find everything he can and then add it to the state's case. When the state announced ready on September 5th with a certificate of discovery that did not include the transcript, I relied on that to create my defense, similar to the.
I hope that's a practice you change going forward, because Whoever handles Mr. Phillips's appeal, should he have one, I think will find no success in the claim that the state has an obligation to hand over something in the docket of the court. But you have now multiple times made that argument. I hope you don't make it in front of another judge again. Anything else?
Your Honor, I guess I won't unless I research it. I'm pretty sure there might be a case about that, but I'll move on. As far as the transcript, it involves, as the court knows, Mr. Dennis Francis's hearsay in that transcript. And that's another basis for me to object to it. I don't have him available for cross-examination to say, why did you ask this? Why did you ask that? And that's impermissible here.
He's not available for cross-examination. Why?
Well, he is now because I subpoenaed him, but,
So what's the unavailability?
well, not unavailable, but I would just ask that the state have to include him as a witness if they're gonna use the transcript. And, you know, that's a basis for not.
How are questions hearsay? What did you do next? How's that hearsay?
Your Honor, okay, maybe I shouldn't have said hearsay, but it does violate Mr. Phillips's right to confrontation under the Sixth Amendment because, and I don't mind being fully transparent, I just didn't want to put it in the motion. Mr. Francis told Mr. Phillips that I don't have any other defense prepared besides self-defense. Mr. Phillips told him something differently, and he told Mr. Phillips unethically that the only way you're going home is if you say you shot in self-defense. And that explains some of the inconsistencies in Mr. Phillips's answers. And that's why, okay, yeah, it's not hearsay, but it is information that I have a right to confront.
It is definitely not hearsay. Let's bring the jury in.
And then I have subpoenaed him.
Another time we can talk about other things.
Yes, sir. That's the only information right from me. That's the only information
I need marks off you.
the marks correspond to the.
Yeah.
Okay, so I took a picture of that template.
Okay.
Mr. Griner, is Mr. Parks's statement that you're going to play pretty clearly in custody, or is it not clear what his situation is?
He, I believe, is has one of those securing bracelets, a handcuff on his ankle, and it's in an interview room. He's wearing street clothes.
Okay. Does the detective at any point say, you know, you're under arrest for?
Yes, he's in custody and he's read his charges. He's read Miranda.
Okay.
All of those things.
Okay. I just want the jury charge to reflect what, I mean, I'll see all that soon anyway.
Yes, Your Honor.
Okay.
All right, for the jurors.
Thank you, Deputy Gordon. Good morning, ladies and gentlemen. Hope you had a good weekend. I appreciate all of you coming back. Sorry for the late start. We had a late witness who has gotten here now. So we are going to continue with the state's case, and I'll ask Mr. Greiner to call his next witness, please.
Call Detective Thorp.
Raise your right hand. You swear affirm testimony you will give the truth, the whole truth, and nothing but the truth, so help you God. I do. Can you state and spell your name for the record?
Detective J. Thorp Jr. Thorpe.
Good morning, sir.
Good morning, sir.
Can you tell the jury where you're currently employed?
Yes, sir. City of Atlanta Police Department Homicide Unit,
How long have you been with the city of Atlanta?
30 years and 9 months.
Can you tell the jury what you do with the city of Atlanta Police Department?
Yes, sir. I'm currently assigned to the Homicide Cold Case Complex Unit,
How long have you been a homicide detective?
20 years and 9 months.
Tell the jury a little bit about your law enforcement training and experience.
Yes, sir. My first assignment out of the academy was the Zone 3 Evening Watch Mobile Patrol, which I patrolled for 2 years from 1995 to 1997. From 1997, I was transferred to the Red Dog Unit, which I worked from 1997 to 2000. 2000, I was promoted to the rank of detective and assigned to the burglary unit. I served in the burglary unit for 2 years. At that time, I was transferred to the robbery unit, which I served another 2 years. Then in 2004, I was transferred to the homicide unit.
Can you give the jury a sense of what you do as a homicide detective once you've been assigned a particular homicide to investigate?
Yes, sir. The Atlanta Police Homicide Unit work off what is called a unit rotation, which is, if anyone is familiar with, like a baseball pitcher rotation. You're on call until you receive a call in service to work a homicide unit or possible suicide or felon justifiable homicide. At that time, you respond to the scene, and at that time, you go ahead and start getting debriefed by the officers and the first responding detectives to the scene.
Were you on duty back on September 13th of 2021?
Yes, I was, sir.
Did you get a call out to a homicide that occurred here in Fulton County?
Yes, I did, sir.
And did you respond to Notting Hill Drive that time?
Yes, I did, sir.
And the location that you went to, is that in fact in Fulton County?
Yes, it is, sir.
I'm going to show you what's been marked as State's Exhibit 1A and see if you can recognize State's Exhibit 1A. This is already in evidence. We've discussed the number of witnesses, but let's see if this makes sense to you.
Yes, sir, it does.
Okay, and can you just tell the jury, sort of orient us a little bit, as to State's Exhibit 1A and what we're looking at?
Yes, sir. That's the bird's eye overall satellite view of 426 and 428 Notting Hill Drive, located off of County Line Road, Southwest Atlanta.
All right, up here along County Line Road, are you aware of whether or not there is fencing between the road and between the rest of the housing development?
Yes, it is, sir.
Right? And then can you notate on the map the approximate area where the deceased was located?
Yes, sir. He was located right in this driveway here.
Okay, and was there
This
a,
driveway right here.
okay, and you've pointed to, is that 42,
Yes, sir.
26,
Yes, sir.
42, 28?
4226.
Okay. And can you tell the jury what you did when you first arrived on scene?
Upon arriving on scene, Sergeant Mitchell of the Atlanta Police Homicide Unit began to brief me about information gathered so far by the homicide detectives that arrived on the scene. At that time, she began to lay down that based on the neighborhood canvass that was conducted, 2 names of possible suspects was developed. The nicknames were Hot and Whoa.
Did you walk around the scenes yourself?
Yes, sir. Prior to coming inside the subdivision myself, I parked right along here on kind of on the road, and I walked up just to get my orientation correct and look overall. And I walked in and met Sergeant Mitchell right here.
Were there a number of people out there in the neighborhood when you arrived?
Yes, sir.
Do you remember approximately what time you arrived or how long other officers had been there at the time of your arrival?
I believe it took me about an hour to get to the location because I was actually off the working shift. And when the homicide rotation shift is, doesn't matter if you're off or you on holiday. If you get a call, you have to come back and respond back into the city.
When you arrived, had other officers secured the scene, secured the area?
Yes, sir.
Were there other people or witnesses, potential neighbors out there available to speak with?
Yes, sir.
Did you speak with anybody that you recall right off?
There's a couple people I spoke with, but they didn't want to get involved other than giving me general information. And I spoke and I've been being directed to a Miss Stallworth.
What was the importance of Miss Stallworth?
Ms. Stallworth advised that she has video surveillance cameras that captured the shooting incident and everything afterwards.
Were you or others able to get a copy of what she was talking about, these video surveillance videos?
Yes, sir, we were.
And did you later, when you had the opportunity, take the time to review all of the videos?
Yes, sir.
What else did you do after you spoke with Ms. Stallworth?
At that time, I started to walk around the crime scene myself to see exactly why the other homicide detectives, there was one team of homicide detectives processing the crime scene, laying down markers with the crime scene investigators, marking the shell casings and also where the victim was discovered. And I began to walk around, seeing exactly where everything was being placed and even where the evidence was all correlating together.
When you say walk around, let's look again at State's Exhibit 1A. If you could just sort of give the jury an indication of where all you walked around.
I walked around here, there were shell casings here, walked through here, shell casings, looked at the defects to the locations, walked back over here and looked around over here, discovered shell casings in the driveway and further in the front doors.
Did you or others, to your knowledge, look at some of these other areas, around the cul-de-sac and these other areas?
What I was told that the officers had already started walking around Kingston, looking at themselves, anything else, any other people that got hit by stray rounds or anything like that.
Can you give the jury a sense of approximately how many officers were out there when you got there?
I want to say probably around 6 to 7.
And did you do anything in terms of collecting evidence?
I did not physically collect the evidence myself. I went on ahead and instructed the crime scene unit, once everything was photographed and processed, to go ahead and start collecting everything.
Did you receive any evidence from another detective?
Yes.
I'm going to hand you what's been marked as State's Exhibit 154 and ask if you can just take a look at this and tell us what that is.
Yes, sir. This is a cell phone that was recovered from the scene. And Sergeant Mitchell advised me that this is the phone that may have been dropped by a possible suspect by the name of Phillips, AKA Woe.
Okay. Did you know anything about that cell phone or tell the jury a little bit about what you did with that cell phone when you received it?
Okay, upon receiving it, because there was other people on the scene stating that this was DeMario's phone or Woe's phone. At that time, I went ahead and secured it. Secured a Fulton County search warrant to have the phone itself downloaded and dumped by our cyber crimes unit.
Can you tell the jury what that means, what you just said?
Basically, it's a forensic electronic extraction that is done, which means that all calls that was made, the phone, who the phone is registered to, the call logs, text messages, images, everything that's on the cell phone's hard drive, might as well say.
Are there times when you get a phone and you're not able to get into the phone because of passwords or encryption or something like that?
Yes, sir. If the phone is password protected, it takes the encryption key a while to crack into the phone itself to decipher the encryption.
It sounds like you were told that phone was dropped by someone about a particular individual. Did you have any way when you were out there on the scene of verifying these phone actions?
No, sir.
The information that the other detective, did you say Nelson?
Sergeant Mitchell.
Sergeant Mitchell. Sergeant Mitchell received, did you get a chance to speak to the people who told her that?
No, sir. That person kind of walked away and never came back to the scene.
In your experience, when you have sort of a wide open area like this, wide open scene with many ways to get in and out of the scene, is it sometimes chaotic?
Yes, sir.
Can you describe this particular scene on that evening?
Most of the scene was basically the residents, people that lived in that subdivision, you know, they was expressing that this was an ongoing conflict between the two residents, and that, you know, everyone was pretty much checking up over the shooting. The victim family arrived on scene, so we had to secure the family also, and also along with his girlfriend or his fiance, who was pregnant at that time.
Say victim, are you talking about the deceased victim?
Yes, sir.
There was a house that was shot up, 4215. You're familiar with that house?
Yes, sir.
Did you see defects to that house that corroborated what you were told?
Yes, sir.
Can you give the jury an indication of, when you say defects, what you're talking about?
Pretty much the defects was pretty much in line with defects done by bullets penetrating the location, whether it's the door or the frame of the house or the brick or the stucco that was on the house.
Okay, and was that at 4215?
Yes, sir.
Did you later become aware of whether or not another residence close by had been struck?
Yes, sir. Later on that night, after we cleared the scene, the first responding officers were still on scene doing this report. At that time, the residents on 4322 arrived home, and she discovered that one of the rounds penetrated her front door, made it through her house into her downstairs bathroom, penetrated and landed inside her bathroom, the downstairs bathroom. She indicated that her son and daughter was at home prior to the shooting, but she had picked them up and took them to work with her. So there was no one luckily at the house at the time of that shooting.
Was there also damage that you later determined or found out at another residence?
Yes, Ms. Stallworth contacted me the next day and discovered that there was a round that penetrated her garage at 4219, and there were bullet fragments inside of her garage.
And Ms. Stallworth is the one who also turned over the video?
Yes, sir.
Did you or others also get video from 4215?
Yes, 4215 had their own DVR video surveillance. At that time, I secured a Fulton County search warrant to seize that DVR, and then secured another Fulton County search warrant to have that same said DVR video extracted by our cybercrime unit.
Let's talk for a second about what you just said. Can you tell the jury, first of all, we're talking about 2 search warrants concerning that DVR.
Yes, sir.
Can you explain the reason why you needed 2 search warrants for a single piece of evidence like that?
Yes, the first search warrant is signed by Fulton County Judge to give permission and clarification that we can seize that piece of equipment at that moment. The second search warrant is again signed by Fulton County Judge, giving us permission to go ahead and extract information from it. Without those 2 search warrants, anything that we've done, we cannot do without those 2 search warrants.
So the first search warrant is actually grabbing the box and taking it out.
Correct.
You need it for that reason.
Yes, sir.
Second search warrant is actually to go in and receive information out of the report.
Correct.
There was, did you become aware that Javante Harris, the resident at 4215 had been detained?
Yes, sir.
Can you explain to the jury why he was detained?
He was detained because the neighbors that came out stated that they saw him standing outside with 2 pistols. He was detained, and I instructed the homicide detectives have that subject transported to the homicide office for a follow-up interview. And at that time, he was transported and secured at the public safety headquarters for the homicide unit to do a further investigation on him.
And just so we're clear, when we say detained, we're talking about handcuffs in the back of the car.
Yes, sir.
Did you later become part of an interview with Mr. Harris or speak with Mr. Harris while he was in the police station?
Yes, sir. Upon clearing the crime scene, I made my way back to the public safety headquarters homicide office. At that time, I had Detective Fall and Detective Barber do an initial interview with him. And it was already determined that he was not the shooter of the incident based on the video that we was able to look at on the scene. At that time, I began to question Mr. Harris about his knowledge of what the events led to the shooting.
And what were you told by Mr. Harris?
Mr. Harris advised me of 3 individuals that had walked in front of his place of residence. And he stated that there's been an ongoing conflict between them. And he stated that, yeah, I know who they were. I only know their nicknames of Woe and Hot. He said the other guy I did not know. So I told him, can you give me the clothing description of Woe and Hot? He gave me the clothing description of what everyone was wearing before and after the shooting.
Did you ever get a chance to show him any photographs of Woe and Hot? Or?
Yes, I did ask to establish a relationship or a timeline of how long he's known these 2 subjects. He said he's known them for about a year. So I presented him single photos, and he was able to say this person was the person he knows at Hot, and this is the person he knows as Woe.
Did you ever develop any indication or any evidence that Mr. Harris had been out there shooting his gun or threatening anyone with a gun that day?
No, sir.
Can you tell the jury whether or not you ordered or requested a gunshot residue test to be done on Mr. Harris?
Yes, to verify that he did not discharge a firearm. I went ahead and had a gunshot residue test conducted on him and submitted to the GBI.
And are you aware of the results of that test?
Yes, sir.
Okay. And what we have it in the evidence, but what were the results as you understand them?
It was negative that he was in the vicinity or that he discharged the firearm.
Were you told or were you led to believe that there was a white car involved in any of this incident?
Yes, sir.
Can you tell the jury what you learned or what you observed on video concerning the white car?
There was a white car on scene, and that subject happened to have been a friend of Mr. Harris. Prior to the 3 young men approaching, you can see that he reached inside of his car and pulled out 2 pistols. And he
Say he, can you tell us who you're talking?
I cannot recall the young man's name.
Okay, let's just call him Sam.
Sam. Okay. Sam did.
Counter leading.
Yeah, let's, let's just call him, you don't know his name. So we'll say unknown individual.
Okay. The unknown individual stood at his door frame and just watched the three subjects walk past him. And at that time, he never engaged them. He never said a word to them. He just observed them walk by. Then he went back. He put the pistols back inside his vehicle. He talked to Mr. Harris, him and his girlfriend, I assume, came to his car and they drove off.
Did you see the video that shows them drive off?
Yes, sir. The video showed they drove up to the top of the exit entrance of the subdivision, and he made a left-hand turn on the county line and continued on.
So when officers were responding to this location right after the shooting, are you aware of whether or not it went out on the radio to look for a white vehicle?
I cannot recall if it did went out on the radio, but the officers were aware that a possible white vehicle was involved. So when the homicide units got there, they notified us.
And are there police cameras up on County Line Road?
Yes, I believe they point primarily onto Campbellton, and I believe they were not working at that moment.
Were there any traffic stops or any suspicious vehicles located in that area at or around the time that the police were called out for this homicide?
No, there was not.
Did you ever develop any indication that this unknown individual in a white car was responsible for any of the shooting out here?
I discovered that he was not involved in the shooting at all.
Let's talk a little bit about Carrie Henderson. Do you know who Carrie Henderson is?
Yes, that's the mother of Kamari Parks.
Okay, and let me show you again, this is Exhibit 1A. If you could just point to where Mr. Parks and his mother live.
They live right here at 4228 Notting Hill. Section right here.
And the homicide occurred.
At 4226. Right next door to them.
Okay. And did you get a chance to speak to Ms. Henderson?
Yes, I did not speak to her directly, but Detective Churchill of the London Homicide Unit spoke with her on scene, and she gave the names of Roe and G.
I'm looking to you, Mr. Griner. They've objected on the basis of hearsay.
Yeah, I can rephrase the question.
Okay, so you all should disregard what you just heard Detective Thorpe say.
Okay. You spoke with Ms. Henderson. Let me ask you a different question. Did she ever indicate that her son had been there?
Objection, Your Honor.
So how is that not the truth of the matter asserted?
I can change.
Okay,
Did you end up charging Ms. Henderson with charges related to this case?
Yes, I did.
And what did you charge her?
False statements.
Going back to the scene here, this is Exhibit 1A. Let's talk through a couple of scenarios. Did you check into the possibility that someone had been somewhere in the neighborhood shooting back at the defendants down here near 4226?
Yes, sir. Myself and Detective Benson of the Homicide Unit came back out from there so later to talk to Ms. Neal, which was the girlfriend and fiance of the decedent, Mr. Arnold. At that time, I stood here in the driveway and looked back up this way to see if I could see the top of the hill where the businessman needs to be out, since we kept getting word that the driver of the vehicle drove to the entrance exit and started firing. And also we was told that he came out this way and shooted back toward this way.
Objection, Your Honor, hearsay.
I was gonna ask, who made the statement to you? Who told you that?
It was by Kamari Park.
okay. I guess you need to elaborate on how he learned that. And if you do, then that's not hearsay.
Okay. All right, did you later interview Mr. Kamar's Parks as defendant in this case?
Yes, I did.
All right, was that interview a formal interview with Miranda?
Yes, sir.
Okay, we're gonna listen to it in a few minutes.
Okay.
But you can ask him about the contents of that interview. Just make sure it's going to sound like it's a leading question. It won't be. But as long as you're qualifying your questions about, did you learn this? Or if it's, did Mr. Parks in his interview tell you X? They can object to hearsay, but I'll overrule it.
Can you tell the jury essentially what Mr. Parks told you in this interview?
Yes, he stated that the person in the white vehicle started shooting. I advised him that based on the video surveillance that I'm looking at, the person in the white vehicle never got out his car or never fired a round. He then later changed the story to saying that he parked on County Line Road. I'm sorry.
The unknown person?
Yes, the unknown person pretty much walked in through the side of the subdivision between the homes and started firing his weapon on that street. And I told him couldn't be, because he does not have a clear view to where you live, and you don't have a clear view to where he may have been shooting. And once again, there's no video surveillance showing this occurred.
So let's look at 1A then, and if you could just elaborate. When you and Mr. Parks, the defendant Parks, were first talking about what you just said, the white car and all that. Can you just demonstrate to the jury what you all were talking about?
Yes, Mr. Parks stated that the vehicle left, drove up here and started shooting. As you can see, they were back here near the front door, and inside, in the walkway, in the driveway. There's no clear view back this way towards the vehicle. Then he later stated that the subject came in between the homes, the then started shooting. Once again, he will never have a clear view from where the initial shot was fired, of a clear view of going back up this way.
Sir, you also talked about meeting with Miss Neal.
Yes, sir.
I'm gonna dot a Neal.
Yes, sir.
And do you recall approximately when you met with her?
I believe it was like maybe a day or two after the incident. I gave her some time to gather herself, because she got very hysterical on the scene. And because of her terminal pregnancy, I went ahead and interviewed, I had concluded the interview to keep her from having any type of medical issue during the days.
Okay. And did you get a chance to walk around outside with her and have her look at things and point in different directions?
Yes, sir, I did.
Can you tell the jury what she told you about what occurred? She's already testified.
Yes, she basically said that her and Mr. Arnold was coming back in the vehicle. He kind of rushed him back inside the apartment. Upon him being shot, that's when she came back down the stairs. When she was trying to figure out where he was, she came back down the stairs, in man in the driveway, on his back with his head towards the front door of their location. She also stated that Bo and Hot and G was at the location prior to the shooting and during the shooting.
And did you give her photographs to look at to help identify who Woe and Hot were?
Yes, I did, sir.
Let me hand you what. It's been marked as State's Exhibits 173 through 189. And ask if you can look at these, please.
Yes, sir. Yes, sir. Yes, sir.
You recognize those photographs?
Yes, sir.
Can you tell the jury what they depict just generally?
They generally depict the location in broad daylight, because the incident did occur during daylight time. It shows the view off of County Line Road into the subdivision, and also show their vantage point from 4226 and 4228 Notting Hill back up to County Line Road.
Were you present at the time those photographs were taken?
Yes, I was.
Are they true and accurate depictions of how the neighborhood looked as you were out there?
Yes, he did.
All right, this time I'm gonna move to the exhibits 173 to 189.
Mr. Rowe, any objection?
Okay.
Mr. Menendez?
Yes, Judge, just one objection. He said he was present when they were taken, but I don't think he can testify as to if they're accurate or unaltered if he didn't take them himself. He doesn't have that exact view and hasn't looked at the pictures before today.
Do they appear to be altered in any way?
No, sir. I was.
Admitted.
This also is 173.
Yes, sir.
So we're gonna put it up on the screen.
Okay.
So you can see it. And you should have this screen right.
It says unmute.
Yeah, don't hit unmute. Say stay muted. Great.
Can the top screen work?
It can. Deputy Gordon? Sorry, we're a little rusty. It's a Monday. Can you do your screen activation thing? Sorry, Detective Thorpe. Just got to get up there. Do it? Excellent. Thank you. You do good work.
So, Your Honor, my colleague, just before I forget about it, I want to tender State's Exhibit 154, which is the phone. And
All right. Any objection to States 154, Mr. Menendez?
No objection at all, Your Honor.
Mr. Rowe?
Okay.
It's admitted.
Okay, thank you. So let's look at State's Exhibit 173, and can you just explain to the jury what we're looking at State's Exhibit 173?
Yes, sir.
This is County Line Road going this way. This is the entrance exit into the subdivision. So this will be the viewpoint from you leaving out of the subdivision, looking back inside the subdivision.
Okay, so if we look at 1A, and if a car came up here to the intersection of Notting Hill Drive and County Line Road and made a right hand or made a left hand turn, would we be looking at roughly what we're looking at here?
Yes, sir.
And can you see 4226 from that location?
No, sir, because the trees were obscuring your vision and also the residents.
Okay. Is there some curvature to the road?
Yes, sir. It curves back in
To the
the other.
to the left. Okay. Let's look at State's Exhibit 174, please. There's a time lag.
Okay.
It goes out and comes back. And can you tell us what's occurring here in 174?
174, I had the crime scene unit come closer and take an even closer shot, looking down into the subdivision. So this is now on the sidewalk on Notting Hill, looking down County Line, sidewalk on County Line, looking down once again into the entrance exit of Notting Hill.
Let's go to 175, please.
Let's see, it's still a photograph from County Line, Double Line Road. Looking back once again, then trying to look down into the subdivision itself.
And 176.
That is, this is the location of where Miss Neal and Mr. Arnold live. So we're at the corner of 4226 Notting Hill and 4228 Notting Hill, the driveways.
Let me show you Six Exhibit 1A, if you could just take a look at that, point at the general area or from this vantage point.
So we were here, curving through Oxford Court. Section one.
This looks like kind of a burgundy SUV. It's kind of on the right side of this picture. Is that sort of turning toward Oxford Court?
Yes, sir.
And can you identify 4215 on the photograph, 176?
4215 would be right here on the left.
Can you see this other residence, 4322, which you testified earlier had been shot?
4322 is right here.
Can you see County Line Road, or if somebody was out there, or in the car out there, would you be able to see that from this location?
If you're standing in the driveway, you have no vantage point to look up and see anybody on the road or the entrance, exit of the subdivision.
Just to give the jury sort of perspective, photographs can always do a good job. Is there a great distance in between the driveways here, between where you are, where this blue car is, and 4215? Is there, we're talking about a long distance here?
Yes, I believe it was like through about 42 yards, something like that.
Okay, 42 yards or so.
Yes, sir.
Okay. All right, and, all right, let's go 177, please. 77 is kind of similar.
Yes, sir. This is once again another closer angle view looking up.
So 178.
That's once again inside the driveway of both
4226 and 422890. So this, their driveway is a split driveway.
So if you're standing here in the driveway, which is shown as 178, would you be able to see a car up there at the top of the hill?
No, sir. Once again, it's taken as a, based on surveillance, their possible visual vantage point or where they could have been standing, or anyone could have been standing, looking back up, once again, toward the top of the hill in the subdivision.
Did it make sense to you what Mr. Parks told you occurred?
no, it did not make sense to me.
Let me show you Six Exhibit 1A again. Let's talk about the gap between these two buildings, between 4316 and 4312. Were you ever told by Mr. Parks that the person came through between buildings or something like that and shoot?
Yes, sir.
Can you tell the jury what you were told and whether that makes sense?
According to Mr. Parks, he did change the story from the shooter was inside the white vehicle to the person parked on the county line. As you can see, it's a single lane. So parking there, county line road, you get kind of busy. So the park there, you'd be obstructing other cars coming through. He stated that the person came through and started shooting from up there, and I advised him that's once again, that's impossible. There's no surveillance, no vantage point to show that this person came over this fence, cut through the buildings and started shooting.
Would you be even able to see someone who's up here in this area between the buildings from the vantage point shown in 61?
No, sir, not from this angle here. And then looking up, we're not able to see anyone coming up this way. And also based on the video surveillance, there's a young man playing basketball right here on this side street here. When shots are fired, he runs back that way on 90 here. So he did not run this way in front of the residence. He ran to the side. So if anyone was shooting this way, common sense would take that he would not run towards it, he would run away.
And you've also reviewed the video and looked at what timing cues you might be able to see.
Yes, sir.
Was there enough time for an individual, this unnamed individual or someone else, to park up on County Line Road and come down and be in a position to begin shooting?
No, sir.
Let's look at State's Exhibit 179. Okay, can you tell us what's occurring here in 179?
Once again, this is the same driveway of 426 and 428 Notting Hill. So once again, we just taking different vantage points or photos. Which once again to show, you cannot see the entrance or exit of the subdivision, or clearly see somebody coming from this side, start shooting.
I'm trying to locate one exhibit in particular. Let me move on to something else. Let's go to 180. So we got a lot of photographs of sort of this vantage point. Was this an important vantage point or area for you to investigate?
Yes, sir. Once again, crime scene, investigator, she's gonna be able to even closer shots, zooming in, zooming out. Everybody's vision is different. So I'm pretty sure that you can definitely see what we don't see. There's no way you can come from between these two buildings and start shooting.
Let's look at 181.
This is Notting Hill. It's the front of their driveway of 426, and 428, 4228, 4226, and 4228 leading out of the subdivision.
So whoever took this picture, 181, looks like they were standing in the roadway. From that vantage point, can you see the entrance of the neighborhood?
No, sir.
Let's look at 182. Did you become aware of a car that was important for the investigation?
Yes.
Can you tell the jury about this specific car?
As myself, Detective Benton was interviewing Ms. Neal, he stated that Mr. Parks' grandfather or uncle's silver Malibu got struck. I remember seeing the silver Malibu on this video surveillance. And on the video surveillance of the night of the incident, the nose of the vehicle was pointing down towards the street of Notting Hill. And she said, Ms. Neal advised us that vehicle even got struck by a bullet. So I went out and looked at the vehicle, and based on where the vehicle was parked, the vehicle was struck on the left rear door frame of the vehicle, which means that you had to be standing on this side of 428, shooting back this way. All the damage to the left side of the vehicle.
I'm going to show you State's Exhibits 24 and 25. Can we look at 24, please? Just have you look at those. We're going to put up those exhibits here in just a moment. Okay, do you recognize State's Exhibit? Lost. Were you able to look at video and photographs of the crime scene technicians took that evening and determined the placement of this vehicle we're talking about?
Yes, sir.
All right, so it's gonna come up in a second. Let's look at State's Exhibit 1A real quick. If you could just point out approximately on 1A where this car was parked.
You can just imagine the Malibu, the silver Malibu, you're on this street with the nose, the front end of the vehicle pointing this way from Oxford Court to Notting Hill. That's where the vehicle was parked. And also, with that vehicle, Burgundy vehicles on the street also.
Okay. And so this is not a picture of the car, but it was somewhere in this area.
Yes, sir. It was parked right along here.
And so earlier you testified that it was pointed out, it was parked on Oxford Court, pointed toward Notting Hill Drive. And the bullet damage was where?
To the left, rear quarter door frame of the vehicle, the door frame and the roof.
And what, if anything, did that indicate to you was the direction of the bullet struck?
If you had built, the bullet was traveling from, you stand in the driveway from left to right going up. There was no defects to that same vehicle on the passenger side of the vehicle. The damage was to the driver's side of the vehicle. Also, it correlates to where the victim was standing as he took a shot to the left side. So,
Did you reach a conclusion about just the general area where the shooters were standing when they were shooting and where the shots were?
yes, the shooters were staying here, Ms. Jarvis and here. When we continue, when they walk out the driveway.
Yes. Well, let's just focus on this part right now, on where the shots were.
So there were shell casings collected here in the driveway and back up here near the front, going toward the door, the walkway leading to the front door. So they were shooting from this area back down this way.
Did you or anyone else ever determine that there was damage going in the other direction? Any indication of projectiles being fired down this hill and down toward the defendants?
No, there was no defects in any buildings to the right side of this, to the right side. Everything was going from left to right, not right to left.
Let's look at State's Exhibit 24. And can you just orient us up to where State's Exhibit 24 is talking about?
This is the driveway once again, shared split driveway, on 426 and 428. This is the, Mr. Arnold's vehicle, and that's Mr. Arnold's name. On his back.
Let's look at 25, please. And if you'll look at 25 and see if you can determine where the Chevrolet was.
The Chevrolet is going to be right on this side of the street here. In this area right here.
Okay, very good, thank you. Let's go back, all the way back to, I think it was 170. While that's coming up, the day that you went out there, had the Chevrolet been moved?
No, sir, it was still there.
I mean, like several days later when you went?
Yes, yes.
Okay, let's look at 182. Is that the location of the Chevrolet at the time that you went?
Yes, sir.
And were you out there speaking with Miss Neal that day?
Yes, sir.
And did you walk over and take photographs of this particular Chevrolet?
Yes, sir.
Let's look at 183 and 184. And can you just point generally where this bullet defect is?
The bullet defect is right here, in the quarter frame of the vehicle, door, and then the roof.
Back at the time that the shooting occurred, this car was placed on Oxford Court.
Yes, sir.
Pattern that you described.
Yes, sir.
And was the location of that bullet defect consistent with its location as it was described to you and shown in the photograph? Is this bullet defect, does that make sense?
Yes, sir.
Let's look at 185. What's 185?
That's a close-up of the defect of the bullet penetrating the vehicle.
186.
Once again, just another close-up view of the defect to the vehicle.
187.
And that's the overall side view of the vehicle.
188.
the front end showing that there was no defects caused by rounds, bullets penetrating the front end of the vehicle.
189.
And that would be the passenger side of the vehicle showing that there's no bullet defects to the side of the vehicle.
There's some kind of markings down here. Can you tell the jury what, if anything, that is, and whether it relates to this case?
Does not relate to the case. It was from a prior accident.
Like a traffic accident?
Yes, sir.
Did you have the opportunity to interview Mr. Parks?
Yes, sir.
Can you tell the jury how that interview came about?
That interview came about based on the arrest warrants for the murder of Mr. Arnold, which was executed by the Atlanta Police Fugitive Unit, along with the U.S. Marshals Southeast Regional Apprehension Task Force.
Can you explain why you took the arrest warrant out against Mr. Parks?
Based on the video surveillance, the identification by both Mr. Harris and Ms. Neal, I went ahead and initiated the arrest warrants and apprehension packages for Mr. Parks and Mr. Phillips.
Phillips as well.
Yes, sir.
Before I get too far ahead, let's talk about the other part of this neighborhood. We've got a crime scene down here near 4226. Can you talk about the other crime scene that was up the hill?
Yes, sir. There were shell casings, a group of shell casings located here on Nine Hill Drive, going to the left. And there was also shell casings in front of 4215 and 4219. That's also correlates with the video surveillance that we received, showing that the three individuals fled from this location, fled from 4226 to 4228 driveway. They was running up this way. They started shooting into 4215. As they got in front, one of the subjects yelled out, "Cover your face." They got cameras. They continued to shoot as they ran around the corner, shooting back at 4215 and hitting both 4215 and 4219.
Right, and if there's ballistic evidence that indicates that it's a different address, then did you go with that list?
Yes, sir.
Okay. There are photographs that show the placement of cartridge casings. Would you rely on those photographs rather than your memory?
Yes, sir.
All right. Now, when did you speak to, what's your understanding of what these individuals did after they shot at 4250?
Objection, Your Honor. Cause for hearsay.
So I guess you would need to lay a foundation for what he's about to answer, and then we'll know hearsay, not hearsay.
Did you see a vehicle on video, Lee?
Yes, I did, sir.
What kind of vehicle was it?
It was a red Mustang.
Did you form an impression or did you determine who was in that red Mustang?
Yes, sir.
Can you tell the jury that you're?
Based on my interview with Mr. Parks, he stated that himself, Wall, and G, Mr. Phillips, and G was inside that vehicle. Mr. Phillips was driving the vehicle as they fled the location. As they came out to the top of the hill, they made a right turn onto the county line, and left it in the other direction.
Do you remember seeing other video of other cars leaving about this time?
Yes, sir. I believe it was another four-door, like white or silver sedan and a white minivan.
Did the minivan have anything to do with this case?
No, sir.
And the other sedan, did that have anything to do with this case in terms of the shooting?
No, sir.
Let's then play the interview. Stay.
All right, before you do that, how long is it? Or at least the part you're going to play.
30 minutes.
Okay. So two things, ladies and gentlemen. One, There are a few parts of the interview that have been redacted, so it may play in a choppy way. Nothing suspicious about that. There are parts that I've said not relevant to this case, so I don't know if you'll see mouths moving, but you can't hear, or if it's going to jump, and so someone's hand will be here, and then their hand is suddenly there. That is all consistent with my directions. But two, we've been going for a little while. It's 11. Do you all want a break before we press play on the video? No? Yes? Okay. Yes is the answer from powerful voices. So we're going to take a morning break. We'll try to keep it about 10 minutes. And then we'll get back and pick up where we left off. Please don't discuss the case. No outside research. About 30 minutes is the video, give or take?
Maybe 35. I might be wrong.
But it's not 2 hours.
No, you're wrong.
Okay, so we'll fit it in definitely before lunch. Do you have much else with Detective Thorpe after the interview?
No, you're wrong.
Okay, all right. Mr. Monetis, anything before we break?
No, you're wrong.
Mr. Rowe? All right, Detective, we'll get you back in here in a few minutes. Thank you.
Yes, sir.
All right, we're back on the record in State versus Parks and Phillips. Can we get Detective Thorp back in here, please? Mr. Griner, anything before you resume your examination?
No, Your Honor.
Have you tested the audio of this interview, or we're hoping we'll be able to hear it?
Good idea. Good idea.
All right, while you're doing that, anything, Mr. Monetis, from Mr. Phillips' side?
No, Your Honor. Thank you.
Mr. Rowe?
Oh, yes.
Okay.
We're going to record our conversation. Yes, sir. If we're going to have one. Yes, sir. So, answer a question, that's my charge.
Judge, I don't know if we can, I don't think we can manipulate the volume from where we are.
So the way it has worked in the past is the person who's sharing the video checks the little box in the corner that says share audio and video when you're doing share screen. So if you click on share screen, that has these little boxes in the lower corner.
Yeah, second. Okay. Didn't get a chance to introduce myself to you.
And that has historically been enough. And then your audio volume is what controls. So in that share screen before you're sharing, there are a couple of boxes to check in that.
I can tell you, hold on for a minute. Please come back to me. My gun was decop, bro. I swear to God. Where's your gun at now? It's gone. I don't know. How did you leave the neighborhood? In the car. What kind of car? Thinking.
They're gonna have trouble hearing that if that's as loud as it gets.
If we plug our speaker in this device, I don't know if that's gonna be helpful because there's a reverberation.
Right, that could be awful.
Like that.
Right. Well, you need to figure it out because we need to move forward.
Can we have 3 minutes, Your Honor?
Okay. Clock started. Sounds like we're in some old laboratory.
Does Your Honor ever plug this into is this considered the main terminal here, the main outlet?
Yes, but people generally don't mess with that.
Okay.
So within 5 minutes, you change your pants just like that.
Yeah, cause I already took a shower and everything. I went to my mama's house. This is exactly what I said. I said, come on, y'all, boy. My pants not matching my outfit. We finna go to my mama's house. We walking by. We see these niggas. We looking at them. He looked me dead in my eye.
Which one? Who looked you dead in your
The
eye?
nigga cat.
Some interference or something. Is it?
This one.
So we need to keep moving along. Do you have other things you can explore with Detective Thorp? You want to bring him back at another time to play this? I'm not going to keep the jury waiting anymore.
Yes, Your Honor, we could just, I do have a second speaker. It's not real strong. We could try that. And I could do a couple of questions with Detective Thorp, but I'd like to be able to come back to direct if my colleagues want to cross-examine. I know that's not normally how we would do it, but I'd like to be able to at least have this play into evidence.
Okay, you need to figure out how to, I mean, we've been in trial for a bunch of days now, and it surprises me that no one took the step to make sure it would be audible before you were ready to press play. I'm not going to make the jury wait anymore on that. Maybe on redirect, you'll put that in if there's not an objection and I let it in, but, or you, like I said, could recall Detective Thorp at another time when you figured out how to make this audible. But we're now at almost 11:30 and we've covered very little ground this morning and we're falling behind. So I'm going to bring a jury in. You figure out how you want to navigate with Detective Thorp, and we'll go from there.
We will continue working on this. If I am able to recall Detective Thorp after another witness if needed, then I may just need to do that.
I will overrule any objection there too. You could call witness 3 different times if you need to, and this isn't newly discovered evidence. It's newly discovered technical limitations.
Thank you.
Okay, Mr. Menettis, anything before we bring the jury in?
No, Judge, I just lost track. Is it gonna be me or Mr. Rowe that does the cross first?
Depends what I ask. Mr. Rowe, anything before we bring the jury in? Okay, all right.
He had 2 guns in his hand.
So he was standing on his porch looking at you?
Yeah, he was standing on his porch. They had the U-Haul truck out there in their front yard. All type of stuff. He walked right past. He just.
We'll just try it.
If you all have a preference as to the order in which you go, you can let me know. You all have been silent, so I've sort of gone with just mixing it up so the jurors are on their toes, but it's always up to you. Thank you, Deputy Gordon. Welcome back, ladies and gentlemen. Detective Thorp is still on the stand. And we'll see what happens with the video. My guess is you'll get to see it at some point, but the state is trying to figure out how to make it audible. So with that, you remain under oath, Detective Thorp? Under oath, Detective Thorp?
Yes, sir. Okay, let's talk for a minute about how you conduct a formal interview. Can you tell the jury what you do in a formal interview?
Yes, in a formal interview, it is generally either video or audio taped and recorded.
If somebody is in custody or considered detained, do you read Miranda rights?
Yes, I do.
Can you explain what Miranda rights are?
Miranda rights is your rights given, whether you want to continue a conversation with law enforcement, with or without your attorney present.
And we see in TV and movies sometimes when somebody's arrested and they're immediately read their Miranda rights.
Correct.
Is that how it really works?
Yes, sir.
So I'm not talking about, okay, on the scene of the arrest versus when you sit down with somebody to do an interview. When is the appropriate time?
We usually, Miranda is read when they're under arrest or, and you have charges on them. Or during the middle of the interview, they pretty much start confessing to their participation in a crime. And that's where you pause them and advise them of their Miranda rights.
Sort of in addition to that, when you are interviewing an individual, do you take into consideration whether someone might be intoxicated?
Yes, sir.
Take into consideration whether somebody might have a lower IQ or be disadvantaged in some way like that?
Yes, sir.
Did you have either of those concerns with your interview with Mr. Parks?
No, sir.
Did he seem to be lucid and able to talk?
Yes, sir.
All right, so let's see if we can play it now, and then if we can't get it to go now, then we'll come back.
Yes, sir.
So, sort of at the outset, is this an interview room?
Yes, sir.
And is Mr. Parks detained?
Yes, sir.
I can ask you one question. I'm going to jail today.
Yeah. We're going to record our conversation.
Yes, sir. Yes, sir.
If we're going to have one.
Yes, sir. So I can ask you a question. What's my charge?
Yeah, in a second. Okay. Didn't get a chance to introduce myself to you outside. My name is Detective Jacob Jr.
Yes, sir.
Are you not able to hear it? Okay, me neither. Didn't work.
All right, we'll work on that. So, Your Honor, I'm going to just, that's going to be all the questions that I have at this time for this witness.
Okay, you may recall Detective Thorpe if your tech team can get the audio to an audible level.
Absolutely. Thank
Got
you.
it. Mr. Rowe, do you have questions for Detective Thorpe?
Yes, Judge, thank you.
Detective Thorpe, obviously you were the detective that conducted the interview of Mr. Parks, correct?
Yes. Good morning, sir. Yes, I was.
Okay. Was there anyone else that interviewed Mr. Parks? Other than
No,
yourself?
No, sir.
Okay. And during the course of the interview, when Mr. Parks indicated that the victim was already dead when he came out the house, you indicated it didn't matter.
Yes, sir.
You did?
Okay. Okay, what was that question again, sir?
Okay. During the course of the interview, Mr. Parks said that the victim was already dead when he came out the house, and your response was that it didn't matter.
Yes, sir.
Okay, why? Why did you say that?
Because I'm telling you, because he was actually standing on the porch or near the front door at the time of the shooting. And I was basically trying to get through to him that it does not matter. You were always out there shooting.
Okay. All right. Now, you also interviewed Miss Ananda Neal, which is the girlfriend of the victim, correct?
Yes, sir.
Okay. And according to your report, you indicated that Miss Neal indicated that Hot and Woe was the target of the shooting.
Yes, sir.
Which she also indicated that there were 3 initial shots that came from somewhere else, correct?
Yes, sir.
And she indicated that the initial shots came from the heel or something to that effect.
Yes, sir. And I think she was basing that on what she was hearing from Ms. Henderson.
Okay.
Objection, Your Honor.
Objection, Judge. I'm sorry.
I mean, let's take them one at a time. What's your objection?
Might be the same as Mr. Rose, just speculation, hearsay.
Yeah, it calls for speculation, Judge. He went further than what my question asked.
So you asked a question that wasn't objected to, that may have involved hearsay, and then he responded, providing context.
Judge, he was responding based on what he thought that she thought. So I don't think that was a proper answer. He can't testify as to what he thought, what she thought.
Okay, so Detective Thorpe, you should confine yourself to, I guess, what people told you. If a lawyer asks you, well, what do you think was going on in that person's head, then you can go there.
If I recall correctly, Your Honor, that's what she stated to us the next day
So you were given the full context. This lawyer asked you, what did Ms. Neal say? And you were given the full context of what she said.
Yes, sir.
Okay, well, what was the full context of what she said?
She said that she was getting information from Mr. Park's mother.
And that's Ms. Henderson.
Yes.
Okay, so objections are overruled. Next question.
Thank you, Judge. But she did specifically say as to what she witnessed that there were 3 shots that came from the area, correct?
Okay. Once again, she was saying what she was told by Miss Henderson. So I never understood that she was saying that's what she heard or that's what she knew. She was saying the shots came and that what Miss Henderson was telling me.
Okay, was she there?
Who?
Ms. Neal?
Yes.
Okay. And so she did tell you what she personally observed, correct?
Right. But she was saying what she was hearing as opposed to what she was really saw on the scene.
Objection, Your Honor, speculation. He just said what?
No, he's now overruled. He's explained the source of Ms. Neal's information as Ms. Neal related to him. So you should move on.
Okay, but she did indicate that Roll and Hop was the target.
Yes, because she said the majority, that's will always get into trouble over there.
Objection, Your Honor.
Your objection is?
For me.
So the question was asked and it was responsive to the question. Overruled. Next question.
Okay. So based on, you also interviewed 2 other witnesses, Lakira Dixon, correct?
Yeah, I would call yes.
And you also interviewed Shawanda Blakely, correct?
Yes.
And they also said there were 3 shots that came from another direction, correct?
I don't recall them saying that.
Okay. And the shooting happened at the house right next to Mr. Parks, where he resided, correct?
What you mean, the shooting? Where the shots was fired?
The actual crime scene, the actual place where the victim was shot was the house right next to Mr. Parks' residence.
Yes, would be Mr. Arnold because he died in his driveway,
Right.
but the shell casings was also in 4228 driveway also.
Okay.
So that whole area right there was the crime scene.
Okay, so give me the 2 addresses of the crime scene.
Okay, 4226
Right,
is where Mr. Arnold's body was.
right.
4228, 4215, and 4217.
Okay, let's talk about 4228. Is that the residence of Mr. Parks?
Yes, it is.
And 4226 is the residence of the victim, Mr. Arnold?
Yes, sir. Yes, sir.
And you also determined in your investigation that there were children outside during the shooting, correct?
Yes, sir.
And those children were related to Mr. Parks, correct?
Yes, sir.
So, your testimony is that, Mr. Parks began to shoot at his own residence. Is that your testimony?
No, sir, he was shooting at his own residence.
Okay. Where was he when he was shooting?
He was standing in his residence, but he was shooting away from his residence. Your question is, he was shooting at his residence.
Isn't it true your investigation revealed that he was returning fire?
No,
And you interviewed Ms. Dixon, and your testimony now is that she didn't tell you he was returning fire.
I don't recall her saying that.
And you interviewed Ms. Blakely, and she did not indicate to you he was returning fire.
No,
And you interviewed Ms. Neal, and she did not indicate he was returning.
correct.
That's your testimony.
Yes, sir.
You made a report of this incident, correct?
Yes, sir.
And when you make a report, you're obligated to tell what's true based on your investigation, correct?
Yes, sir.
In fact, I believe you did a supplemental investigative report as well, correct?
Perhaps I did. Can you show me
Okay.
the documents?
You would agree with me that you interviewed several witnesses in this case, correct?
Yes, but I don't recall the Miss Blakely or Miss Lively.
Okay,
Was it me or another detective?
okay. But you did personally interview Ms. Neal.
Yes, sir.
Okay. Did you personally interview Ms. Dixon?
I don't recall interviewing a Miss Dixon.
Okay. You agree with me that even Ms. Neal indicated that Mr. Parks was coming out the house?
Yes, she said he was standing in the doorway. Yes,
Okay. And in fact, you would agree with me when the first shot was shot that Mr. Parks was at that point coming out?
you can't really see that well into the video,
Okay.
but you can see you can hear the shots start coming. And that's when someone says, think he's dead or he's dead to that degree.
Okay. All right. Thank you. Thank you. All right. I'm gonna show you. I can keep it marked. Yes, mark.
Hold on. So when you're talking, it's hard for Ms. Rivers to do stuff. So if you don't have stickers, let's just get you some now and then. Hold on one sec. So why don't you write Parks on that as well? Because defense one will be confusing. So that should be Parks one.
So I'm showing you what's marked. Defense Parks Exhibit number 1.
Yes, sir.
Do you recognize that document?
Yes, by Detective Churchill.
Oh, that's your.
Right. So I did not interview
Okay.
her.
Okay. Did you share investigative results with Detective Churchill?
Yes,
Okay. And were y'all co-lead detectives on this
No, sir.
investigation?
no, sir.
Okay, so he never shared with you any of his notes or reports that he generated from his interviews with various witnesses?
Yes, sir. That's why you have that possession right there.
Okay. And this is in fact, to the best of your knowledge, Detective Churchill's report?
Right. Detective Churchill had testified to that degree. Yes, sir.
And this, based on your knowledge of investigation, is this an accurate depiction of this page of this report?
we type our stuff differently, but that could, yeah, that's him because I see his name at the bottom.
Okay.
Yes.
All right. Judge, I'd like to introduce this. This is exhibit 1, Parks.
Mr. Griner, any objection to the admission of Parks number 1?
I think the testimony is that that's Detective Churchill's report. And although this witness might know some of the information on it, I think that Detective Churchill will be the better witness to enter his own report in. And, the defense can call Detective Churchill.
Okay. Mr. Monetis, any objection to the admission of Parks 1?
No objection, Your Honor. He's the lead investigator. He shared with us. He's familiar with.
So there's no objection.
No, Your Honor.
Got it. So what I'm going to do is make it part of the record. It's not publishable. It's probably not going out with the jury. It's probably all hearsay, but let's make it part of the record so it's preserved.
Okay. Thank you, Judge. Okay. All right. So, who were the actual witnesses that you interviewed?
Mr. Harris, Miss Neal, and that was about it.
Okay. Can I approach to refresh your memory as to what information you received from Detective Churchill?
Yes, sir.
Report?
Yes, sir.
You just look up after you refresh.
Okay. Yes, sir.
Okay. Have you been refreshed?
Yes, sir.
Okay. All right. So based on your investigation regarding Ms. Blakely, did she in fact indicate that there was a initial shooters prior to these 3 young men?
Based on that,
Stop, don't answer. Yes?
I'm not sure if the question's been asked about this witness and whether he interviewed Ms. Blake.
I'm not going to remind you what his testimony was, but now, did you hear what Mr. Rowe's question was? The one you just objected. What's the basis of your objection?
I'm not sure that this witness has had his recollection refreshed. And so I'm objecting. I thought the witness said that he had interviewed Ms. Neal and Mr. Harris. And I don't know that he indicated that he interviewed Ms. Blake.
So assume that he has not interviewed Ms. Blakeney. Mr. Rowe is asking this witness a question about a report Churchill wrote about something Blakeney may have told her.
Okay, well, it's hearsay.
Sustained.
All right. So you indicated that that there was a gentleman that had 2 guns that came out and went into the white car, correct?
right. He removed the 2 pistols from his vehicle when he saw the 3 young men, 4 subjects coming around the corner. He stood with them in his door frame, not pointing at anyone, at his side, and he's looking at them as they walk by. And that was it. He told Mr. Harris, see you later, bye to that degree, got into the car with his girlfriend, his sister, whoever she may have been, and they drove off.
Okay. Is this something that you gathered from the witnesses you interviewed, or is this something you watched on surveillance tape?
Watched on surveillance tapes and listened.
Okay. And did you watch all this? Obviously, you watched all the surveillance tapes, correct?
Yes, sir.
And that same young man had 2 guns as he walked out, correct?
Yes, sir. Put him inside his car.
And he said some words when he walked out with those 2 guns.
Yes, he said something like, I'm not sure what you're getting into.
What did he say?
I guess he said, I'm not sure what you're getting into, but I'm getting ready to go. And he just left.
Okay. He didn't say, I'm gonna get these motherfuckers.
I don't recall
Okay.
that.
And did you have the opportunity to discover who this gentleman was with the two guns that walked out?
Yes, sir. I asked Mr. Harris to have that subject call me,
Okay,
and the subject never got in contact with me.
okay, all right. So this individual walks out with two guns, correct?
Yes, sir.
Okay, and he drives off
Yes, sir.
shortly thereafter they're shooting.
Yes.
They're shooting, correct?
Yes, sir.
Okay, all right. And you never identified who this person was?
No, sir.
So therefore you never ordered a gun residue test on this gentleman, correct?
Correct.
All right. And the children that was outside at 4228, they were related to Mr. Parks?
Yes, sir.
All right.
From my understanding.
I'm sorry?
So from my understanding.
Okay. And you testified that there were prior shootings at 4226, 4228, and 4215.
Prior shootings? No, people just told us prior incidents.
So these prior incidents were not prior shootings?
Not to my recollection that there were shootings at those.
Okay, so Mr. Harris did not indicate to you that his house was shot up before?
I believe he said there was a shooting, but his house was not shot up, I believe.
Ms. Stallworth never indicated that her house was shot up prior?
Not to my recollection, no, sir.
Would anything have changed your investigation if you had discovered that there were prior shootings at all of these houses?
No, it just once again confirmed that it was an incident, ongoing incident between the two separate locations.
Okay, and the ongoing incidents was based on what type of ongoing incident?
The residents who didn't want to get fully involved stated had dealing with two kids, maybe 6 or 8, got into an altercation at the swings or the playground, and the adults took it to another level, and this just been going on and on and on, beef between those two residents because of that.
Okay. Did Ms. Harris indicate to you about 2 males prior to this incident coming to his house with guns, shooting up his house?
He may indicate that to Detective Fall or Detective Barber, but he never indicated that towards me. He just said it was an ongoing beef between them.
You testified, actually on cross indirect, that Ms. Neal was pushed to the ground when the shooting first began.
I never indicated she was pushed to the ground. See?
Did she ever indicate to you she was pushed to the ground?
Oh, she said he told her to get inside the house. Mr. Arnold told her to get inside the house.
You just testified a few minutes ago that you said that she may not have been aware of everything that was going on during the time of the shooting.
Yes, sir, because she went back inside the house.
Okay. Do you know at what point she went back inside the house?
She said at some point, Mr. Arnold indicated to her like something about to go down, get inside the house. And at that moment, as I believe she was entering the house, that's when the shots went off. And when she realized Mr. Arnold was not inside the house with her, that's when she went outside and discovered him laying flat on his back behind the vehicle in the driveway.
Okay, let me just stop right there. Just back up for a second.
Yes, sir.
You said that she went inside the house and then the shots came.
Right. She said she made it to the doorway, was inside. That's when the shots went off, and she realized Mr. Arnold was not behind her.
So she was not outside when Mr. Arnold struck.
No, sir.
So she didn't realize Mr. Arnold actually struck her with a bullet until she came back outside the house after the shooting, correct?
Correct.
So she did not see who shot Mr. Arnold, correct?
Correct.
And when you determined the bullet on the vehicle that was beside Mr. Arnold, You said it was on the left side of the driver's side.
Yes, sir. Driver's rear.
Were you able to, you could not positively identify when that bullet was actually struck the car, correct?
By looking at it, you can tell it was fresh because there was no rust or condensation built up around the defect itself.
But this also came from the prior shootings, that there were prior shootings of the house or in that area, correct?
Okay. Once again, there was no rust or indication that that was an old defect to that vehicle.
Nor did you go to any other location to try to collect any shell casings? Then the 4226 and 4228?
In the driveway of 4226 and 4228, which is a shared split driveway, there were shell casings at the bottom of the driveway and shell casings near the front walkway into 4228 Notting Hill.
Did your investigation determine a motive as to why Mr. Parks would shoot at his location with children outside?
That's something you have to ask your client, sir.
And your investigation did not determine any type of issues between Mr. Arnold or Mr. Parks, correct?
No, sir. Just straight round.
All right, no further questions.
Mr. Monetis?
Yes, thank you. Now, there were some questions about Mr. Phillips's phone being found at the scene, correct?
Yes, sir. Good morning. Good morning. Good morning.
Oh, good morning. I'm sorry. Yeah. Good morning to you as well. Thank you.
Okay.
Again, my question is, there was some questioning about Mr. Phillips's phone being found at the scene, correct?
Yes, sir.
Okay, and in fact, on the video where we see him come out of the house right before the shooting starts, we can see that presumably he's on his phone. He's got his hands like this.
Yes, sir.
Okay. And you mentioned it actually multiple times in your reports that it's believed that it's Mr. Phillips's phone that's found on the scene, correct?
Yes, sir.
Okay, and not only that, but in the warrant affidavit, you also mentioned that it's your conclusion that Mr. Phillips's phone is found on the scene.
Yes, sir.
Okay, and a warrant affidavit is important because that's how you tell the judge what you think happened so that you can get a warrant.
Yes, sir.
Okay. Now, I want to go, I have other questions for you, but I'm going to first just go through some of the questions you just answered and ask a few follow-up questions. Now, you testified that at the very beginning, you developed the names of two possible suspects, correct? Possible suspects.
Yes, sir.
And those were Hot and Woe.
Yes, sir.
And presumably Hot refers to Mr. Parks.
Yes, sir.
And presumably Woe refers to Mr. Phillips.
Yes, sir.
Okay. You didn't have anyone who goes by G as a possible suspect.
Yes, sir.
Okay. You didn't have anyone that goes by Sam as a possible suspect.
No, sir.
Okay. And you also testified that you came to the scene about an hour after the shooting, correct?
Yes, sir.
So you have no personal knowledge about what happened in that hour as far as the crime scene or the witnesses.
No, sir. Just the briefing.
Right. And that's because you weren't there.
What's that, sir?
That's because you weren't there.
Right, because I was not there. They was briefing me. Because I was the on-call homicide response detective, which means that my shift is from 7 A to 5 P. So I was already a quarter way home when I received the call. So I had to turn around and come back into the city. So
Right.
that's why it took me an hour to get there.
I understand that. I'm not
Okay.
asking you why. I'm just confirming that your answers to the questions so far are based on you arriving at the scene an hour afterwards.
Correct.
Okay. And you mentioned there were some people that didn't want to get involved.
Yes, sir.
And by that, I assume you meant they didn't want to tell you about what happened or whether they have videos or not, stuff like that.
That and they did not want to give out their names or contact information.
Okay. And that's not abnormal, right? As a detective, a lot of times people are afraid to talk to you.
Yes, sir.
And not because they've done anything wrong, but because.
Retaliatory. Yes, retaliatory issues.
Right. So
Yes,
there's
sir.
innocent people that don't want to share things with you.
Yes, sir.
Innocent people that don't want to share videos from their homes with you.
Correct.
Okay. And it could also be possible, in your experience as a detective, that people don't want to get involved with you because they have some connection to someone that's done something wrong.
Yes,
Right, okay. Could be that people that didn't want to get involved with you has some kind of connection to the person known as G, correct?
could be,
Right, the person that's on video shooting but not on trial here.
could be. Yes, sir.
Could also be that those people that didn't want to talk to you or get involved have some connection to this person known as Sam, the guy with the 2 guns.
Could be.
Okay, and you're aware that Sam was known by Javante about a month earlier and that he had just gotten out of jail.
Could be.
Oh, could be. So that wasn't part of your investigation.
Yes, sir.
Okay. You testified that when you got there an hour later, you testified that you walked around the crime scene yourself, correct?
Yes, sir.
And that's when you saw police placing down markers, correct?
Not police, crime scene.
I'm sorry about that. You saw crime scene professionals placing markers.
Right, sir, along with a homicide detective.
You're right. You use the word placing, correct? The ing at the end,
Yes, sir, placing.
not had placed, correct?
Right, placing, yes, sir.
So they're in the process of placing them when you arrive an hour later.
Correct.
And it's those markers that you rely on for your investigation to speculate about where those casings were after they were shot,
Correct.
after ejected out of a gun.
Correct.
And you're not an expert in the properties of guns or shell casings to make expert testimony about how far a casing might come out of a gun.
Expert, no, I wouldn't say I'm an expert, but I've been dealing with weapons from military to the police department for 36, 38 years.
Right. And so you know that all weapons are different, correct?
Correct.
And they have different properties.
Correct.
And there are no weapons seized in this case to analyze or,
Correct.
your expertise on. Okay.
Correct.
Now, Mr. Phillips's phone, we already said being dropped at the scene is significant to you. It's significant to you because it's your way to place Mr. Phillips at the scene, correct?
Yes, sir. Sorry about that.
As part of your investigation or anyone else's that you know of, it doesn't have any other significance apart from it, correct?
Okay, say that again, sir.
Apart from placing Mr. Phillips at the scene, the fact that his phone was dropped there didn't play any other role in your investigation, correct?
Yes, sir. Possible identification of G or hot.
Okay.
Okay.
And nothing beyond that.
Nothing beyond that.
Okay, so it never crossed your mind that when we see him on the video come out of the door and we hear shots go off, that he's filming or attempting to film using his phone. That never crossed your mind, correct?
It did.
Okay, and you were never able to exclude that possibility, correct?
No, sir.
And you don't mention that possibility anywhere in your reports, correct?
No, sir.
Okay, and the reason we have reports is so that they can refresh your memory like had just been done earlier?
Yes, sir.
Okay, and you're sure to include all important information in the report because of that, right?
Yes, sir.
Because it's relied on others,
Yes, sir.
and it's relied on by yourself,
Yes, sir.
and it's relied on by other criminal justice professionals, correct?
Yes, sir.
Okay. Now, you testified about initially thinking that it was Javante that had the 2 guns.
At the time of the shooting, or
We ask a different question. You investigate Javante and you test his hands for gunshot residue
yes, sir.
to find out whether or not he's ever shot you.
Not whether he ever shot a gun. He shot a gun at that moment.
That moment or shortly before.
Yes, sir.
And even, you know, that gunshot residue can get on your hand just from touching a gun, correct?
Yeah, but sometimes it's most likely from from my experience. If the gun has not been fired, then you will not have gunshot residue on your hand. Unless the weapon is discharged, that's when you get gunshot residue on your hands.
Right. And gunshot residue is transferable, correct?
Correct.
It doesn't degrade or go away, it moves around.
As far as my knowledge is, yeah, correct.
So if a gun was fired, there presumably could be gunshot residue on the gun, correct?
So let's focus this witness on his area of expertise. We had our gunshot residue person. You
Understood,
had a
John.
chance to cross-examine that
Of
person.
course, Judge. The point is, Javante Harris does not test positive for gunshot residue on his hands, correct?
Correct.
And the reason you tested him for gunshot residue is because you thought he might be someone who you got reports about who had 2 guns in his hands.
Correct.
And now it turns out that Sam, you believe, is the one that had 2 guns in his hands.
No, that Sam had 2 guns in his hand based on the video.
Right.
Mr. Harris had 2 guns in his hands because he came outside his house to see who was shooting into his house.
Okay.
So, yes.
Understood. And it's not a huge amount of bullets that go into Mr. Harris's house, right? It's how many?
I cannot recall. I think it was somewhere in the neighborhood of 10, maybe, I believe.
Okay, so 10 or less.
Yes, sir.
Okay. And when you initially suspect Javante of something and then do investigation and it turns out not to be true, did it cross your mind that that same thing might have happened when you suspect Mr. Phillips of doing something?
Based on what would not make me think Mr. Phillips had nothing to do with anything, when the video is clearly showing that he's discharging his firearm. So this is not, that's a witness testimony. This is video that I'm looking at, seeing Mr. Phillips discharge his firearm, get close to the house, discharge his firearm some more, and then flee the location. So,
So that's what you're telling us that the video will show.
yes,
And you're aware that the video has been already admitted from the jury to see?
yes.
Okay. And the video does not clearly show Mr. Phillips shooting in the driveway.
So you don't testify. If you've got questions, ask questions, but your opinion of what the video show isn't what this jury needs to hear.
Right, I'll ask him a question. It's your opinion that Mr. Phillips is clearly shown, use the word clearly, is clearly shown with a gun in the driveway.
Cannot clearly see, but based on the evidence that there was 3 separate weapons fired at that location, 2 in that driveway, 3 in front of the 4215 and 4217. G, who is in all black, you can see that he was having a malfunction with his weapon until he got to the location of 4215 and 4217. You can clearly see that's when he started shooting. So, do you see him actually shooting in the driveway? Because of the distance, it's kind of pixelated. So, but based on the evidence collected from the crime scene, processed and done, one can surmise that's where the shooting started and the shooting continued.
So that's what you're basing it off of. You can't clearly see him with a gun because it's pixelated, but you decide that because there are casings in the driveway.
In the area that he was standing in the video that you can see.
Okay.
Yes,
And in
sir.
the area where G also runs around, correct?
Yes, sir.
G moves around during the shooting quite a bit.
Yes, sir.
And now, even though you say correctly that we can't see clearly whether Mr. Phillips has a gun, you want us to believe that we can clearly see that G's gun is jammed.
Yes, based on the evidence of the shell casings collected at both 4226 and 4228. My recollection is correct. Those are 2 separate shell casings at that driveway, and there was 3 in front of 4215 and 4217.
Let me ask you this then. So it's the casings that are deciding this. We can't clearly see Mr. Phillips shooting a gun in the driveway, but we can see that G has a gun in his hand in the driveway. That's why you're testifying that it jammed, correct?
Okay, you can see all 3 in the driveway motioning towards that direction. Once again, one can only surmise looking at it based on their own visualization of it, that those 3 individuals are the ones that are shooting.
Okay, but it's not true. We don't see Mr. Phillips' arm.
So your things being true, not true, please don't testify, comment on the evidence, questions, not, you can argue closing, I know you will, save it till then.
We see Mr. Phillips on that video with his left hand straight up like this, correct?
I believe so, yes.
Towards an elevated hill, right? There's a little elevation towards that area.
Mhm.
Okay. And we cannot see clearly because it's pixelated whether or not that's a phone or a gun in his hand, correct?
Is that a question or a statement? We cannot see.
And not clearly see because of the pixelation that you shared with us,
Okay,
whether or not when Mr. Phillips's hand is up like this, his left hand whether or not there is a phone or a gun in his hand, because we cannot clearly see that there's a gun in his hand. Correct?
Correct.
Okay, thank you. And we can clearly see G with a gun in his hand in the all black, correct?
So we've covered this now several times.
Okay. And it's your testimony because of casings that G's gun must have jammed.
Correct.
And you don't have any other evidence to believe that except for what you've testified to already, correct?
The video, the shell casings, you can see G running up to the place, trying to get his weapon to work. When he finally realized he got it to work, he lays off his few rounds, run around the corner, they jump in the Mustang and they leave. But you can clearly see as he's coming down the driveway, they're shooting. Mr. Parks, Mr. Phillips are clearly shooting as they're coming out of the driveway at 4215 and 4217. And you see G lagging behind because he's trying to figure out how to get his weapon to fire. The shell casings were analyzed and shown that it was fired from 3 different weapons.
That's your opinion, your conclusion. You didn't explore any other conclusions besides that, correct?
Okay, now my opinion, based on the evidence we collected.
Right, and your investigative experience based on the evidence.
Correct.
And you're aware that us and the jury have the video.
Yes, sir.
Okay. Now, you testified that there are police cameras in the area, but that they weren't working.
Correct.
Had they been working, those flock cameras could have captured a license plate of any cars committed.
We didn't have flock at that location at that time. There would have been the license plate readers and the VIC cameras. Yes, sir.
But similar concept is reading.
Yes. Yes.
Without any officer having to be there, it's being done automatically. By
Correct.
Now, I want to go back to this right here. The exhibit that it shows.
Mm-hmm.
The monster images.
Yes, sir.
Now, you talk about your theory is all about that there's some conflict between these 2 residences, correct?
Yes, sir.
Okay, but it's also an area that has quite a bit of shootings, correct?
Yes, sir.
Okay, and so it's certainly possible that the shooting that happened in this case initially had nothing to do with this conflict, correct?
Can you say that again, sir?
Isn't it possible that the shooting that happened in this case, when Miss Neal hears those 3 shots come to the driveway first, isn't it possible that those shots came for some other reason besides this conflict?
My investigation did not show that.
Right, because you didn't even look for that or investigate that, correct?
I mean, we would have got 911 calls. When we plug in, 911 can show if there was ever a 911 call about shots being fired in the area. There was no calls during that time frame of shots being fired in the area. The calls we received was the 911 emergency call of a person lying shot in the driveway of 4226 Nighting Hill.
Miss O'Neill shared with you that 3 shots came from this area, from this direction, before Pop fired back. Is that correct?
Right, and once again, that was based on her hearing it from Miss Henderson.
Okay, but you don't have any reason to think that Miss O'Neill would come in a trial and lie, correct?
No, not to my knowledge, no.
Okay. And so you testified about, oh, we don't have 911 calls otherwise, but we also just shared that sometimes people are reluctant to share things with law enforcement, even when they have no involvement, correct?
Sometimes, but people will call 911 just to get that out there, and they're done with it after that.
Okay, and sometimes they won't,
Correct?
because they're either afraid
Yes, sir.
or they're either trying to protect someone, correct?
Correct.
Okay. We don't know whether or not that happened in this case.
Correct.
Now, this area, there's actually this area where there's this grass and elevated hill, you can see. That's also between this residence and this residence, correct?
Correct.
Goes through it, and we don't have any photographs of this grassy area here, correct?
Correct.
So we don't know whether or not any other shell casings might have been deposited in this area.
Correct, but
Okay,
by walking around, it was determined, that's why we was able to locate the violent approach.
what's up?
That's why the detectives discovered initially shell casings here along the first responding officers. As they started walking around, that's when they noticed the shell casings back towards the front door. in this area here. But then once again, as they walk around the body, they did not discover any other shell casings, so there was no need to photograph anything else in this grassy knoll.
And that's not around the body's right here, next to the driveway.
But when we homicide, we always expand our search out. We go 50, 50, 50, 50. Then we do it again, taking the crime scene, just expanding, just to be sure.
That's what you say, but this grassy area is elevated, correct? It's not part of the driveway. You can't go from the driveway into the area. You have to step up, climb
Once
over.
again, visual inspection, they do not see any shell casings up in this area right here.
And you don't have any report to say that area is inspected, do you?
Okay. Once we're on the scene, and we see that that's not, and we don't see anything of evidential value, we continue to move on.
You do not have anywhere documented.
Can everyone sit back down? Does he need to stay up there, or do you have more questions with that?
I have more questions, Your Honor, but.
No, if you have more, no, may have many more questions. I suspect you do. Do you have more questions involving that exhibit? Because we're doing a lot of back and forth. It's easier if the detective's at the microphone. Do you have more questions about 1A, such that we should keep Detective Thorp up there?
No, Judge, location's been established. My questions are about that same.
Great.
So my question was, that you didn't answer. Yes or no, we do not have any report by you or anyone else to say what you just said, that grassy area elevated was ever searched for gunshots, casings.
No, sir.
Okay, we don't. And of course, if it was, that's something significant, correct?
Yes, sir.
And so you just said earlier that you put significant things in your report, correct?
Correct.
And we have no photographs of that area, correct?
Correct.
So all we're doing is taking your word for it after you all have prepared for trial to say that no casings were there in that grassy area.
And based on what we did the night of, we found shell casings once again in the walkway leading to the doors. Shell casings, a grouping of shell casings in the bottom of the driveway. Once officers and responding detectives get to the scene, we visually inspect. If we determine that nothing on this side is of any evidentiary value, we move on to what we know is, this is where everything happened. So there's no need for me to type in, I used the restroom that day, but I didn't put it into my report. I used the restroom that day. What I indicated was things that we know we could establish right here, right now. So since there was no shell casings or anything of evidentiary value, there's no need for me to type in, we found nothing of evidentiary value, because they decided, hey, we know from this location to this spot right here, this is where the shooting happened, this is where the shooting continued, this is where the shooting ended.
My question wasn't whether or not you went to the bathroom. My question was.
He answered your question. It's not in the report. Your next question is what? And don't mention the bathroom.
You don't have anything besides your testimony today.
You asked that, and he said it's not in the report. Next question.
Those are my questions. Now, I'm gonna raise this, I'll hold it this way so you can see. Now, this is the area of that red Mustang, correct? Right here?
Yes, sir.
Okay.
Based on location, yes, sir.
And same answer to all my questions about shell casings in this grassy area. This grassy area behind the Mustang, towards this way, that was also not photographed or mentioned in your report as being searched for shell casings, correct?
I walked it myself and I did not see any shell casings.
And that's you testifying today, and that's our only way to know whether or not that's true, correct, your testimony?
Yes, sir.
Okay, thank you. Now, you did mention that video of that red Mustang. You talked about seeing Mr. Phillips firing while he's at that red Mustang, correct?
No, not firing when he's at the Mustang. They were shooting, and once they rounded and bent the corner, I thought they thought it was still up. You on my approach?
Sure.
It's all three subjects. It's coming out of this driveway, shooting.
I'm sorry, can you please lift it up on the easel so everyone can see?
Thank you. As they were fleeing the location, they were discharging their firearm, they rounded the corner, still firing. And that's when we got shell cases on this side. That's when you see the red Mustang later coming out. They're coming out so fast, he almost fishtailed and lost control. And he whipped it out and continued the opposite way on our county line.
Right, I'm asking you about the video where we see Mr. Phillips take one shot while asking about that.
Yes,
And that, you've testified earlier, played a role in your investigation.
yes, sir.
And wouldn't you find that hard for this jury to believe you're telling the truth when that video wasn't known to anyone besides the HOA until about a week and a half ago? You
Correct.
see how that makes you hard to believe?
So don't ask a question like that. And if you're done with that board, please take it down.
So keeping in mind all your other answers so far today, isn't it true that that video where he's shooting at the red Mustang wasn't known to law enforcement until about a week and a half ago?
Yes, sir. But it was not long, about a week and a half ago. Yes, sir.
Now you mentioned that you stopped talking to Miss McNeil before you got asked for the rest of your questions because she was, of course, upset and traumatized by what had just happened.
Yes, sir.
She had just seen her intimate partner murdered.
Yes, sir.
Now, we saw a lot of pictures that the state showed you about this view, the view from the driveway supposedly towards the house that you're saying is part of this deal.
4217. Yes, sir.
And isn't it true that all those pictures we saw were taken from beyond that grassy elevated area that we've been talking about?
What you mean? In the driveway? Yes, sir.
Right, so the pictures we have are not from the driveway with that elevated grassy area in between us and this view we've talked so much about. It's from beyond that grassy elevated area towards the view.
Okay. Yes.
Okay. Now, you answered a lot about the Malibu and the photographs. Isn't it true that neither your testimony or the photographs can show the actual position of the Malibu at the time of the shooting? Because your perspective and the photographs were taken after the shooting, correct?
The video surveillance shows the advantage of where the Malibu was parked.
Okay, and there's fresh bullet holes in it.
Yeah, bullet hole. Yes, sir.
Right, again, because this area seems to be incredibly violent or violence.
I'm not understanding your question.
But there's been shootings in this area, correct?
Yes, sir.
Right, okay. And they're not all related to this conflict between the two houses, correct?
Not to my knowledge.
Right. How many doors were on that Mustang?
I believe that was 4.
Okay, not 2?
No, I believe it was 4-door Malibu.
Okay. Okay, those are my questions based on your answers thus far, but I do have some more questions, and if there's any overlap, I'll do my best not to go there. Now, I want to ask you some more about the video surveillance footage. Now, the video that you got was by residents voluntarily giving it to you, correct?
Yes, sir.
Okay, and from the HOA?
Yes, sir.
Okay, were any obtained by warrant?
Yes, the video surveillance hard drive from 4215,
Okay.
Mr. Harris' residence.
Okay, and is that because you were able to get it by consent at first?
No, because they was worried if we take the module itself, they would no longer have video surveillance on their house. So that's why I went on ahead and issued a search warrant to go ahead and take possession of it.
And did you canvass the area to ask every single resident whether or not they have video for you?
Yes,
Okay. And did you, for the people that didn't want to give you their cameras, you didn't get a warrant for any of them? You just got a warrant for your content, correct?
correct.
Okay. And some of those video camera systems might have video stored in a cloud, correct?
Correct.
And if there's video stored in the cloud, you could have served a warrant on that company and gotten that video, correct?
Yes, and you know, based on the search warrant, you have to be able to target a particular device or a particular account. You just can't say, give me somebody's cloud account information. They want to know what date, what time, what range, and what account.
Right, and you could have given them the date, the time, and the range where Mr. Arnold, an innocent person, was shot in the neck, correct?
But once again, I would not know your cloud account number unless you tell me your cloud account number. And that's what the search warrant targets, your cloud account number, not the cloud itself. Because then there'll be millions and billions of video to try and stream through. So you got to always make sure in the search warrant that you're targeting that person's account and no one else's.
Okay, so you're saying that the only way for you to get Ring video from Ring is if the if the person who owns that camera gives you their cloud number?
Yes, sir.
You don't think Ring has any way to know that person's number without them giving it?
Once again, Ring going to ask for that person's account number, that person's account information, whether it's their login name, their username, but they're going to need that for their protection, for not protecting that person's right to privacy.
Isn't it true that in the Ring user agreement says that we waive that right to privacy, that those videos can be given to law enforcement without our consent? Is that correct?
I believe so.
Okay, so the right to privacy has nothing to do with it.
So for some, yes.
Okay. For all, Ring.
I believe whoever that contract they signed it with.
And what you're expecting us to believe is that Ring doesn't know the account numbers of its own customers.
I'm not saying they don't know, but we give them in our search warrant so that the judge will sign our search warrant. We have to be able to target that person's user account name. Ring don't arbitrarily just give it to us. We have to make sure that when we serving it to them, that we already have that in hand, in the legal document, in the search warrant, asking for that. So I can call Ring up and say, what is it? They say, what is that user's account name or user's login name or user's name? If I don't have that, there's nothing else I can do after that but try and get a search warrant. And once again, the search warrant, the judge is going to ask, who are you asking to get information from? There can be a million people with your name, but if I don't have the right user name, then that warrant will not get signed.
If I understand you correctly, what you're saying is that if you see a video of something that we don't have yet, and you tell a judge, I want the Ring video that's that camera at that house from the day that an innocent person was killed, that in your experience, which you have a lot of, a judge would not sign that warrant. I understand.
Yes, because once again, we have to indicate that user's account name. We can't arbitrarily just go in and just grab people footage.
All right, we've covered this. Next topic.
Right. And then, let's say the judge signed the warrant we just talked about. What you're telling us, because I don't think you've answered yet, is that Ring cannot connect an address and a customer to an account.
Ring can, but we have to have an account name and information. Ring can, yes.
Okay. Now, about how many investigators besides yourself were involved in this investigation?
Initially, there were 5 homicide detectives that was already on duty that responded to the scene. That'll be 4 detectives and 1 sergeant, I believe it was.
Okay. And there's no record in any of your reports of you canvassing the area for witnesses or other videos?
Yes, I walked through the neighborhood and got nothing.
My question is, that's not anywhere in your report?
Correct, it's not in my report.
There's only one way to drive in and out of the complex, correct?
Correct,
There's not only one way to run in and out of the complex, right?
correct.
There's forest around it.
Yes, sir.
There's forest around that area, that grassy hill, that driveway was talking about.
In the rear, yes.
Okay. And you check that rear for any possible escape routes, for any possible attackers?
Based on the video, no.
Okay. I'm just going through, make sure we don't repeat anything. Now, again, so your theory of this situation was that this shooting involved these two residences and people associated with them. And because you excluded Javante, then you said, well, if it's not him, then it must be Pop.
Based on the video surveillance, yes, sir.
Right, so kind of logically speaking, it's either A or B, because not A, therefore B.
Yeah, based on video surveillance, yes, sir.
You didn't consider any other possibilities like C, D, E, F, anything else?
Initially, based on what we got, that the shooter was shooting from the white vehicle. The video, once again, proved I was wrong and incorrect. We looked for the video of anyone coming down, shooting from the street to that location. Video proved that was wrong. So logically thinking, the video is showing that the shooting was coming from 4228 Notting Hill.
You didn't explore whether or not someone might have been in that grassy area unrelated to this robbery or serious crimes of the two houses, correct?
So I thought you weren't going to repeat things. That was your vow to the jury and me when you switched pads, that you're not going to cover stuff you've already covered.
I'm doing my best, Your Honor. I apologize.
Okay.
Now, besides anything I've already asked you, we don't have any information about Sam, G, or anyone else.
Correct.
Okay. We already talked about escape routes from the Grassy Hill area, that it's elevated. I want to ask you one more thing that I haven't asked. So that Grassy Hill area, it's at the side of the 4220 townhome, correct?
Okay, 4228. Which side are you talking about, sir?
Talking about this area right here, correct?
Okay,
And there's no camera here, correct?
correct,
Because that's the side of the townhome, correct?
correct.
And typically, customers put their surveillance video at the front and the back, or both?
Correct.
Okay. Yeah, I'm done with this. So given that that area is not under camera surveillance, it's elevated, that seems like a perfect place to attack someone from, correct?
You mind if I, once again,
I don't mind. If you need to use it, let's put it back up and wrap up this hill that we're coming back to again.
we'll try to right here, right now. Based on the video surveillance coming from 4219, the shooters are shooting this way. They're not shooting to the side of 4220 at all. If I know someone is shooting at me, I'm not going to shoot in the opposite direction of where they're shooting. So once again, the video surveillance showed no one was at 4220 shooting at them at 4228. 4228 took it upon themselves to start shooting at 4215. Video surveillance showed that the white vehicle never discharged his weapon, pulling out. Video surveillance also showed that there was no one came back around. Also, once again, as my earlier statement, there was a young man shooting basketball right here. He ran this way, which I believe is north, on Notting Hill, away from where Mr. Parks and Mr. Phillips were standing. Logic dictates, if someone's shooting to the right of me, I'm not going to run towards them, I'm going to run away. So if this is the Grassy Hill area that you're talking about, no one was over here shooting. This part right here,
That's the part I'm talking
okay, what you was pointing over here. Okay, so once again, video surveillance does not show any subject in this grassy area right here. The jury, because I was jury sitting, I'm sorry. Okay, I'm sorry. No one was shooting from here or here, or here, or here, or here.
We don't have video, I hate to keep talking about this, but we don't have video of anyone in or not in there.
So, video surveillance has a wide view of this location here, okay? Once you look at it, you see they're shooting this way, not this way. So once again, their driveway is going this way. 4220 is here. They're not shooting this way, they're shooting that way. And
All right,
so-
you have made that clear. Let's take that board down, and then if you've got other topics you want to explore something new and different with this witness, let's go to a new and different space.
Your Honor, only one last different question. So it's your testimony that on that pixelated video from all the way over there, you can tell the minute detail of the angle, whether it's this or this, correct? I just understood you
Okay.
correctly?
Yes, sir.
Okay, thank you. You didn't investigate whether or not Mr. Phillips had any reason to be in that driveway besides to supposedly be involved in the shooting, correct?
I believe he was dropping Mr. Parks off at his residence because they all arrived in a Mustang together.
Okay, that's not in any of your reports.
No, sir.
Okay.
Other than Mr. Parks' statement.
Now, just lastly, Judge, I wanna go to State's Exhibit. I believe it's State's Exhibit number 17 from yesterday. And I want to play the detective zoomed in version of that video we were just talking about.
So you may be doing some zooming. I mean, state 17 doesn't zoom. State 17 is the native format, unedited, unrevised, unzoomed. You're gonna manipulate it in some way?
Only by screen recording and taking a screenshot of that recording so that it's like this instead of like this.
So are you tendering a new exhibit? Because it doesn't sound like you're gonna simply play state 17. If you're gonna play state 17, it's in evidence you can do that. If you're playing something that is not state 17, then you'll need to figure out how to get it in through this witness.
Thank you, Judge. I think what I'll do is, since it's been admitted, I think I will do that process in front of us all and then play it.
Right now?
No, I could do that after the lunch, Your Honor, and I would like to do it after the state enters the park statement. That'd be so.
Okay, so you'll save that for a recross.
Yes, Judge.
Okay, anything else?
Not at this time, Your Honor. No, thank you.
All right, ladies and gentlemen, we're gonna break for lunch now. During the lunch break, the state will figure out if it's gonna be able to play the statement that it tried to play this morning. If it's not audible then it's just not gonna be audible and it will be in evidence, and I don't know what we'll do with it, but they'll have the lunch break to do that. You should take the lunch break to do something other than talk about this case or do any outside research. And I've got kind of 12:40-ish, so let's be back around 1:40 to resume with Detective Thorp's testimony. Thank you. Mr. Griner, the courtroom will be open throughout lunch. That's your opportunity to get folks in here to make it work.
Yes, Your Honor. Thank you.
Anything else from the state?
No, Your Honor.
Mr. Monetis, anything else on behalf of Mr. Phillips?
Yes, Your Honor, just briefly, I did want to, similar to yesterday, make a motion for mistrial with prejudice based on the lack of a severance, because there was 404B ruling by this court that we were not to talk about Woe or Mr. Phillips having done anything wrong at any other point, other acts, and yet the co-defendant's attorney opened the door to that, and I had no control over it. And I think that's made this trial, again, fundamentally unfair, and it allows evidence against Mr. Phillips that this honorable court ruled should not have been admitted against Mr. Phillips.
Okay. I don't know that your motion is timely, so I'm going to deny it on that basis. I'll also deny it because I think what you're referring to was a maybe 3 or 4 word response from Detective Thorp, where he said that Hot and Woe had had issues before, had been in trouble in that neighborhood before. Full stop. Now you say open the door. Mr. Griner better not ask anything about that. I don't think he will ask anything about that. the way a door would be open would be if your client testifies and says, I never had any issues in that neighborhood, then Mr. Griner can explore. But in case you're worried about that, I don't think that the response that was given was either inappropriate or particularly prejudicial. It was about as generic as can be. Mr. Rowe didn't go back there, and I'm directing the state not to go back there. So for both those reasons, I'm denying your motion for mistrial. Anything else from Mr. Phillips's side?
Nothing, Your Honor, besides I want to stay here and access that exhibit number 17.
Mr. Rowe, anything else?
Okay.
All right, I'll be back in about an hour.
That's my question. I'm going to jail. Yeah. On his face. Okay. So. I'm not gonna lie, bro. When you saw, so who had the two guns?
dude that lived in the house or dude in white car?
Okay, we'll get on the record now. It's State versus Parks and Phillips. Monday afternoon. Didn't make a lot of progress this morning. Are you still forecasting that you're resting today? Or much like our hurricane weather map, we need to revise that because the cone wasn't accurate?
Your Honor, it's hard to say. If it's not this afternoon, I think it'll be early tomorrow morning.
You've got Jarvis, Falls, medical examiner.
Correct.
Other witnesses, or that would be it?
2 more.
Beyond that?
Very brief, very brief.
Okay,
Yeah.
you can have 10 more. I just wanted to know. So you have 5 more witnesses. We're not done with Thorp, but after that, there are 5 witnesses. We're not finishing today. Okay. I'm not going to tell the jurors that, but we'll see how we do. So the plan is we had direct and cross of Detective Thorp. This will be your redirect. In the course of your redirect, you can play that video, assuming you still want to do that. And then I'll turn to Mr. Rowe and Mr. Menettis for recross based on what you covered during your redirect.
Yes, Your Honor.
All right. Anything else from the state?
No, Your Honor.
Mr. Menettis, welcome back from lunch. Anything from Mr. Phillips' side?
Thank you, Your Honor. Thank you. Only that I don't anticipate asking many questions about the state's redirect right now, just playing that video and cutting it and that stuff. That's
Okay. And you've charted a course you think that gets in your version of the video?
Yes, Judge. My intention is to just do it live on my computer, and I just did a test run of that.
Okay.
And then probably save the product of that onto a USB and enter it as an exhibit.
Okay, so you'll be using State 17 and then through the marvels of modern technology, do the Zoom sort of real time.
Yes, I'll screen record it. You can set what area you want to screen record, and then you can then play that back, but as full screen. And then I can also crop parts of it.
Okay, all right. Mr. Rowe, anything on behalf of Mr. Parks?
No, not until after the station.
Okay, all right.
Yeah, just 17, but it's 16 to 21. Yes, this is what's on this USB.
Your Honor, I think that my colleague's actually using video 17 or 19, not 17, but it's all on the same thumb drive. So just want to.
Okay, let's just make sure we're clear on the record, which of the segments 19 is described in your exhibit list as continuation of 17, but it is a separate exhibit for whatever reason. So we'll want to be as clear as possible when Mr. Menettis is doing what he's doing, which exhibit he's talking about.
Yes, Judge, it's the USB in evidence that says States Exhibit 16 through 21, and that's the 6th video download list and the 7th video download list. So I don't know how.
Okay.
So, yeah.
I don't know either. It's on something that's in evidence, so
Yeah.
I think we're okay. And the jurors will have all these videos, so there are no surprises here. There is a computer with a big screen, I don't know, maybe that size, in the jury room, and I intend to install, that hard drive has on it only the Windows operating system and a way to play videos. There's no internet access or anything, but I intend to have all the videos available for them to replay in whatever way they want, using their own skill set in pressing play on a media player. So we'll make sure that all the video evidence does get properly installed back there, but we don't need to inconvenience them or us during deliberations. Should they want to replay 18, they just press play on their own machine. And it's worked well in the last 2 trials. Okay, Detective Thorp, thanks for being back. Let's bring the jurors in.
All right, so the jury. Jurors present in the county court.
Thank you, Deputy Gordon. Everyone else can be seated. Welcome back, ladies and gentlemen. Hope you had a good lunch. We are resuming with Detective Thorp's testimony. We're pivoting back to the state for redirect. We'll see if they're going to play that video, if their technology is working for them. Mr. Greiner, when you're ready.
Thank you, Your Honor.
I'm asking my questions. I'm going to jail today.
So I don't have down that it's been tendered yet. Did you get the witness to identify it? And I know we've had some testimony about it, but my notes don't have it as admitted. This would be states 156.
Yes, Your Honor. And I thought that we had covered that in a pre-trial morning hearing, but I'll ask a few questions.
Okay, just so the record of the trial, I'm not suggesting there's anything inadmissible about it, but I think we ought to make a record for the trial, tendering it. So if there are any things that defense attorneys want to add, they can do that.
Yes, Your Honor. Detective, did you interview Mr. Parks in the case?
Yes, I did, sir.
And have you gotten a chance to review the recording of that interview?
Yes, I have, sir.
You've seen a few seconds begin to play here on the screen here in the courtroom, have you not?
Yes, sir.
And did that appear to be a true and accurate depiction of the beginning of that interview?
Yes, it was, sir.
Your Honor, this time I'm going to move to admit State's Exhibit 156 into evidence, and Detective, you'll tell us if there's anything that changes, correct?
Yes, sir.
All right. So ladies and gentlemen, I'm going to hear from the two defense attorneys in just a moment, but I want to remind you that this video has been redacted, edited. There are parts that you won't see and hear, or at least won't hear. I don't know how the state has handled the redactions, but it is not uncommon when a defendant has a custodial interview with law enforcement, that something comes up that's not germane to what you need to decide. And an attorney will say, hey, I don't think the jury should hear that. And the attorney's right. And so instead of saying they can't hear anything, some part of it is cut out. Sometimes, like I said, it just goes mute, but you'll see people talking and you can't hear it. That's one approach. The other is they literally digitally splice it out. And so it may be jumpy. None of that is shenanigans where someone's trying to keep something from you. It's my ruling that certain parts of the interview aren't relevant to what you need to decide. So with that, Mr. Menettis, any objections to states 156?
No objection, Your Honor.
Mr. Rowe?
No objection.
Admitted.
We're going to record our conversation.
Yes, sir.
If we're going to have one.
Yes, sir. So I can ask you a question. That's my charge.
Didn't get a chance to introduce myself to you outside. My name is Detective Jacob June.
Yes, sir.
Civil Atlanta Police Department Homicide Unit. Your name is once again, sir?
Mars Parks.
Kamaris Parks. What's your date of birth, sir?
8/24/2001.
Okay. Today's date is September 28th, 2021. Time is approximately 13:10 hours. We make it 1:10 p.m. I'm about, because you are in custody, I'm about to advise you of your Miranda rights. You know what your Miranda rights are, right? Yes or no?
Yes.
Okay. Says you have the right to remain silent. Do you understand that?
Yes.
Anything you say will be used in court as evidence against you. You understand that?
Yes.
You are entitled to have a lawyer now and have him present now or at any time during questioning. Do you understand that?
Yes.
If you cannot afford a lawyer, one will be appointed for you without cost, and he may be presented, and he may be present at all times during your questioning. Do you understand that?
Yes.
You can decide at any time to exercise these rights and not answer any questions or make any statements. Do you understand that?
Yes.
Do you understand these rights?
Yes, I understand.
Do you wish to talk to me at this time without a lawyer?
Yes, I will.
Okay. For the record, spell your name again. K-A-M-O-R-A-C-E.
K-A-M-O-R-A-C-E.
Last name, middle name,
Taquan. T-Y-Q-U.
your last name,
Parks. P-A-R-K-S.
and your date of birth again, sir.
8/24/2001.
And where do you live?
I really don't. I don't still my mom. Oh dang, what's my address? Damn, it's on Stone Road.
On Stone Road?
Yeah.
You stay with your dad?
Yes. Oh, it's 2430 Stone Road.
2430 Stone Road.
Yeah.
Okay. That's in East Point, right?
Yes. I think that's it. 303.
You got a cell number?
No, I don't.
All right. You hear Mr. Parks in reference to the homicide investigation of victim name is Tobias Arnold. It happened September 13th, 2021
Yes.
at 4226 Notting Hill Drive in the city of Atlanta, Fulton County, state of Georgia. Under the police department 392. I'm obliging you. You've been charged.
Can you pause it for a second?
Possession of firearm during the commission.
So that funny feedback, that's not occurring in the interview room. That's something that's happening here.
I believe so, Your Honor. I have to unmute my laptop in order to access the device, but I believe everyone else has to be muted. It might be picking up feedback.
Okay. All right, we'll see what happens.
Were you at that location?
May I position the speaker in a different place in the courtroom to see whether or not it's.
Sure. So I suspect it's the
This one.
podium microphone, but do not mute it. That's the central sound system, so that can't be muted. I've muted all the other microphones, but that's one that needs to stay on.
Is it possible to mute the witness microphone?
It's been muted all along.
Maybe the speakers.
This, it still says green.
Oh, you can go ahead and do that.
Oh, yes.
That's fine. It's
Okay.
muted in the system. Don't know how excited the jurors are about that, but we'll see what happens.
Where were you? I was on the other side of County Road. And I was
So, you're starting off with a lie.
So let's stop it. I don't know what you did at lunch, but it didn't work. Do you have other questions of Detective Thorp, Mr. Griner?
I do. During the interview, if you recall, at some point, the defendant Parks referred to his gun as being decocked. Do you remember that? Remember him saying that?
Yes, sir.
Can you tell the jury what it means for a gun to be decocked in the manner that he said that his gun had been decocked?
Basically, he was trying to say that the weapon was out of ammunition.
So he had shot and all the ammunition was gone.
Yes, sir.
All right.
Can you hear me? Okay.
There was some talk of an Instagram page or some kind of communications back and forth on Instagram. And do you remember being provided with an Instagram address by defendant Parks?
I don't recall receiving an Instagram account.
Well, if you did get an Instagram account or an Instagram address, did you check it out? Did you check that out as a possibility?
Yes, I will check it out, possibly.
And do you remember viewing the video early on when defendant Parks, defendant Phillips, and this third guy, G, walked down past this unknown individual and walked down to that residence? Do you remember reviewing that video?
Yes, sir.
Can you tell the jury if you recall anyone clutching? If you remember.
Yes, sir. After reviewing the surveillance footage again, I can still see one subject, G, who's dressed in all black. He had his right hand inside of his hoodie sweat pocket. And as Mr. Phillips was the last subject to come around the corner, he had his left arm clutching his left side. It's like he's trying to hold what we deem in law enforcement as a telltale sign that the person is carrying a weapon. He's trying to make sure it stays stabilized as he's walking with his inside his waistband.
Can you just explain that a little bit and what it means to be clutching like that?
Okay.
And why someone may need to do that?
Someone trying to conceal the weapon inside their waistband of their trousers. They'll do this to make sure that the weapon is not moving around, or they're trying to reposition it to be comfortable.
Okay, and you saw that occur?
Yes, sir.
All right, thank you. Your Honor, that's all the questions that I have at this point, subject to the interview.
Okay. Mr. Rowe, anything in addition from what you've already covered?
No, sir.
All right. Mr. Manetis, anything else?
Yes, Your Honor, thank you. As far as what the state just asked you about, that could be that you need to hold the gun that way because it's pulling your pants down, like guns are made of metal, can be pulling down your pants.
Yes, sir. Yeah, the total weight of the weapon.
Right, if you don't have a holster and it's just in your pocket or in your waistband, then if you don't hold it like that, your pants might fall down.
Yes, sir.
And you don't find it unreasonable, given the history of the neighborhood, for someone to carry a gun in the neighborhood, correct?
No, I find that unreasonable. No, sir.
Now, Your Honor, this time I'm going to go back. I'm going to publish what I believe is State's Exhibit 17, but in exactness, it's a USB previously admitted that says State's Exhibits 16 through 21. And the first video I'm going to play is the 6th video down in that USB, and it's labeled as IMG, all caps, underscore 3957. And I'm going to share my screen and play it. And Your Honor, my questions don't involve audio necessarily, so I'm just going to avoid that.
Wise choice.
Okay. What I'd like to bring our attention to this hill area we're talking about, this area that's obscured by the tree, correct?
Yes, sir.
As well as everywhere to the left of it, correct?
Yes, sir.
And that's where there's trees behind that, correct?
Yes, sir.
Okay. That's part of the area that we don't have photographs of, correct?
Yes, sir.
Okay. And as far as while I'm on the topic of shell casings, who all were the people in the chain of custody of the shell casings that worked?
It would be the crime scene investigator and I believe Detective Kilgore of the Atlanta Police Firearms.
Kilgore, okay.
Kilgore, K-I-L, okay, yes, ma'am.
Now, I want to bring our attention to what you testified to earlier. Which one of these is the Malibu? I see both cars are facing with the nose of the car towards the townhome. Which one is the Malibu? You're saying this is the Malibu? Okay, not one of these.
Can you, I couldn't see what you pointed to. Your screen, if you click stay muted.
Sir.
And then tap the screen once in the lower left-hand, tap it once. And then in the lower left-hand corner, there's a circle with the other corner. There's a circle with a pencil in it.
Yes, sir.
Tap that. Now your finger, circle, please, what you're saying the Malibu is.
That's the Malibu, sir.
Got it. Thank you.
And so presumably because the shots, the markings of bullets were on the other side of it, we don't have any reason to think that if there was someone attacking from the left, that they were attacking the Malibu.
No, sir.
Okay. Now, Your Honor, I'm going to ask you a couple questions and then play the video. Not Your Honor questions, you, sir. So it's true that Mr. Phillips is in the all white on this video,
Yes, sir.
and he does not walk up with Mr. Parks and the unknown person, G, correct?
Yes, sir.
He walks up behind them on his own.
Yes, sir.
Okay, so Your Honor, I'm going to start the video at 18 seconds and play it briefly for us. Okay, Your Honor, I'm stopping the video at 1 minute. At 1 minute. At this time, I'm going to move on to the video labeled all caps IMG underscore 3963. And I'm going to start, Your Honor, that video at about 15 seconds into it. And Your Honor, may we remove the red circle?
Well, when you put the new video up, it may go away. I can't tell. We don't have the new video yet. If
Okay.
not, we'll make that go away.
Okay. Oh, and I'm sorry, Your Honor, I mixed up the labels. This is actually 3963. The other one was 3957.
Okay.
Sorry about that. Okay, and I'm going to play this one. Oops. Yeah, I'm going to stop sharing the screen for a second. And I'm going to start again now. All right, I'm going to begin to play this video at 15 seconds. But what I'm going to do, Detective, as well, is I'm going to crop a screen record of that area of the death, and I'm going to play it, and my computer is going to record that area while we're watching it, and then I'm going to save it, and I'm going to play us that part of it.
Okay, sir.
Okay, and then while we're on this topic, you saw Mr. Demaro Phillips in the hallway. You see him opening up his backpack, which are on his waistband on the way back.
On the way,
Around
get back to the car?
Yeah, around the middle of this area.
Yes, sir.
I go over this, and then you see him doing something with his backpack, something with his waistband.
Yes, sir.
Okay, and then it's after that we see him on a different video with a gun in his hand straight up in the air.
Yes, sir.
Okay. Okay, Your Honor, I'm going to stop sharing my screen so I can access what we just produced. Okay, and Your Honor, I'm going to play, it's what's become now a 48-second clip. It's what I have done in front of us now with the state's exhibit. And so you see that before I started?
Before you play it, you should make this an exhibit. So is this going to be Phillips number one?
I believe it's going to be, Your Honor, I would like to label them as Phillips 2 and Phillips 2B, because 2B is going to be a screenshot that I make of this, and those will be just my two exhibits
So Phillips 2 is the 48-second video that you've created.
Yeah, I'd like to have it be 2A and 2B, but I'll do it however the court.
Do it however you want. You had said 2 and 2B. So 2A is the video?
Yes, sir.
And then 2B is some still yet to be made.
Yes.
Okay. Any objection, Mr. Griner, to the admission and publication of Phillips 2A? 2B doesn't exist yet, so I'm not going to ask you to weigh in on that. So 2A.
No objection.
Mr. Rowe?
Objection.
All right, Phillips 2A is admitted.
All right, Your Honor, permission to publish?
Yes, sir.
Okay, Your Honor, I'm pausing it. So that person in the black, presumably that's G,
Yes, sir.
the guy that we don't know anything about.
Yes, sir.
The guy that you say we can see on this particular video, who's gun obviously.
Yes, sir.
And we see him during the shooting all around this area, right? We see him sometimes up by the door, we see him come around by where Mr. Arnold's killed, see him in various parts of this.
Yes, sir.
area. Okay. And we see that part where Mr. Phillips is holding his left hand sort of forward and kind of like this, correct?
Yes, sir.
And we can't tell whether or not that's a gun or a phone in his hand, correct?
Correct.
Now, I'm gonna stop sharing my screen one more time, Your Honor. I'm gonna play us one more thing. Your Honor, what I'm about to play is the video before I cropped it. I'm not gonna do any more manipulation. It'll be just defendant exhibit 2.
Okay,
2A.
so there's no 2A, there's just defendants 2. You'll get that onto a thumb drive at some point, and that'll be part of the record.
Yes, Judge.
Great.
But now lastly, I would like to play the zoomed out video of what I just played.
So this is 2, and you are zooming out.
Yeah, it's what we just watched a little bit of, but I want to play a later portion of it.
Part of the 48 seconds.
No, Judge. It's part of what I created the 48 seconds out of. It's state's exhibit that's on the USB 16 through 21, and it's what's labeled as IMG all caps _ 3963.
You're going to play 3963.
Yes, at a certain point.
Because you're not manipulating it in any
No.
way. You're just playing it at a certain point.
Yes, Judge.
And it's something we've already seen with this witness.
I paused it before we got to the part that I just want us to watch.
Okay, thank you. Just wanted to understand.
Okay, Your Honor, what we're seeing here is that video at 50 seconds.
Yes, sir.
Okay, this is where you see Mr. Phillips is doing something with the backpack.
Yes, sir.
Okay, before we see him with the gun and his left hand straight up on the other video.
Yes, sir.
Okay, and then there's G doing something with his arms.
Yes, sir.
Okay. And then I just want us to pay attention to whether or not we end up seeing a white van at the end of the video speed off towards the boys. I'm starting at 50 seconds, Judge. Okay, you saw that white van?
Yes, sir.
Okay. And when we see the shooting, presumably, G, Hot, and Mr. Phillips in the driveway, if we were to take Miss O'Neill, who said she heard shots coming from that obscured area, if we were to take her as telling the truth, and she heard these 3 shots, we don't have any way to really know whether G knew where those shots were coming from, correct?
G had to be able to tell you that, sir.
Right. And gunshots are incredibly loud and terrifying,
Yes.
especially if you're not wearing ear protection.
Yes, sir.
Okay. And so same way that we don't have any way to know whether G knew where the shots were coming from, we also don't have any way to know where Hot thought the shots were coming from, Mr. Parks.
Could speculate that.
Those are my questions, Your Honor.
All right. So what I ought to do now is let the jurors ask questions, because we've gone through direct and redirect. Anything else? I'm not really into redirect.
I understand. I think we've got the means now to play the interview.
And my confidence level should be above 0. Why?
New person, new equipment. We're going to try to use this board over here in your program.
Okay.
So we can set it up. Different equipment.
Mr. Rao?
Yes, sir.
You've got 60 seconds.
Yes, sir.
So have you been pressing the same button a bunch of times back there? I'm just asking because if you don't have a realistic hope that the audio is going to work, I want to thank you for parachuting in here. Your colleagues had all lunch to get this to work. So I think we need to move on. All right. I appreciate it. All right. Ladies and gentlemen, if you all have any questions for Detective Thorp, now would be the time for Deputy Gordon to get them from you. Thank you. All right, counsel, if you'll come with me, we'll be right back.
Yes, sir.
Detective Thorpe,
Yes, Your Honor.
you were asked several questions about something having evidentiary value. Tell the jurors what that phrase means to you when you're doing your job as a lead investigator. What makes something have evidentiary value?
What makes something have evidentiary value is its regards towards the investigation itself. Whether it's shell casings, a weapon, video surveillance, cell phone, anything to that degree in nature.
Speaking of cell phone, where was the cell phone found? Do you recall, or if you had a map of well, you won't know what evidence placard it was, but in general, do you remember where the cell phone was recovered?
No, I do not. Sergeant Mitchell, when I arrived on the scene, I was being debriefed. She brought the cell phone to me in this package and said that they believe that's a cell phone that was dropped by a person, by the subject by the name of Woe. And there was another party out there trying to take possession of said cell phone.
When you said it was in a package, meaning like the phone was in a box, or
No.
it was in an evidence envelope?
Yes, it's an evidence envelope. I'm sorry.
Got it. Was the phone ever accessed? In other words, I didn't ask that well. After it was in police custody, were law enforcement officials available to open it using investigative techniques?
Yes.
Were there any videos or photos found on the phone that would demonstrate that the holder of the phone was recording the scene at or about the time the shooting occurred?
No, it was not.
Were any firearms recovered in connection with your investigation or any of your colleagues' investigation into this homicide?
No, there was not. No firearms were ever recovered.
Do you know if a projectile, a bullet, was recovered from the deceased during medical intervention or autopsy?
I believe there was, and they automatically are sent to the GBI.
Would you be the one who would figure out the caliber if the caliber was ascertainable from whatever was removed from the deceased?
No, that'd be on the GBI, and they would usually say small, medium, large caliber.
Were there any shell casings or other items of evidentiary value found on the grassy hill areas you've been asked about?
There's none. Zero.
You may, during your testimony, have referenced Mr. Harris, not the unknown individual by the white car, but Mr. Harris, at some point carrying a gun or two guns. How did you come to believe that Mr. Harris at some point that afternoon, early evening, was possessing firearms?
He was stated himself, and you see him come out with two weapons in his hands, and the neighbors was like, yeah, he had two weapons in his hand. He never denied it. And he never tried to fight back on it.
Okay. Mr. Greiner, do you have any follow-up with Detective Thorpe based on that exchange?
No, Your Honor, I do not.
Mr. Rowe?
No, Judge.
Mr. Menettis?
Yes, Judge. Just a few. So you're saying that there's no casings found anywhere else, but again, we're taking your word for it.
That's how it works. He's under oath.
No photographs,
No photographs of,
that area supposedly having no shell casings.
no, we don't take photographs of nothing.
Okay, but that's certainly significant to the case, whether there's something there or not.
Right, but once again, we don't take photographs of nothing. I explained earlier, it was looked, it was observed, nothing of evidential value was there. We ascertained, based on where the evidence was found, that the driveway of 426 and 428, along with the street, was where we need to focus on.
Do you have a new area you want to cover? This is an area
Right.
you've covered multiple times with this
Okay.
witness.
That's correct, Judge. Now, that's a grassy area. It's possible that someone shooting can pick up their shell casings, sir.
Yes, sir.
That's something you've had criminals do in a lot of cases you investigated.
Yes, sir. And the video showed no one picked up shell cases from that area.
Video doesn't show that part behind the tree, correct?
What's that, sir?
You don't see the entirety of that hill area on the video, correct?
Okay, you talking about the hill right next to 426 or 4220?
I'll move on. Now, last thing about this phone. So Mr. Phillips's phone that you found on the scene, you can't say where. Was it an Android or an iPhone?
I believe it was an iPhone, I believe.
And isn't it true on iPhone that you need to press the camera? It's automatically on photo. You need to swipe a small area of the screen to get to video, and then you need to press record in order to record a video, correct?
I'm not an iPhone user. I use Android.
Okay. On your Android, though, you don't just go immediately to a recording. You have to press a few buttons to get to
Yes.
the recording. Okay.
Yes.
And again, this is a chaotic, loud, terrifying scenario, correct?
Yes, sir. For the people that was there. Yes, sir.
Okay, and Mr. Phillips is at the scene of Mr. Arnold being shot in the neck and dying right in front of him.
Yes, sir.
Okay. We see him run up to him, and then we see him run away, correct?
Correct.
Okay, those are all my questions, Your Honor.
All right, Detective Thorpe, I appreciate all your time. You are free to go.
Thank you, Your Honor. Thank you, jury.
Next witness.
The state calls Detective Fall.
Thank you, raise your right hand. You swear or affirm that the testimony you'll give will be the truth, the whole truth, nothing but the truth, so help you God.
Thank you.
No, yeah, I see. Can you state and spell your name for the record?
Yes, sir.
Name is Detective Christopher Fall, CHRISTOPHERFALL.
Good afternoon, Detective Fall.
Good afternoon.
Where do you currently work?
The Atlanta PD Homicide Unit,
And how long have you worked for the Atlanta Police Department?
about 11 years now.
And how long have you been assigned to the homicide?
A little over 3 years, I believe. It was 2021.
Can you tell the jury your educational and professional experience that leads you to having 3 years of experience in homicide?
So I graduated the academy, went to the academy in 2013, graduated in 2014. I was in Zone 3 as a patrol for about 6 years, working patrolman and crime suppression unit. And then I promoted to detective in 2020. I worked in the zone for about a year. And then I've been on homicide since then, just learning, taking a homicide investigation class as well, 40-hour class as well, and learn from learning from other investigators and experience.
And are you post-certified?
Yes.
Can you explain to the jury what might you do when you're investigating a homicide?
There's a bunch of different things. You do first you want to get out there and look at the scene, talk to any witnesses, do a crime scene sketch to document the scene, try to get any video. It just depends what you have when you first arrive.
And were you involved with the homicide investigation that occurred on September 13th, 2021?
Yes.
And in what way were you involved in this investigation?
I responded to the scene. I also did the crime scene sketch for this case.
And explain to the jury, what is a crime scene sketch?
A crime scene sketch is where we document what we have on scene, either casings or the victim. It could be a car, whatever's on scene, it's documented in the crime scene sketch.
I'm going to hand to you, which you previously marked as State's Exhibit 63. When you get a chance to take a look at it, please look up. What is State's Exhibit 63?
It's the crime scene sketch for this case.
And is it a fair and accurate depiction of what you sketched in your report from 2021?
Yes.
Does it appear to have any alterations, deletions to your report?
No, it does not.
Your Honor, at this time, the state tenders into evidence State's Exhibit 63.
Mr. Manetis, any objection?
No objection, Your Honor.
Mr. Rowe? Admitted.
State will now publish State's Exhibit 63. The second of all, this monitor you can actually interact with. There is an option if you just touch the screen.
Oh, okay.
You can get a pencil and you can circle and things like that, okay?
Okay.
So we're gonna be interactive with the crime scene sketch shortly. As we're waiting for the crime scene sketch to come up, what will be the relevance of a crime scene sketch in an investigation?
To document where, for example, the casings are located in reference to the victim, or the victim in relation to where the casings are. Distances between the victim and the casings, is document that.
And did you receive additional training and education to complete crime scene sketches?
No, I didn't do additional. It was just what I learned when we first got the homicide.
It looks like it's active now. Kind of on the screen, it talks about the crime scene sketch diagram and measurements. Can you walk us through some of the points of references?
Yes. So with the points of references, we try to use objects that won't be moved generally. For this one, we used a fire hydrant. It's going to stay there regardless of what happens in that community. It's generally going to be there for a long period of time. And then we also used a manhole cover, or I also used a manhole cover. So we try to use objects that won't move, that will be there for a long period of time.
And in this crime scene sketch, how many markers did you identify?
33 markers.
What?
There's 33 markers.
Okay, here is the sketch. Can you slowly walk us through this crime scene sketch, and you can also use this drawing tool to identify as well.
So where's the drawing tool at?
Well, I'll help you with that in a minute. Is there a way we can zoom that at all? It's kind of small. We're somehow in Word within PowerPoint. Yeah, I don't think you can do, but I think you could still magnet, if you go back within the Word document and scroll down to where you want to be, and then see what happens if you use that sliding magnifier. All right.
A little bit larger?
That's good.
Okay.
Thank you.
All right, now you can use the drawing.
Where's the drawing feature? I don't see it on here.
So if you tap your finger on the screen and then
Oh,
tap
okay.
that,
Oh, I
now
see
your
it.
finger can drop.
All right, thank you.
Sure.
So can you please walk the jury through your crime scene sketch?
All right, so marker 1 is going to be the victim, so the victim was located when we arrived on scene. That's going to be then 1, 2, 3, casings 2 through 12 are going to be 40 caliber casings discovered were in the area where the victim was located at. And then you're going to be further down the street right here. There was a house over here that was actually shot prior to this incident or before this incident. And that's what these shell casings are right here. Were used to actually appears to shoot into that house.
Talked about two measuring points. Can you show the jury the two measuring points that you use as a reference?
Absolutely. Okay, so we have point A, which is going to be a fire hydrant. And then point B is going to be a manhole cover. My drawing's not that good. And then we got point B, which is going to be another fire hydrant that was on over here. And then point A is going to be a manhole cover, which was used.
So for 1 through 12, you use the point A and point B that are closest to what's labeled house.
Yes.
And then for 13 through 30, you used the ones that are near that intersection.
14.
Well, the numbers aren't, I'm not worried exactly, but
Yes.
but that's why they're two A's and B's.
Because it was kind of big, it was kind of a big area.
Okay.
I recall, so we weren't able to just use one due
Okay.
to the amount of casings in the area.
So I noticed on your crime scene sketch, there's no marker for 13. Is there a reason why there is no marker for 13? Is it due to the diagram not allowing you to add it here, or is it just a human error?
Could it be human error? I don't know why it's not there.
But for the record, there is evidence marker number 13.
Yes, there is. I just don't know why it's not actually on the sketch.
And these evidence markers that are collected on scene and also described in your crime scene sketch, do they correlate the same? So is crime scene marker number 1 the same that a crime scene technician would have placed down on
Yes.
scene?
Yes.
I also noticed markers 31 and 33. Can you highlight that for the jury, please?
Right there.
And that's towards that house in crime scene marker number 1, correct?
Yes.
When collecting evidence, can you explain in your crime scene sketch the measurements and how they're relevant to your sketch?
Yes. So to actually take the measurements, we use a device. You put in your hand, it's got a dot. We have somebody go to the other point where they're at, usually with those hold up a piece of paper or a notepad. And once that dot hits a notepad, you can tell the distance between where the casings, and that's how we actually determine where the distance is, how we do it. And then we
It's a
also,
laser.
yes. And then also, if there's not a laser, there is a actual way of using actual measurement, a tape measure, but we tried to use the laser when possible.
There is a way for you to take these markings off, I believe.
Yeah, well, there should be, if you tap again, there should be tools all along the left-hand edge.
And there's a circle that looks like it's going counterclockwise. That removes them one at a time. I guess you can just tap that a bunch of, excellent.
It was working it.
Okay.
All right.
Oh, you're using it as an eraser.
I think
All right.
it's supposed to be an eraser.
Hey, that works.
Thank you, Secretary Hall. So for marker number 1, when we're talking about the measurements, can you explain using an example with marker number 1 where the victim is lying?
So you're going to go to point A, and then the other person is going to go to where the victim is. They're going to hold up that notepad or piece of paper, and that's going to, you're going to actually get the measurement from where that 35.3. That's how you actually get the actual measurement. And then from point B, you go to point B, have somebody be the victim, and then you do the same thing with the laser to get the actual distance.
And is that inches or feet or miles?
I believe it's feet. I believe.
And when collecting evidence, are there several law enforcement officers in the area looking for related evidence?
Usually there's going to be multiple detectives on scene. Before we get there, patrol might be also be looking for evidence. And then, yes, there's different officers on scene and detectives as well.
The state will now show state's exhibit number 52, which is already evidence. Detective Fall, once state's exhibit 52 is published, can you just explain to the jury what we are observing?
Yes, whenever you're ready. So that's, oh. So for example, marker 13, which is right there, you want me to circle it or?
You can circle it.
13 is going to be a 40 caliber S&W casing, and that's going to be the marker which the crime scene tech actually puts down. They document it via picture, and they pick it up, tell me what it is, or whoever's taking the crime scene sketch, and they put it directly into a envelope, so it's safe and secure, and then gets taken to evidence when they're done with the scene.
Mr. Monetis, do you have any questions for Investigator Fall?
Just a couple, Your Honor.
That's two.
I'll hold myself to that, Your Honor. Now, the locations that we see on the sketch, those are the locations known because of whoever put the marker down there first, correct?
You're talking the 1 through 33?
No, just all of them. Like somebody at some point came, you don't know exactly when, and put the markers down where those casings were found at that time, correct?
Yeah, the crime scene tech's going to put the markers down when they arrive on scene next to the items that are going to be marked.
Okay. And based on how long after the shooting that took place, you don't have any personal knowledge about whether or not there was any contamination or movement of the casings?
I don't believe so.
Okay, those are my questions, my two questions, Judge.
It's all good. Mr. Rowe, any questions for Detective Fall?
Yes. So at what point were you able to actually observe the markings yourself?
I probably got to see, we were notified of the homicide, so we responded to the scene probably within 30 minutes to an hour. I arrived on scene, and then I was there when the crime scene tech put him down.
And then after they finished, that's when you began to draft your report?
Yeah, I did the report when I got back to the office, document on my notepad, and then I did the report back in the office.
And did that complete your part or your role in this investigation?
Yes.
And when you arrived, it was dark, just as indicated in the pictures, or?
I believe so. I don't remember what time. I believe it was dark. I'm not entirely sure.
Thank you, that's all I have.
Thank you.
Any redirect? Any questions from jurors for Investigator Fall? Nope. Thank you, sir, for your time.
Thank you.
You should leave up there anything you didn't bring.
I brought this can stay.
Great. All right. You keep yours. Thank you.
Thank you, Your Honor.
Next witness.
Jarvis will be next.
All right, ladies and gentlemen, we're going to take an early afternoon break because I have to talk with the lawyers about this next witness. It won't take very long, but you can't be in here while we have this discussion. So please retreat to the jury room, the hallway. Don't talk about the case. We'll get you back in here in a moment. All right, Mr. Griner, anything in particular you want to add before I rule on the couple of Jarvis issues that are floating around?
No, Your Honor, I mean,
As soon as we got the information, we turned it over, and I believe that my colleagues have had ample time to review the evidence in the case, and so our position is that we should be able to present it.
Okay. Mr. Monetis, anything you want to add to the already extensive record you've made in connection with Mr. Jarvis's testimony?
No, Your Honor.
Mr. Rowe?
Okay.
All right. There are two things I need to rule on. First, there is a motion for a Daubert hearing. I am denying the motion. A hearing's not required. A court can be a gatekeeper without one. Based upon the bare bones motion that was filed, I am assuming he provides sufficient qualifying testimony as to his skill set. I am going to permit Mr. Jarvis to testify as an expert in the field of firearm tool mark identification. I do find that that field satisfies sufficiently for there to be some testimony, but I'm going to qualify it in a minute. It satisfies Rule 702, Daubert, cum tire. It is not a novel science. It is a science that has been peer reviewed. It has a fairly low error rate as it's been documented. There are clearly established standards that experts in the field are to follow. However, those standards are very subjective, and that's not meant in a pejorative sense, but it is a little more of an art than a science in some respects, because an expert is offering an opinion that things look similar as opposed to it's 3 microns wide by 4 microns high, that level of science. And again, non-scientific experts are qualified under 702 to testify all the time. But the theory of firearm tool mark identification can be and has been tested. It is a technique that has been peer reviewed. The demonstrated error rate is very low. The standards exist, but they're subjective. It's a generally accepted technique amongst practitioners, and that is a critique of the science in that firearms investigators accept it, but those who are on the outside, scientifically oriented people on the outside, have critiqued the approach as being somewhat circular. They look similar because the experts say they look similar, as opposed to, as Mr. Monetis will likely ask, as he explored with our other expert, it's not that there's a certain concentration of antimony or of lead, and there's a mass spectrometer that identifies lead from its unique isotopic presence. It's not science to that degree, maybe capital S science, but it is certainly a skill set that none of us possesses. And again, if Mr. Jarvis lays a sufficient foundation as to his experience, practice, and expertise in the field of firearm tool mark identification, he can testify to it. And I'm relying in part on United States versus Pete, P-E-T-E, 2024 Westlaw 4040388. That is a very recent 11th Circuit case, which is certainly persuasive here in Georgia, as well as United States versus Hunt, 63 F 4th 1229, a recent 10th Circuit case. Both those cite some compelling district court cases that tell judges to proceed with caution, not that it's not a science, but that there are some limitations to it because of its subjective nature. So here are the limits to Mr. Jarvis's testimony. One, because of the discovery issues Mr. Monetis encountered, Mr. Jarvis may say nothing about where specific shell casings were vis-a-vis this gun versus that. He may say that he has concluded based on his expertise that there were 3 guns involved and that X number of shell casings go to gun A and then gun B and gun C, whatever those numbers are. And he can say based on his analysis, he believes that those 16 all came from the same gun, but he may not say that to a scientific certainty he makes that conclusion. It is based on his application of firearm tool mark identification principles and practices. Mr. Griner, do you feel like you understand the limitations to Mr. Jarvis's testimony? And if not, I'm happy to clarify.
Can you please clarify that last point? You said,
Sure. So if you had a DNA expert, you'd say, what's the degree of scientific certainty that this is a match? 1 in 3 octillion. There's no one in the known universe that matches this DNA other than Mr. X. That is not what Mr. Jarvis can say, nor would I expect him to say that. But what cases that have been grappling with firearm tool mark identification have been sorting through is the degree of scientific certainty. So this is contrasting in engineering. I measured it, and the tensile strength of steel is X, is a known fact, versus a more subjective, a softer science. These appear to me to have all come from the same gun. He can certainly say that. And he can say, I'm very confident using the methodology that I applied that these came from the same gun. Well, I'm not confident, whatever his answer is going to be. But you need to stay away from and so is it a scientific certainty that the shell casings came from the same gun? He is free to rely wholeheartedly on the methodology of what he practices. That does not yield scientific certainty in the same way that that's cocaine. We know it's cocaine because it's atoms and there's no goofing around with it. I mean, the machine could be not calibrated correctly, but they check for that when the GBI does what it does. And there's nothing magic about the GBI. They're private scientists who could do drug identification or DNA work. And there are GBI firearms experts, but the leading edge of the case law is not okay to say with scientific certainty, all these shell casings came from the same gun. Now, we're in fairly safe space here because Mr. Jarvis, even if he was getting in that area that I'm excluding about, and these shell casings were here and those shell casings were there, he's not going to that nearly fatal for any defense. And that gun recovered from the defendant is the one that fired that shell casing. So I'm comfortable with my ruling based on the state of the practice of firearm tool mark identification. And this isn't a case where we get to that. No, I'm telling you, this weapon with the defendant's fingerprints fired this bullet that was removed from the head of the victim. That's not this case. So is that clear?
that part is, I just want to be clear. So part of the way that Mr. Jarvis identifies these different cartridges, if I may just reach in, is, for example, he will pull out one, and this particular object that I'm holding right now, it says Atlanta PD number 14. This is how Mr. Jarvis identifies this particular piece.
Yep.
So would he be able to testify Atlanta PD number 14 was fired from the same gun, I'm just making up an example, as Atlanta PD number 3?
No, what he's going to be able to testify is that I received X number of shell casings, and I examined them, and I determined from the scene that they all came from Atlanta police or from your office. So you can establish what you need to, and I will reject a claim that that's insufficient chain of custody, because in normal circumstances, you could do that with each envelope. This is evidence marker 14. Which gun did it come from? The one I'm calling gun 1. And you could have this nice color-coded chart that has green circles for all the shell casings from one gun, and blue from another, and red from the third. That would be a pretty compelling exhibit, but that uses the information that Mr. Menettis, I find, didn't properly have access to, or Mr. Rowe, but it's Menettis's objection. So he can hold up one of the envelopes saying, I got an envelope, this is an envelope that I got. I opened it, and he can describe whatever he does with the shell casings, but he ought not to testify, this is APD evidence item 14. Generically, he can hold one up, and you can even have him open one if you want, but you should identify it as state's exhibit, whatever exhibit that is. And then he can describe to his heart's and your heart's content what he did with that shell casing, and those like it to conclude that 16 of them were fired from one gun, 12 from another, whatever the math is.
Okay.
So those areas you can explore, but I am directing you not to, even in a single instance, get into, all right, so here's this is evidence marker 13. Which gun did that come from?
Understood. I just need to cover that very briefly with him before he comes in the door.
Sure.
And may I just remove one of these, I'm removing evidence marker number 14. If I could just show him this as an example, we're gonna open it up, but we're not gonna talk about this part.
Not going to talk about what's on the envelope, right? I mean, you can talk about if he made markings on the envelope, but not things that the Atlanta Police Department put on the envelope. And that comes from what? What is the state's exhibit that has the shell casings?
All of these are exhibit 128.
Okay, that's the 31 casings in one live round. Got it. Okay. Okay, yes, you can do that. But before you go, let me just get other things on the record. Did you have any other questions or concerns about my rulings in connection with Mr. Jarvis?
I do not.
Okay. Mr. Rowe, anything you want to add about my rulings as to Mr. Jarvis? Okay, Mr. Manetis.
Thank you, Judge. I'm satisfied with the court's definition of science. And, yeah, as long as the jurors don't get to look at the envelopes and see the numbers on the envelopes or have them read to them, as well as not see the pictures of the cartridges, because those also have, this is item 23, this is item 8 labeled on them. So as long as they're sheltered from that, I think that will be in accordance with the court's ruling.
So I don't know that the jurors won't get those envelopes during their deliberations. We'll talk about that at another time. With this witness, yes to all of your requests. I'm not deciding right now whether those envelopes go back with the jury or not.
Okay, thank you, Judge. And I understand that, and I'll just ask that if we can decide that before I do my closing argument so that I can tailor things according to what inferences they might make based on, how to take them back.
You'll need to remind me. And if we've got a natural break before your closing argument, we'll revisit that.
Thank you, Judge. And the last thing, I have the defense Phillips exhibit 2, and I want to return the state's exhibit 16 through 21.
Great.
And I would ask, could I have just 3 minutes to go to the bathroom and come back?
Yes, we're going to give everyone, in particular Ms. Rivers, a quick break. We're just having it a little early because we needed to have the Jarvis conversation. So during that break, if you or Ms. Porter could talk to Mr. Jarvis about the way in which you're going to need to channel his testimony, that would be great. And I haven't had Mr. Jarvis testify since his accident. Are there any accommodations we need to make, or he's back and ready to go?
Should be okay.
Great.
One last question. There are some notations in Mr. Jarvis's notes concerning brands. Every cartridge casing is a .40 caliber, okay? Even though they're shot from 3 guns.
Mm-hmm.
There are different brands, Winchester, Spear, Blazer, that kind of thing. Would he be able to speak to brands?
Is that literally like it's on, like, I could figure out that it's a Winchester because if I looked at the base of the cartridge, it says Winchester, but there's something that is pretty identifiable as a Winchester cartridge.
I believe it's stamped on the head stamp.
Okay. Yes, you may do that.
Okay, thank you.
All right. People take their break as they need it. I'll be back in a few minutes. All right, Ms. Rivers, are you ready? We are on the record in State versus Parks and Phillips, having had our afternoon break so that we could, outside the presence of the jury, work through the remaining Jarvis issues. Is Mr. Jarvis ready to roll, Mr. Griner?
Yes, Your Honor.
Great. Anything before we bring the jury in?
Not from the state.
Okay, Mr. Monetis?
Right, just one thing before we did our break, we didn't address, in light of the court's ruling, the photographs of the shell casings that are compared that were given to me on the 16th. Those specifically say group 1A and the number, and then group 1B and the number. There's several of them. I'd ask that in light of the court's ruling, we don't publish those to the jury. It's essentially permitting the testimony that we don't want to permit.
Okay, I meant to address that, so I'm sorry if I wasn't clear. I don't know that anything's going to be published to the jury. Certainly, Mr. Jarvis can open one of the envelopes and hold up a shell casing and say, this is what I mean. And maybe they use the Elmo to magnify and it says Winchester, that kind of stuff he can do. But it may be Mr. Griner wants to get into the record other aspects of Mr. Jarvis's work, like his notes, like those photos, so they could be admitted. But I think much like Parks 1, that would be something that would not go out with the jury. That would be consistent with my ruling that the jury not receive something that Mr. Jarvis created, that would be that decoder table. For another time is the discussion about, well, what about the actual envelopes in which the shell casings were placed? We'll have to talk about that, but those won't be published during his testimony. And I meant to make it more clear, I guess, that his photos that he took shouldn't come in unless a door is opened. If his work is challenged and the way to rebut that is to show one of those photos, then you or Mr. Rowe will have invited those photos to come in. Okay, all right.
And okay, I don't know that I'm necessarily planning on putting any photos in because I think that everything is really on this worksheet. So the court would allow me to put this worksheet, which contains the material that my colleagues don't want, put this into evidence, but it just doesn't go with the jury.
Yeah, that's what I'm talking about is if you want to make it part of the record, so it's preserved, should there be appellate issues in this case, that's fine. And so the way you do it is you'd be tendering it. If you can lay the foundation through Mr. Jarvis, I will admit it. And I'll say, we've already had some rulings outside the presence of the jury consistent with those earlier objections. I'm admitting it. And at a minimum, it will be made part of the record. So that's fine as long as you weren't then going to slap it on the screen for the jury to see.
So in terms of these photographs, I mean, to me, a lot of the photographs, putting them into evidence would just be putting the same material into evidence as the worksheet. So I don't intend to go there unless the door is open in some way.
Got it. Thank you for that clarification. Let's bring the jurors in, please.
All right, jurors. All jurors are present and accounted for.
Thank you, Deputy Gordon. Everyone else can be seated. Thank you, jurors. You've been very obliging with the ups and downs and ups and downs. I appreciate your flexibility. We're done with our afternoon breaks, hopefully. We'll see. If you call your next witness, please, Mr. Griner.
Yes, Your Honor, we'll call Francis J. Jarvis.
Take me and raise your right hand. You swear affirm that testimony you will give the truth, the whole truth, and nothing but the truth, so help you God.
I do.
You know you have a seat. Can you state and spell your name for the record?
My name is Jay Jarvis.
Spell it.
Oh, JayJarvis.
Good afternoon, sir. Thank
Good
you for
afternoon.
being here. Can you tell the jury a little bit about yourself, a little bit about your career?
Certainly, I have been a forensic scientist for 45 years as of September the 4th this month. I have a bachelor's degree in chemistry from Georgia College in Milledgeville, which I received in 1978. And then I went to the University of Pittsburgh in 1978 to 79, where I received a master's degree in forensic chemistry. I was then hired by the state of Georgia and went to work on September the 4th, 1979, and went through my training in their laboratory here in Atlanta, which unfortunately that building is no longer exists, but I still exist, even though they've torn my training building down. But I've worked for the state for 32 years and 2 months. And shortly after I retired, I was encouraged by many defense attorneys that I've worked with over the years, and they wanted me to start a private consulting business. And that's what I have been doing since 2013.
And can you tell the jury what kind of consulting business you operate?
Well, it's kind of the full ranges of anything that involves firearms or firearms evidence. They are either criminal cases, civil cases, or sometimes they're the criminal cases can either be for the defense or the prosecution.
During your work with the state of Georgia, did you work with the GBI, the Georgia Bureau of Investigation?
We were a division of the Georgia Bureau of Investigation, yes.
Can you tell the jury in what capacity you work with the state of Georgia? You just kind of provide a little bit of detail there, please.
Well, back when I started, I went through training in a lot of different fields because when wasn't long after I was hired, they planned to open their first a regional forensic laboratory in the city of Macon, Georgia. So I was trained to do many, many things: firearms, tool marks, fire investigation, trace evidence, which included hairs, fibers, shoe and tire impressions, paint, glass, also some drug identification, blood testing, fingerprint work, and also crime scene stuff. So I started long enough ago that I wore a lot of hats.
And since you retired from the state of Georgia and you opened up your own consulting business, have you had occasion to work on the forensic evidence concerning firearms and things of that nature?
Yes, I pretty much had to restrict it to doing firearms work for two main reasons. Number one, firearms being something I did just about my entire career with the state. And number two, it's a lot less expensive to buy the equipment that you need to do firearms identification than it could be if you're starting to do some of these other lines of testing. I could have easily spent $50,000 to $100,000 for equipment if I wanted to do everything that I had been trained to do.
During the course of your career, can you give the jury a sense of how many cases you might have worked on concerning firearms analysis in one way or another?
Oh, I'll just have to give you the same answer I've always given. I never kept records of all the cases I've done. I can honestly tell you, just based on the caseload, when you're working anywhere from 25 to 35 cases a month, I know that I have probably worked evidence in close to 1,000 different firearms related cases.
Sir, did you prepare a CV or a resume of your basic qualifications?
I have at some point in my career. I'm not so sure the last time I updated it, but.
Okay, well, let me hand you what's been marked in State's Exhibit 192 and ask if we can take a look at that. If that at least gives a rough outline. Some of the work.
Yes, this one's got a date of April the 4th, 2022. So this one's probably very correct and up to current line. It talks about my education, my training, and my years of experience and all the training and extra schools that I went to, anything that I've published, and any places I've ever been invited to be a speaker.
Okay. A true and accurate copy of your CV?
Yes, I recognize it because every time it prints out, it puts the current date on it.
Your Honor, this time I'm going to move to the State's Exhibit 192.
Mr. Menettis, any objection to States 192?
No objection, Your Honor.
Mr. Rowe?
No objection.
Admitted.
Sir, have you ever given expert testimony in what are called firearms tool markings or that kind of work concerning cartridge cases?
Yes, I would estimate that being probably the type of case I've testified on more than any others. I would estimate it's somewhere between 750 and 800 times in my career.
Did you give any testimony in court?
In firearms or tool mark identification, yes.
Can you tell the jury a little bit about what we're talking about when we talk about tool identification or firearms markings?
Yes, basically a firearm could very easily be considered a tool. It's a device that is designed to discharge a round of ammunition and propel a bullet or other type of projectile at somebody. And there are a lot of tooling mechanisms that have to be used to create a firearm. And these tools, when they cut the metal, they leave behind very microscopic defects that can put markings on either a fired projectile or a cartridge case. And it's these types of markings that we look at under a specially designed microscope that allow us to make a conclusion about whether 2 bullets or 2 cartridge cases were fired by the same firearm.
So let's kind of start with some basics because not everyone has fired a firearm. Can you explain generally when a cartridge is loaded into a firearm, semi-automatic firearm, how that mechanism works and why there might be markings on either the bullet that travels out the barrel or the cartridge casing that is ejected from by the ejector?
Certainly, when a firearm barrel is manufactured, it has to have something that is known as rifling. And what rifling does, it leaves raised ridges in the barrel with a twist. And what those raised ridges do is they grab the surface of the bullet and impart a spin, a gyroscopic spin to it. So when it exits the end of the muzzle of the firearm, it is spinning. And to give you a great example of, if any of you have ever watched somebody throw a football, if you do not put the spin on the football, you cannot throw it with any type of accuracy. It'll just tumble. A bullet would do the same thing if it didn't have a gyroscopic spin when it came off the end of the muzzle. And that allows it to fly in a straight and accurate manner. And that's what a firearm barrel is designed to do, is to put a spin on a bullet. Now, the cartridge case, when it is struck by the firing pin will leave markings on the primer that are only microscopic in nature. And that will help you identify a cartridge case as being fired from a particular firearm. And then when the bullet exits the barrel, the mechanism of the semi-automatic will extract the empty cartridge case out of the chamber and eject it from the weapon so it can reload a fresh cartridge off of the magazine. So each of these processes can put marks on a fired cartridge case that would allow it to be identified as being fired from a specific firearm.
So, Mr. Jarvis, you testified that you've testified in court as an expert witness between 700 and 800 times at least. Your Honor, at this time, I'm going to move that Mr. Jarvis be recognized by this court and in this trial as an expert in firearm tool mark identification, also firearms and ballistics analysis.
All right. Mr. Rowe, do you want to examine Mr. Jarvis at this time concerning his qualifications?
Okay.
Any objection to having him qualified as an expert in those fields?
Okay.
Same questions for you, Mr. Menendez.
I would like to examine Mr. Jarvis.
All right.
Now, Mr. Jarvis, the state asked you about having testified before in the past. Do you remember testifying in this county this past January 2024 in a case titled "The State of Georgia versus Nehemiah Smith"? Does it ring a bell if it was a case where actually the defendant had tried to use you as an expert and the state was objecting to your work? Do you remember that?
So right now you're exploring his qualifications as opposed to a specific instance of his testimony. So maybe you're about to get there, but this would be voir dire, see what he has to say about his qualifications as an expert, not the state.
Okay. Although there have been times where the state of Fulton County challenged your qualifications as an expert, correct?
Could you give me the date on that again?
Yes, so January 22nd, 2004 this year.
2024, January 22nd?
Yes, sir.
I'm pretty confident that that is not something I remember because I was still in a hospital in Chattanooga, Tennessee on that date.
Okay. Actually, I think I got the date wrong because that's the date that it was filed. I'm sorry. But it would have been, I guess, shortly before then, sometime in 2023. Do you remember that?
It's not really ringing a bell to me, but again, if you could give me a better date, could either.
Well, how about this generically? Do you recall an instance when you were proffered as an expert by a criminal defense attorney and the prosecution, whether it's Fulton County or any other jurisdiction in Georgia, said, no, we object, we challenge Mr. Jarvis's credentials?
Honestly, Your Honor, I do not recall that ever happening in my career.
Okay.
Okay, I'll move on. It's fair to say that you talked about the tools that you use. They're not as expensive as some other kind of analysis. Is that because this involves a lot of visual interpretation and it's essentially like a lens that you're?
So again, this is his qualifications. It's not about the nature of the work involved. That would be something that will go to the weight of his expert opinion, and I will not interfere with your ability to do that when it's your turn. But the state hasn't even presented his substantive testimony. The threshold question was, did you want to effectively challenge Mr. Jarvis's qualifications as an expert in the FTI field? And I welcome you to do that if that's what you want to do. But getting into, is this a more subjective science or less subjective, isn't for right now.
Okay, and Your Honor, may I examine him on his present ability to serve as an expert?
You can start there. We'll see where it goes.
Okay. Mr. Jarvis, I had heard that sadly you suffered an accident sometime in 2022. Is that correct?
It was 23. It was November the 14th, 2023, to be specific.
Okay, I'm sorry to hear that. And what exactly was the impact of that? What happened?
I fell rearward out of pretty much stupidity on my part, but I did hit my head on a concrete driveway.
Okay, sorry to hear that. And
I am too, actually.
and did you go through any kind of treatment for any traumatic brain injuries over that?
That's what I am told. I don't have specific memories of the first 36 days of treatment, but I clearly know that for whatever it's worth to anybody, including yourself, God Almighty told me He healed me.
Okay, well, I'm happy for that. You made this report in July of 2023. And we've heard that it's a visual comparison, and I noticed that you're wearing corrective eyeglasses. Are you able to share with us when you made that report, when the last time it was that you visited an optometrist or had your vision checked?
The last time I believe I've been to the eye doctor was sometime March, April, or May of 2024. I believe it's been sometime this year.
Right, and what about at the time that you made the report in this case?
Oh, I didn't have any difficulty back in July of 2023 when I conducted the work on this case.
No, I understand that, but at that time, just like you shared with us when you last went to the optometrist, at that time in July, when was the last time you had been to the optometrist to try to maybe adjust your glasses or anything like that?
You know, I typically, to the best of my knowledge, I usually go to the eye doctor somewhere every 2 to 3 years for just a general examination. You know, if I have some sort of a vision problem, it's usually pretty obvious to me pretty quick.
Right. And this examination involved a microscopic examination, is correct? Looking at microscopic?
Yes.
Okay. Your Honor, those are all my questions.
All right. So my second question to you, Mr. Menendez, then is, do you have any objection having Mr. Jarvis qualified as an expert in the field of firearm tool marking identification and ballistics and firearms in general?
Not in general, Your Honor, just to the conclusions of his report. I guess we that.
I guess we will. Mr. Jarvis, I find that you are an expert for purposes of these proceedings. You are qualified as an expert for the purposes of these proceedings in the field of firearm tool mark identification, as well as ballistics and firearms generally.
Thank you.
You're welcome.
Mr. Jarvis, when we talk about a cartridge, can you just explain to the jury what the different parts of an unspent cartridge would be?
Certainly. Your typical cartridge consists of several components. There is a cartridge case, which has a primer attached to the base, and then there will be a certain amount of gunpowder inside the cartridge case, and then the bullet or projectile is fitted in the open end and crimped so it stays in place. So what happens basically, the firing portion of the firearm strikes the primer with something called the firing pin. And by striking, there is a compound in there that when it feels the friction of the firing pin hitting it, creates a spark, which ignites the gunpowder inside the cartridge case. And the swift burning of the gunpowder is what creates the pressure to force the projectile or bullet down the barrel of the firearm.
So in layperson's terms, is it more or less an explosion that occurs in that little cartridge case?
I'm not sure that that's the proper term. It's basically, the gunpowder burns very easily and very quickly and high pressure and high heat. So it's really the burning of the gunpowder. It just creates a tremendous amount of pressure and gas.
When the bullet exits the end of the barrel, is the projectile or the bullet the only thing that exits into the barrel, or are other things, these gases and other things also released?
There will be hot gases, as well as either partially burned or unburned gunpowder particles, as well as some of the components that were in the primer that can also exit and land on whatever object is close enough.
Okay.
Bless you.
Concerning this particular case, did you receive some evidence in this case?
Yes, I did. I received evidence on July the 24th, 2023.
And can you tell the jury who you received that evidence from?
It came from Investigator Joseph Rickman, who worked here at the Fulton County District Attorney's Office.
And what evidence did you receive?
It was three large, what I would consider to be a brown paper bag, evidence bag. One of the bags contained multiple items, 32 separate items. The second bag, another brown paper bag, it contained 3 items. And then the third bag, which was another brown paper bag, it contained 1 item of evidence.
I'm gonna hand you what's been marked and already put in the evidence, the State's Exhibit 121. Ask if you can look, or I'm sorry, 128 rather. You can look at State's Exhibit 128 and tell us about that.
Okay, State's Exhibit 128 is one of the brown paper bags that has stamping on it that identifies it as an evidence bag, and there's lines that are printed on there so it can be filled out appropriately by whoever's collecting it. I can identify this by the handwritten case number, which I've placed on the outside of the bag, which in this case was 2023-CR-072401. 2023 obviously being the year, CR meaning it's a criminal case, and 07 the month, 24 the date, and the 01 would be the first case I received that day. And this particular bag was designated as item 1 from my records.
I hand you what's been marked and put in evidence. State's Exhibit 153 and ask if you can look at that, please.
153, very similar. Again, marked with my case number personally, and then this one was designated as item number 2, and it's State's Exhibit 153. Very similar sized bag, just obviously does not have near the quantity of items in it.
Show you what's been marked, placing it into evidence already is 171, and ask if you can identify that.
Yes, State's Exhibit 171, again, another very similar sized brown paper evidence bag. Again, has been assigned the same case number, and it was subdivided as item number 3. Again, doesn't have as much quantity in that. I think this is the one that only had 1 item in it.
Let's talk for a moment about how you receive these items. When you receive these items, are they sort of taped and packaged up in a tamper-resistant sort of way?
Yes, these 3 bags all had red colored evidence tape. And I could see like where whoever sealed it usually initials across the seal. So they were all, in my opinion, properly secured and sealed.
At the time you received those bags, did you see any evidence of tampering?
Not on the outer packaging, nor quite frankly on any of the packages that were inside.
So when you received those into your lab, can you explain to the jury what you did next?
I take photographs of the items in the appearance that they have when they first come in. And I would take a picture of the front side and then flip them over and take a picture of the back side. So I have documentation so I could show and remember what condition these items were when I received them.
And then what's your next step when you actually begin your analysis?
It would be to open each one of these packages, typically in a brown paper bag. I do not like opening the original seal. I prefer to take a scalpel and cut open one end of the bag, and then I can take out each individual item in there and line them up and take photographs of the front and back side of each of those packages as well. So I have documentation of what condition they were in when I first received them.
After you have done your work, we're going to come back to what you did. But after you've completed your work, you package up these items again in the same evidence bags and initial them and everything else?
Yes. If there are smaller containers, they're all repackaged in their same containers. And I use a green colored evidence tape because I very rarely ever see green evidence tape on anything that comes in. So I like green because it's so distinctive. And I have it special made. It has my markings and name of the company, and the logo is printed on there. So it's very easy when I see it that I say that's my evidence tape. And then I initial and put the date that I seal it.
And just generally speaking, did you actually analyze the materials that were presented to you in those 3 bags?
I did.
Did you have an opportunity to reach any conclusions after you had conducted your analysis?
I did.
And did you write up an official report concerning your results?
I did. It was dated July the 26th, which was 2 days after I received the evidence.
I'm going to hand you what's been marked as 193 and ask if you can identify that, please.
Yes, this is the 3-page report that I issued on the analysis that I did on the multitude of items that were in all 3 of these bags.
Through an accurate copy of your report?
Yes, it is.
Your Honor, at this time, I'm going to move to the next case, 193.
Mr. Manettis, subject to discussions we've had outside the presence of the jury, any objection to the admission of states 193?
No objection, Your Honor.
Mr. Rowe?
No objection.
Admitted.
Let's kind of talk through the basics here. Mr. Jarvis, can you explain what you did concerning, just tell us, just begin, if you would please, telling us what you did.
Well, when you open a bag that relatively what I would consider to be a medium-sized evidence bag, but it was very obvious to me even before I opened it, it had a lot of things in it. And when I sliced open the bottom and spilled out the large number, there were 32 small manila coin envelopes, each one that contained an item of evidence. And with one exception, they were all fired cartridge cases. There was only one that was a live round or unfired round. And being a scientist, when you see that there are over 30 fired cartridge cases or shell casings, your first thought is, were they all fired by the same firearm, or were 2, 3, 4, 5 multiple firearms used to fire all of those? And that's my first question that I try to answer.
Okay, and so how did you go about trying to answer that?
opened each of the package one at a time and lined them up in a way that I could easily identify one from the other. And then I would start by selecting one and then compare it microscopically with all the additional items to see if I could see enough similarity in the tool markings that were placed on those cartridge cases, either by the breech face or the firing pin. Just could I tell that these were obviously fired by the same firearm? And I would work my way down that row of items, and the ones that appeared to be fired by the same firearm were placed in one grouping. And then I moved on and worked with the others to see if they were similar or different, or was there a second weapon? And then when those were identified, I would move to the third group and do similar thing. And I would continue this until I could satisfy myself scientifically as to how many different firearms were used to fire all these fired cartridge cases.
Okay. So you testified earlier about the barrel of a gun and how during the manufacturing process, the grooves are made a little bit different in every gun, right?
Correct.
Can you explain to the jury about cartridge casings and how they're ejected and how two different guns, same model, same manufacturer, everything came off the same production line, how they may or why they may eject and put slightly different marks on a casing as they are fired? Can you explain that?
Certainly. Well, the firing pins that are manufactured for firearms, the process that's used, whether to cut the steel or to make a hemispherical surface on the rod to be a firing pin, the tools that are used to do that, every time those tools are used to grind a metal surface, they are changed microscopically. So even two firing pins that are made one after the other are going to have microscopic differences to them. Same thing with a barrel of a firearm. Every time you manufacture a firearms barrel with rifling, the force of the rifling tool grinding or making marks on another piece of metal, the microscopic characteristics of that surface is going to change. Same is also true for the little grip that's called an extractor that pulls the empty cartridge case out of the chamber after the bullet has exited. It will pull it out, and then there's a second device called an ejector that kicks the cartridge case up and out of the opening in the breech face and out of the weapon, which allows it to load another one. All of these metal components are unique, even if they're made one after the other, because the tools that are used to create these surfaces will change the microscopic marks from one to the next. That's just the way tools work.
And do you use in your lab the same processes that you were trained and you used for all those years with the state of Georgia?
Yes, in fact, the microscope that I currently use is physically identical to the one that I was trained on starting in 1979.
So if I have a single handgun and I fire it, say 10 times, will all 10 of those cartridges be ejected and have similar markings showing that those cartridge casings were ejected from that one firearm?
Yes, I would expect that to be absolutely true, yes.
And if I had the same model, same manufacturer, make a second handgun and I fired 10 casings out of that second handgun, would those casings be different from the first casing from the first gun?
Yes, I would also expect that to be true, having participated in enough training exercises during my career where firearms examiners who have written reports that have been published in scientific journals where they would take weapons that were made one after the other in a particular firearms manufacturing plant like a Ruger, and they would do studies where they could show the drastic difference between cartridge cases of bullets fired out of the first one versus the ones that are fired out of the second one. Even though they were made one after the other, they mark the bullets in the cartridge cases microscopically differently.
Are there ever times that there might be a cartridge casing that is recovered and just for whatever reason there are not sufficient markings on that casing to try to match it? Does that ever happen?
I cannot think of any instances in my career where there were not sufficient markings unless the bullet of the cartridge case had been seriously damaged either by impact or being run over by a mechanical bulldozer or run over by a car or a rolling thing that they would use to put, new asphalt on a street, that could conceivably could destroy markings on a brass cartridge case, for example. But generally speaking, I don't expect them to disappear unless there was something that has taken, damaged them to the point to where the markings were no longer visible.
Let's talk, let's kind of compare that to a projectile. Bullet comes out, speed out of a barrel. Are there instances in which that projectile may be deformed or damaged in such a way that it cannot be identified or it's not of identifiable quality?
Yes, again, it's based generally on whatever impact it has. If it has impacted a bone in someone's body, for example, sometimes can destroy the surface where that you would expect to see the markings. If a bullet enters a body and exits a body and then hits a concrete wall, that can sometimes destroy it enough to where you cannot see the microscopic markings.
As you were working with these different pieces of evidence, did you have notes that you were using? Or did you have some kind of worksheet or something that you were working?
I think I was referring to my report when I was looking at these, but I do have the worksheets that I completed when I did my testing.
I'm going to show you what's been marked in 6 Exhibit 193A and just ask if you can identify that.
This is 5 separate sheets. The one on the top is the worksheet that I filled out for each of the cartridge cases or the one fired cartridge. And then the second page is the worksheet that I filled out based on my examination of the 4 projectiles. And then the last 3 pages are the notes that I keep as I take photographs of any of the evidence during my analysis. I make a notation so I know what I took a picture of on photo number 1 and what I took on photo number 2. And this then helps me later when I want to put numbers and markings on each individual picture so I can identify what the picture is.
Okay. Your Honor, this time I'm going to move for the purposes of court exhibit, 6 Exhibit 193A. For the purposes of a background exhibit.
Okay. Mr. Manettis, any objection beyond things we've discussed outside the presence of the jury to the admission into the record of states 193A?
No objection, Your Honor.
Mr. Rowe? Okay, it's admitted.
Okay, so Mr. Jarvis, let's take a look at actually what you did in some of these evidence bags and stuff here. Let's look, for example, at State's Exhibit 171. If you could just take a look at State's Exhibit 171 and tell us what you did with that bag.
Of course, I would cut it open so I could retrieve the item from the inside. It was a smaller, like a manila coin envelope size. And again, it's sealed with the same type of evidence tape. And again, I would cut it open again with my my little scalpel and then conduct the testing on the item inside. And then once that testing is completed, it's placed back in that original container. It's sealed with the green evidence tape, and then it's placed back in the outer container. And the cut that I made is sealed with evidence tape. And again, I initial it and put the date that I've sealed it on.
Okay, and did you do a similar process with State's Exhibit 158?
153, I believe that is.
I saw it wrong. 153.
Same procedure. This particular thing had 3 small manila envelopes.
And how about this exhibit here, 120? Similar situation?
Yes, that had a total of 32 separate manila coin envelopes inside.
And so let's just open this up. It's already been opened before. Let's just open it up, and if you'll just lift something out, doesn't matter which one, we'll just pull something out and show the jury what we're talking about.
Feel like I'm pulling a winning ticket out of something here. My goodness. All right, we'll pull this one out. You know, it's what I would call a coin envelope, a manila coin envelope. You can see again, just like the outer bag, it is sealed up with the red colored evidence tape. It also bears a label that was placed on at some point with a barcode. And then it also bears the laboratory case number, which I placed on there, 2023-CR-072401. And this particular one was sub-designated as item 1A.
Okay, so let's talk about, when you say sub-designated, is that your own designation?
Yes.
Let's talk about how you divided these things up after you've done your work. What if any, what were you able to determine out of the 32 manila colored envelopes, smaller envelopes inside of State's Exhibit 128? What conclusions did you reach?
Well, based on conducting the comparison of all of these items to each other, I was able to conclude that the total number of fired cartridge cases, which was 31 fired cartridge cases and 1 unfired cartridge. Based on the microscopic examination I did of all these fired cartridge cases, it was my opinion that the 31 .40 caliber cartridge cases had been fired by 3 different firearms.
Were all 31 the same caliber, 40 caliber?
That is correct, yes.
And the unfired cartridge, was it also a 40 caliber cartridge?
Yes, it was.
Did you reach any conclusions about how many weapons had fired these 31 cartridge cases?
It's my opinion that they were fired by 3 different weapons, but based on the shape of the firing pin, which was a wedge-shaped firing pin, it would be consistent with either being fired by a Glock 40 caliber pistol or a Smith & Wesson 40 caliber pistol. as both manufacturers use a wedge-shaped firing pin on a 40 caliber pistol.
Okay. And were you able to, if we just say A, B, and C, gun A, gun B, gun C, can you tell how many cartridges were fired by gun A?
Gun A would be 12, gun B would be 16, and gun C would be 3.
Let's talk about the projectiles that you looked at. So one of the envelopes contained 3 different double jacket, or you tell me, one of them contained 3 different projectiles, is that correct?
Yes, they were each individually packaged, but they were all copper jacketed, 40 caliber size based on their appearance and total weight.
Were they suitable for comparison purposes? Could you compare either of those projectiles with each other?
The only thing I could determine and look at the microscopic examination of these was that they had what I would call polygonal rifling, and that rifling is most commonly found in Glock 40 caliber pistols and some of their other calibers, whether it be 9mm. But these were all 40 caliber, and Glock uses polygonal rifling.
The package containing a single projectile, were you able to get any information off of that, or was it suitable or unsuitable for any kind of comparison?
The only thing, again, I could tell about the one that was packaged singly was that it was also a 40 caliber based on its appearance and total weight. But I was not able to identify enough individual markings to be able to compare them to any of the others.
The unspent cartridge, did it have same kind of tool markings on it, or was it examined that way?
Since it had not been fired, I did not examine it extensively to see whether it had any type of an extractor or ejector mark on it. I'm usually looking for the type of markings that would indicate to me that it had actually been fired, like a firing pin mark or a breech face mark. Anything like an extractor or an ejector mark does not mean that the thing was fired. It just meant that it would work through, it was pulled out of the chamber and ejected. So to me, I'm looking more for the firing pin and firing mechanism markings, because to me, there's more significance to those because they indicate that it had been fired.
3 guns, one fired 3 times, one fired 12, and one fired 16. Is that correct?
That is my opinion, yes.
Sir, thank you for being here. I don't have any further questions at this time. The defense team may have some questions.
Mr. Manettis, do you have questions for Mr. Jarvis?
Yes, sir, I do. And then I did want to approach very, very briefly about double checking one thing.
Before you ask your questions?
Just one thing, Judge, yes.
Is there something you want to show me, or?
Yes,
Okay,
I can just approach.
why don't you come right over here? Mr. Greiner, why don't you come to me?
It's just every single case.
And what he does with it, I think, on its own. I can't tell you, it alone wouldn't, it depends what you do.
Good afternoon again, Mr. Jarvis. I'm going to approach and hand you something. Recognize what I'm handing you?
It's one of the photographs I took, yes.
How do you recognize it? So,
It's got my case number, which I've added to it electronically.
it doesn't appear to be altered in any way.
No, it looks just like I remember.
Right, at this time, I motion to enter Phillips Defense Exhibit 3.
Any objection, Mr. Griner?
No, Your Honor.
Mr. Rowe?
Object.
Admitted.
So you can share with us that this was a picture of just all the shell casings that occurred.
Yes, and also the live cartridge or live round is on the bottom row.
Okay, thank you.
I could easily point it out because it does not have a firing pin mark on its primer.
If he needs you to, he'll have you do that.
Understood, sir. Thank you. Now I want to start off by asking you about some certain organizations. Are you familiar with the ANAB, standing for the ANSI National Accreditation Board?
I've heard of it, yes.
Okay, and then ANSI stands for American National Standard Institute.
I believe that is correct, yes.
Okay, and you've also heard of NIST, the National Institute of Standards and Technology.
I have heard of them, yes.
And that's a federal body, correct?
I believe it is, yes.
Okay, and they put out a series of standards for laboratories.
Them and other organizations, yes.
And then we can't say whether or not you follow those standards, correct, in your ARMA forensics laboratory?
Well, I do have a series of procedures that I use, having been a member and the chairman of an organization called the American Society of Crime Laboratory Directors Laboratory Accreditation Board. I participated in many accreditation inspections of crime laboratories all across the United States.
And I understand that, but my question is, you are not going to tell us that you follow the National Institute of Standards and Technology standards for cartridge comparison. You follow what you just shared with us.
I followed what I was taught in my career, which has lasted over 40 years.
Right, and so not including NIST, but you are aware that NIST puts out pretty regularly updated standards, correct?
I don't know that I've ever seen a standard by NIST that tells you how to conduct bullet or cartridge case comparisons. I don't know that I've ever seen them do that.
Okay, and so what you're sharing with us is that the methods and standards that you're using are similar to the methods and standards that you had been using 45 years ago.
Yes, I had all the procedures that I was supposed to use to do any type of work related to firearms evidence. I had it all written down as part of the operations manual that I used.
Okay, and now I want to go back to the prior hearing in Fulton that I'd asked you about. I found the actual date. If I told you it was on June 13th, 2023, here in Fulton County, would that ring a bell? The state of Georgia versus Namias Smith?
I'll have to apologize. I really don't, it's not right on the top of my
Okay, that's
head on
understandable.
that.
That's
But
understandable.
maybe if you could tell me a little more, I may have more recollection.
Right. Would it refresh your recollection if I showed you a certified copy of the transcript and you could read through it and?
We're gonna have him read an entire transcript right now while we sit and watch.
No, Your Honor. I just want him to flip through it and see, does he remember this generally? His part's not all of this. I just, out of completeness. Would that possibly refresh your memory if you could just flip through real quick? Not, don't read every line, please, but
Oh, no.
you can flip through real quick and see if you do remember that June 13th hearing last year in the Nehemiah Smith case here.
Yeah, unfortunately, Nehemiah Smith doesn't really ring a bell for me, but if I could just maybe look for 10 or 15 seconds, I might have memory.
I appreciate that.
Is there a place he should start? You claim that
Yes.
that is not the,
Okay.
that
I'm with you.
transcript is more than just his testimony.
Yes, his testimony, if you could look to that, would be starting on, there's a.
You have a
table of
copy for the
contents.
state?
I don't have an extra copy of this for the state, no.
Why don't you get it to Mr. Griner first so he can look at it before you share it with the witness?
Judge, this is over 100 pages. I'm not sure where.
Well, it sounds like he'll direct him and he can refresh his recollection with a phone book if he wants to. You're just entitled to see it before it happens. Why don't you tell Mr. Griner the part of the transcript that is relevant so he can take a look at it with no advance notice either.
Yes, Your Honor, there's only two relevant pages. Mr. Jarvis's testimony is on page 15 to 44 of the transcript, and the relevant pages are merely page 29 and page 40.
Judge, I don't need to see anyone.
Okay, let's get it to the witness, please.
So, Mr. Jarvis, your testimony is on pages 15 to 44. Would you mind just, flipping through them real quick, just to see if that rings a bell, the hearing that you did?
Yeah, I think I remember it now. Once I saw some names on the front page, just to be very brief in general, I took exception to some of the work that was done by one of the firearms examiners at the Georgia Bureau of Investigation. Not only the work, but the conclusions he raised based on his testimony. And I was asked by a defense attorney to come and speak at a hearing in Fulton County to express the reservations I had about the conclusion that Mr. Tanner had come to and testified about.
Okay, thank you. I'm glad that you remember now. And so essentially, GBI is the Georgia Bureau of Investigation, correct?
Yes, it's who used to be my employer.
Thank you. And the GBI examiner, that's whose findings you were saying you found to be unreliable or inaccurate in some way.
I would not have given the testimony he gave.
Understood. And now that you remember that hearing, isn't it true that during that hearing, this exact office, the Fulton County District Attorney's Office, through one of its assistant district attorneys, spent a lot of time challenging you, challenging your accreditations, the quality of your work, the reliability of your results? It was someone from this office, Fulton, that was challenging you at that hearing, correct?
Judge, I have to object at this point. This is in the context of a motion for new trials now up on the field. And I think that it's being mischaracterized here. Got 100 pages and trying to boil it down into a soundbite, and that's not fair.
What's relevant is what happened in this case and not an extrinsic example of what may have happened in another case. So I'll sustain your objection. We should move to another topic.
Yes, Your Honor, it just goes to bias or credibility, but I understand the court's ruling. You are not, your ARMA forensics lab is not accredited, correct?
That is correct. I could not afford to pay $10,000 to $15,000 a year now to have my laboratory accredited. especially considering the fact that I used to be the person who signed the accreditation certificates that was issued by the organization that I used to be the chairperson of. So I felt very, very qualified to do work that was subject and okayed for the work that I did. I did not feel the need to have that done.
Okay, understood. And for example, let's say someone feels very, very qualified to drive an automobile. They don't just get to give themselves a driver's license. They have to take an exam, correct? By an examiner?
Which I have done at age 17.
Thank you. And so not only were you not accredited at the time of writing and doing this examination, you've actually never, your lab has never been accredited.
That is correct.
Okay.
I have personally accredited other laboratories.
Now, I want to move on to one of the state's questions. So we have three groups that supposedly were fired by the same gun. And isn't it true that within each of those groups, there are different brands of casings? They're not all the same brand of casing in each.
Correct. There were multiple different brands, which is not unusual based on my experience.
Okay, but not unusual, but that would entail is that gun that you say is firing all of those cartridges, that means that different brands of bullets were in that gun at the same time.
That's entirely possible, yes. And, we went through a period in the United States where it was very difficult to find ammunition and people were, buying ammunition at wherever they could find it. And it was not unusual when working cases that if you got a firearm and a magazine and you emptied that magazine out, it was not unusual for there to be 2, 3, 4 different types of brands of ammunition in it. It was not unusual at all.
Right, and you don't have any personal information about where the ammunition in this case was obtained from, correct? Like where they was.
No, I just know that it was collected somewhere and packaged up and brought to me. That's all I know.
Okay, and your work was in the comparison, right? Nothing about the ejection or how the behavior of different guns would eject cartridges in different ways and how far they go. It's nothing like that, correct?
No, and that's difficult to do unless you actually have 1, 2, or 3 firearms to do tests with, where you can shoot some live ammunition and then you can record where the empty cartridge cases go. And a lot of times the surface those cartridge cases land on also plays a very critical part in where the cartridge case is going to wind up. Because if it's ejected onto a lawn, the likelihood of it bouncing and going is almost non-existent. But if it lands on a paved road or a concrete driveway, it can hit and skip. So it's to do a perfect scientific test, you have to have the gun and know some knowledge about the surface where the shooting took place.
Right, and your conclusions in this case are limited because we don't have any guns to compare any of the casings to.
Correct. I mean, the only thing that I know from shooting firearms over 40 years is that generally speaking, they usually always kick out to the shooter's right and slightly rearward, generally.
Okay, and generally revolver cartridges don't eject because they stay in the revolver.
Correct, unless the person has to reload and at that time they swing the cylinder out and they have to push the rod and eject the cartridge case, and they usually they fall in one little wad.
Okay, thank you. And you testified here that the 3 pistols that are supposedly used are all similar types, correct? They're similar types of pistols to each other?
Similar caliber, and both the Smith & Wesson and the Glocks use those wedge-shaped firing pins.
Right, and that makes your comparisons harder to do than if they were more different from each other, the guns and the caliber.
Yeah, ideally, if you want to come to a conclusion, you want to actually test fire the weapon that's been used.
I'm confused now. what Mr. Manetis just asked was, I thought, hey, if it turns out all three of those guns were Glocks, we don't know, but pretend they were Glocks. The fact that they were all Glocks makes your work in saying these shell casings came from different guns more difficult because Glocks are similar. Whereas if it was a Taurus and a Glock, it would be easier for you to say, these shell casings went from this gun and these shell casings go to that gun. That's how I understood his question. And you said something about it'd be better to have the guns. What's the answer to my question? Is the fact that these two guns were either Smith & Wesson or Glock, so could have been the same manufacturer. Does that make it more difficult for you to link shell casings to a unique firearm?
Linking a cartridge case to a unique firearm requires you to have the unique firearm to get test fires out of.
Okay, I asked it poorly. Your conclusion, as I understood it, was that there were three different guns that fired all those shell casings.
Correct.
Okay. Is it easier to segregate the shell casings into those three piles if you have known different manufacturers? You don't have the guns, but someone said, hey, I had a Smith & Wesson. Someone else said, I had a Ruger. Does that make it easier to do it, or it doesn't matter the make and model of the gun when you're determining this came from a different gun than that?
It doesn't matter to me because two firearms that were made by any company, one after the other, have very unique and distinct markings.
Okay. Thank you.
I hope that helped.
You helped me. I was the one confused. Other folks probably were not confused, but
Thank you,
I
Judge. That
was.
was my question. And so I understand that it doesn't matter to you, but as an expert, would you say if you gave that task to someone else, is it harder if they're more similar manufacturers, or is it easier if they're more similar manufacturers? Not for you, but if you're to give the task to someone else.
Well, it's like a lot of things. The more experience you have, the easier anything is. If you're a relatively new forensic firearms examiner, just like I was when I first started, I had a experienced person that oversaw everything I did before I was working cases independently. So it's very much dependent on your experience. And the more experience you have, I think the better you will be.
I understand that. My question is like the question the judge asked. So let's say we have two people hypothetically with the same level of experience. They're not you, but they have the same level of experience, or just anyone. And in your opinion, if you were to give them like a quiz.
What's the relevance of what a different firearms examiner would do? We've got our firearms examiner, can challenge him, support him, do whatever you want, but what's the relevance if Fred Jones with a different level of experience would struggle or not struggle?
Well, I'm trying to get the answer to the court's question, because my understanding of his answer to the court was, well, it doesn't matter to me. It's not easier or harder to me because I'm so experienced.
Okay.
I'm just wondering about the court's question, an answer to that.
I'm interested in what he has to say and not a hypothetical, not present in this courtroom firearms examiner.
Well, I understand it. I'm just trying to answer the court's question, but I can move on.
Okay.
So the equipment that you say is cheaper than doing other kinds of analysis, the equipment is basically kind of like a telescope, right? It's got two lenses and you use your eyes to look through the lens. And you see a microscopic image, like a microscope of these lines.
Yeah, the type of equipment that we use is called a comparison microscope. And it's basically two microscopes that are linked together with an optical bridge, which allows you to view the item on the right side microscope and align it next to the one that's on the one on the left. So you can look at two things where the images come up, link across and come into the eye, and you can look and you can see the one on the right and the one on the left, and you can line them up. That's what we use when we're doing comparisons. If we have a gun, we test fire that gun in a laboratory test area where we can recover bullets and cartridge cases and put them in a separate package as test fires. If we have the gun, we can compare them using the test to compare with the ones from the crime scene. But when there are no guns to compare, all we can do is compare all the ones that were collected at the crime scene by the police and give an opinion as to whether they were all fired by the same gun or they were fired by multiple guns.
And your opinion then, the way you described it, that involves human interpretation, right? It's not a scientific calculation. It's your human interpretation based on what you're seeing through this instrument, correct?
Yes, and I've been a scientist as long as I can remember. I mean, I became interested in science when I was in the 6th grade. And that was a long time ago.
Right. And that, my question wasn't whether you're a scientist or not, and I'm interested in science too. My question was, although you're a scientist, what you compared is not a scientific calculation, right? It doesn't involve chemistry or physics or anything. It involves what you're seeing. Although you're a scientist, it involves what you're seeing through this telescope, correct?
Yes,
Okay, thank you.
vision's a part of it, obviously, just like any other scientist would use their vision to look at something.
Right. The instrument isn't measuring the lines or doing any kind of measurements, correct?
No, you're doing a visual comparison. If you have 2 cartridge cases or 2 bullets, you line them up so you can see the strias on one right next to the strias on the other. So it's the ideal way to do that.
Right, and there are ways now, though, to use computers and microscopes that can look at a computer-generated image and use the computer to decide how similar or not similar these lines are, correct? Doesn't that exist now?
Oh, I'm sure it does, but it's certainly way out of my ability to purchase.
Understood, but it does exist.
Yes, and
Okay.
visual is all I've ever done.
Okay, thank you. And so you already answered my next question, though, no chemical testing, no high-tech instruments, no physics. You mentioned something about a journal and a reviewed journal. When you mentioned the journal, that wasn't a journal published by like a university, like University of Georgia. That's something published by the government, correct?
It was by the Association of Firearm and Tool Mark Examiners.
Okay, the Association of Firearm and Tool Mark Examiners, not any kind of university or academic institution.
No, actually, the earliest work that was done in this field was done by Dr. J. Howard Matthews, who happened to be the head of the chemistry department at the University of Wisconsin.
Well, right, head of the chemistry department. What I'm asking is, there's no firearm tool examiner department at any university, correct? This is a community of examiners separate from that.
Well, Dr. Matthews was certainly a scientist. He ran the chemistry department at a state university and published 3 volumes that taught anybody that wanted to learn about the field of firearms and tool mark examination.
Well, right, but firearm and tool mark examination does not involve chemistry.
So you've established that, and not physics either.
Right.
Okay, next question.
Okay, and just to be clear, I'm not contesting that this person was a scientist and got his PhD in chemistry, but I was asking you something else, but I think the court wants me to move on. Now, you don't have any familiarity with the chain of custody apart from who it was that brought you the casings, correct? I think you said it was Officer Rickman.
Correct.
Okay. And you didn't have any involvement in the actual crime scene collection, it's strictly just getting it from law enforcement?
From the district attorney's office, yes.
Or from the district attorney's office, okay, but not from the scene or having any involvement in being on the scene with anyone or collecting.
Generally, I can usually find that information that's on the package if I needed to know that.
Okay.
Because
Now-
that person's name is on the package who collected it.
Understood. And just last thing, we had met the other day and you shared with me that you're thinking about retiring soon.
I mean, I guess you lost me on that one. I mean, I retired in 2011 from the state, but I started doing my private laboratory in 2013. Again, quite frankly, because of the insistence by so many of the defense attorneys that I have dealt with in my career, they didn't want to see all that knowledge and experience to just get flushed down the toilet. They wanted me to make that available to them because there were a lot of times that they needed experts to re-examine stuff that the state did.
And Your Honor, I would move to strike that as speculation. We don't have personal knowledge about why any of these defense attorneys hired him.
You can ask your question in a different way, but you got personal by asking him about whether he was going to retire, and he shared with the jury his journey through this profession.
Understood. And so when you say private, you mean for a profit? That's not your only motivation, I imagine, but that's an aspect of it. These defense attorneys pay you money to reach your supposed conclusions?
Well, they sign a contract, and when I'm done, when the case is completely done, I send them an invoice and they pay. I don't require money up front for anything.
Right, but there's money involved at some point.
Well, for the services that I provide, yes.
Right. And so.
Just like you, I assume.
Of course. And so, though, when these defense attorneys, you do work with them, they get to see the results before the trial, correct?
Oh, yes, absolutely.
And so it's their decision whether to use it or not.
Oh, yes, that's always been true.
Okay. And this is through just your laboratory, the ARMA Forensics?
Yes, it was, that name was chosen because it starts with the letter A, which is good for advertising. And number two, the word ARMA is Latin for the word firearm. So it seemed like an appropriate choice.
Okay. And that's the same one we mentioned that's not ever been accredited?
Yes, it has never been accredited.
Okay. Those are all my questions, Your Honor.
Mr. Rowe, do you have any questions for Mr. Jarvis?
A few, just not extensive. Mr. Jarvis, you indicated that you received the material from the district attorney's office in 2023?
Yes, July the 24th, 2023. Yes.
All right. You also testified that since your lab is not accredited, are you required to receive any type of continual education or updated techniques with your field?
Well, I subscribe to certain publications, including the Association of Firearms and Tool Mark Examiners Journal, as well as a multitude of firearm magazines where I can keep up to speed on new firearms that are being manufactured and sold, and well as ammunition.
Okay. You testified that you've been using the same technique for the past 30 years. Is that correct?
My document that I prepared that's got my procedure manual, I developed that, I believe, in 2013, which was the time that I actually became an official business according to the state of Georgia.
You would agree with me that technology has advanced greatly since the time period since you started your initial analysis and evaluations, correct?
The visual comparison of markings on bullets or cartridge cases in my opinion, has not changed drastically at all if an individual is going to do it. Now, are there computer systems that can compare fired bullets or fired cartridge cases that if it's run by the federal government, and if you're a police agency and you have a crime that takes place and you send them some cartridge cases or bullets and they take a scan of it and put it in their system, they sometimes can tell you whether or not your bullet was fired by the same bullet as somebody else's case. I do know that's available.
Okay, when you were employed with the state, you indicated you was employed with GBI, correct?
I was.
Okay, and when you were employed during that time period, were you required at that time to go to additional training?
We usually did at least once a year go to something, yes.
Okay, all right, but since you have now been retired, obviously you have not been required to go to additional training that you would normally go to when you was actually working with GBI, is that correct?
That is Christ. And sometimes, you know,
No further question.
Well, he's not done answering. Don't walk away.
Okay.
Sometimes you just reach the point in your life, especially when you're in your 60s, you wonder, how important is it for me to continue training?
Okay, thank you, sir.
Mr. Griner, do you have any redirect?
I just want to correct one thing. If you look at your official report, let's just turn to, and this is Stacy's Exhibit 193, this is page 2.
Right.
And let's go to under opinions, interpretations, and conclusions.
Yes.
And did you make a clerical error in that second paragraph under opinions, interpretations, and conclusions?
I most certainly did. I frequently in generating this, if I'm going to use the same statement in the first result and opinion, and if I'm going to use the same verbiage, I will cut and paste it for the second one. And what I did on the second paragraph under opinions and interpretations and conclusions, I went from group 1A, which had 12 cartridges, to group 1B that had 16. And when I cut and pasted that, I forgot to change the word 12 to 16. So that is a obvious mistake on my part.
Would you just read that paragraph the way it should have been written then?
Yes. It should read the 16 cartridge cases, which were in item 1B, were compared microscopically with each other. And there were sufficient corresponding individual characteristics noted from the primer shear and breech face impressions to conclude that the 16 cartridge cases were fired by the same firearm.
Judge, that's all that I have. Thank you.
Mr. Monetis, any recross?
Yes, Judge, just one single question. You shared with us that you got the evidence on July 24th, 2023, and it's just 2 days later after that, July 26th, that you write the report, correct?
That is correct.
Okay, thank you, sir. Those are my questions.
Mr. Rowe, anything else?
Okay.
All right, jurors, questions for Mr. Jarvis. If you get them to Deputy Gordon, we are about done. Thank you. Counsel? Wait, please. Be right back.
Mr. Jarvis, share with the jurors how long it typically takes to do the microscopic analysis of a cartridge. So you had 30, however many, how long does it take to do one?
You know, typically I wouldn't think more than 10 to 15 minutes per. And given the fact that I received it on one day and issued a report 2 days later, that's probably a reasonable estimation, because once the work is done, it has to be repackaged and a report has to be written. So that takes a little time too. But it's always been my goal to turn cases over as quickly as possible, because I never had the workload that I remember having when I worked for the state lab.
So 10 to 15 minutes, unless there's something particularly peculiar about a cartridge casing.
Yes, typically the cartridge cases are pretty easy to do. Bullets sometimes are more difficult because they can be damaged based on what they hit.
Would a jammed or misfired cartridge have any markings left on it?
Nothing that, if it was a live cartridge that didn't fire, there would not be any markings that would be a result of being hit by a firing pin or the pressure compressing it against the breech face. But if it had to be extracted and ejected, there could be marks that were placed on there by the extractor and ejector.
There was one live round that you received. Does it fall into the former category of it's a live round, I can't link it to any of the three groups of shell casings, or did it have enough markings on it from whatever happened to it that you could say, oh, that went with the 16 shell casings or the 3?
I do not recall seeing any markings on that particular live cartridge.
can you help the jurors understand how a live round would come out of a gun? How is it that law enforcement would have come across a live round along with all the spent shell casings?
If the semi-automatic pistol got jammed, it may be that the operator would have had to pull the slide back, and it may have ejected a live round. That would be my first guess. My second guess would be if a person ejected the magazine out of the gun and it still had a cartridge, it's possible that it could have fallen out when it hit the ground. I mean, there's several things I could think of.
Okay. Were you able to link the bullet that killed the deceased in this case, the projectile, with any of the three groups of shell casings? Say, oh, that bullet came from the 16 shell casings collection, or the 3 shell casings collection.
There was no way for me to do that.
Mr. Greiner, do you have any questions for Mr. Jarvis based on that?
No, Your Honor.
Mr. Menendez?
No, Judge.
Mr. Rowe?
No.
All right, Mr. Jarvis, thank you for your time. You are excused. That's what that meant. So you take your stuff, but please leave on the witness stand all the other evidence. You're welcome. Ladies and gentlemen, we are going to stop for the day. While I was back there going over your questions with the lawyers, I pressed the state to say, hey, we were going to end today. Today was not a model of litigative efficiency. I think there's a lot of love to go around out there. So we slipped behind a little bit. The state insists that, one, they only have 3 witnesses left. 2 of them are described as short. I think that means duration and not height, but we'll see tomorrow. And 1 will be medium. I have a feeling that the medium one will actually be shorter than they think, given who that person is, but 3 witnesses. Then the state will rest, assuming nothing comes up overnight. They're not precluded from saying, oh, this just in, there's a 4th witness. The forecast is 3 more witnesses. They'll rest in the morning. When they rest, you get a break because there's some legal things we need to take up when the state rests. And then we will see if either defendant is going to put up any evidence. Reminder, because it's been a minute since I talked to you about the law, no burden on either defendant. And so it may well be that Mr. Rowe said, we rest, and Mr. Menendez says, we rest. Okay, that's their call. No burden on either defendant. And then we'll see where we go from there. But no one has rested yet, so you're in the same posture as you've been for a while. No outside research. Don't talk about this case with anyone. I will see you all tomorrow at 9. One last thing for planning purposes. Unless you are deliberating by Wednesday morning, we don't start Wednesday until 1 o'clock. So you get Wednesday morning to yourself. I won't tell your employers this, but you can go to work if you want, but I won't radio in like, hey, there's no court Wednesday morning. I'm one of our drug court judges, and every other Wednesday morning we do drug court. It's very important that I have regular connection with these folks and what they're working through. And so I told the lawyers this a while ago that if we spill into Wednesday, we won't be able to start till 1. I hadn't told you all, but now I'm telling you. But tomorrow's Tuesday, so we've got a full day tomorrow. Wednesday will be a half day unless you've begun your deliberations. You can be deliberating while I'm doing drug court. I will stop drug court for any question you have or a verdict you reach. But if we haven't had closing arguments yet or something like that, I can't do that while we're working through the important work of drug court. Any logistical questions? Sir.
Do you foresee us going through Thursday? It's hard to place, but I have a place. That's why.
Yeah, no, you told us, and we'll work through that. The lawyers knew that. The lawyers are moving at the pace they're moving. So we shall see. All right. Thank you, everyone.
All right, adjourned. Yeah.
Together.
All right, Mr. Griner, please do share with the defense attorneys the photos you intend to, which medical examiner are we gonna have?
Dr. Henniger.
Okay. I don't think he's been working quite as long as Jarvis, but it's close. They're like neck and neck. Share with the defense attorneys the pictures you intend to use before you call Dr. Henniger to the stand. So we know if there are any concerns.
Make those available right now?
Great. Anything else from the state?
No, Your Honor.
All right. Mr. Phillips, tomorrow morning at some point, I will be asking you whether you want to testify in your case. It'll be after the state rests, but it'll be on the record. The jury won't be in here. I need to make sure you understand that you're the one who'll be answering that. You can listen to what Mr. Monetis has to say, or your family, or anyone else, but ultimately it's the defendant who's got that right who needs to exercise it, the right to remain silent or the right to testify. And so I'll be asking you a few questions about your understanding of your right to remain silent and the instruction that I'll give the jury if you choose not to testify, and what will happen if you choose to testify. But in the end, I'll be asking you directly whether you want to testify. And your answer is either yes, I do, or no, I don't. Not, I need more time to think about it. So huddle up with Mr. Monetis now, and if you need to in the morning. But once the state rests, that is what we'll turn to, is finding out whether you're going to testify, okay? I need you to answer out loud.
Yes.
Okay. Mr. Parks, same situation. I'll have the same conversation with you about whether you want to testify. It is 100% your right. Mr. Rowe will give you good advice, and you can follow that advice, but I won't be asking him whether you want to testify. I'll be asking you whether you want to testify, and your answer will need to be, you bet, I do, or no, thank you, I won't, and not, I need to think about it more. Do you understand that?
Yes.
Sounds good. Mr. Monetis, anything else we need to cover today?
Yes, Judge. In light of the court's ruling on the immunity transcript, I am going to need to call Mr. Dennis Francis, the attorney from that transcript, who had his subpoena this morning before 9 a.m. And I was just wondering from the court, since it is the attorney in the transcript that the state had, do I need to put him on a witness list, or are they on notice because they have a transcript? That's one thing. I can do it out of abundance of caution, but I was just wondering. The other thing is he was subpoenaed before 9 a.m. this morning, but I did get word from his staff that he just started a trial today with Net.
Okay.
And I just want to put that on the court's radar.
All right, it's on my radar. I don't know what you want me to do with it. It's more on your radar than mine. So you'd like to have him here. He may be unavailable, and I guess you'll navigate that. Anything else?
No, Your Honor. I mean, I know the answer to my last question. Should we be prepared for the possibility of closing arguments tomorrow, or?
Definitely. I think the jurors would appreciate that, but we only get there if everyone is rested. So there'll be a decision for your team to make. There'll be a decision for Mr. Rowe's team to make once the state rests. Of course, we haven't gotten there yet. They say it's only 3 witnesses and 2 of them will be brief, TBD. So we'll see how all that plays out. Mr. Rowe, anything else?
No.
All right. Then please be here a little before 9. I don't think there's anything more we all need to cover. I added, we need to have a charge conference. We will not do that now. We'll probably do that at lunch tomorrow, part of lunch. I don't think it'll be a long charge conference. I did add one short instruction beyond what you've already received, and it's the pattern about a defendant's custodial statement, that the jury, before they consider it as evidence, need to find that the statement was voluntary and that he was advised of his constitutional rights. I guess they'd have to listen to the statement to make that finding, since the state didn't manage to play it for them, but that language is now in the jury charge. And we'll talk about it on the record when we do the charge conference. I guess that's it.
And I may have a non-pattern charge to submit to the court. I'll email that tonight.
If you get it in time, then I will consider it.
Thank you, Your Honor.
Thank you, everyone.